Hey, good morning, everyone. My name is Joaquin Esquivel, Chair of the State Water Resources Control Board. Today is Wednesday, September 20th. It is 12:03 a.m., and I'd like to call this meeting to order. I'll begin by introducing my fellow board colleagues. With me here today is Vice Chair Doreen Diadamo, Board Member Nicole Morgan, Board Member Sean McGuire, and Board Member Laurel Firestone. As you can see, this is a hybrid meeting. It is being webcast and recorded. For those of you participating remotely, you're either on the YouTube live stream or the Cali PA website. But if you intend on commenting on today's item, you need to be on the Zoom platform. There are instructions on how to do so at the top of the agenda, a link and a form to fill out. If you're having any challenges, though, please do reach out to the board clerk at board.clerk@waterboards.ca.gov, and she can help get you onto the platform. Once you are, your camera will be off. You'll be on mute until it's your turn to speak on the item here you've indicated. For everyone here in the room, good morning. Good to see you. We're here in Sacramento in the Cali PA building. Please, just a couple announcements here as well. Please observe the exits. If we happen to have an emergency, we'll calmly file out over to Cesar Chavez Plaza and await further direction. If you intend on commenting today, please do either sign up through the QR code, or there's a tablet here at the side of the room. Please introduce yourself and any affiliation once you come up to the microphone. Also, for us here in the room, please silence any phones just so that we don't have any interruptions during our discussion. With that, we can move on to what is the single item for today, and that is your discussion on the agriculture order. I have a script I'm going to pull up quickly here and be able to read from. So we're offering Spanish language, first and foremost, interpretation services for this item, including broadcasting this meeting simultaneously in Spanish. If you are here in the meeting room and you need Spanish interpretation services, please raise your hand and a headset will be provided to you. If you are joining the Zoom platform and you want to listen to the meeting in Spanish or provide comments in Spanish, please select the language interpretation channel by clicking on the interpretation feature with the globe icon in the meeting controls at the bottom of your screen. Then select Spanish and mute original audio. We ask all presenters apologies here. We ask all presenters, board members, and individuals providing public comment to please speak slowly and pause occasionally to allow the interpreters to accurately capture your remarks. This applies to both English speakers and Spanish speakers. If you speak too quickly, we may ask you to slow down or pause. During the public comment period, Spanish-speaking commenters here in the room can come up to the podium and share their comments. Community Water Center will be providing interpretation as needed for their community partners, and our interpreter will interpret comments for anybody else. During the public comment period, Spanish-speaking commenters on the Zoom platform can share their comments, and the interpreter will interpret their comments. Once they start speaking in Spanish, our interpreter will interpret their comments. We have a bilingual staff person from the Office of Public Participation, Mandy Roman, here available in the room if you have any questions or need interpretation. Please let Mandy know in advance if you need an interpreter. In this item, number 13, we are considering a revised proposed water quality order for adoption in the matter of file number A-2751A and B. It arises from petitions from State Water Board review of the Central Coast Water Board's general waste discharge requirements for discharges from irrigated lands order. Staff from OCC, the Office of Chief Counsel, and the Division of Water Quality will provide a presentation on the draft order, followed by presentations by the Central Coast Water Board, the agricultural petitioners, the environmental petitioners, and Central Water Quality Preservation Incorporated, the third-party program administrator for the Central Coast Water Board. After that, we will hear from the remaining commenters. Following the public comments, the board will consider adopting the revised order with or without any changes desired by the board. With that, I will turn over to Eric Gilman with the Office of Chief Counsel to provide an overview of the revised draft order. Thank you. Good morning, Mr. Gilman.
There we go. Good afternoon, Chair.
You may need to turn on your microphone. Apologies.
Not working? There we go. Just a little closer. Okay. Good afternoon, Chair, Vice Chair, board members. My name is Eric Gilman, and I'm an attorney in the Office of Chief Counsel. I'm joined here by Brianna St. Pierre from the Division of Water Quality, and she's available to answer any technical questions. I will be presenting on a revised proposed water quality order arising from petitions of the Central Coast Water Board's general waste discharge requirements for discharges from irrigated lands, which I will refer to as the general WDRs. Following adoption of the general WDRs in April 2021, the State Board received 2 petitions seeking review, one filed by the Grower Shipper Association of Central California and others, or the GSA petitioners, and one filed by the California Coastkeeper Alliance and others, or the CCKA petitioners. Board staff considered the petitions as well as responses from petitioners and the Central Coast Water Board, and in June 2023, we issued a proposed water quality order and opened a written comment period. We received 21 timely comment letters and 4 comment letters that came in just after the deadline that were ultimately accepted. We also received a request from the CCKA petitioners to consider supplemental evidence, which we declined to accept for the reasons laid out in footnote 10 of the proposed order. Staff carefully considered the written comments and made a number of changes to the proposed order, resulting in a revised order that was circulated on September 8th. We took up the petitions in order to restate and reinforce some of the most important precedential requirements from the board's 2018 water quality order on the Central Valley Water Board's general waste discharge requirements for growers within the Eastern San Joaquin River watershed, which I will refer to as the ESJ order. We also announced our intention to further develop the irrigated lands regulatory program by convening a second agricultural expert panel, and to direct the Central Coast Water Board to develop an alternative water supply program to assist residents who rely on nitrate contaminated groundwater. The proposed order addresses a number of other issues that were not subject of significant comments, so I will not summarize them unless you have questions. These issues include consistency with the State Water Board's composting general order, monitoring for 123 TCP, pesticide surface water receiving water limits, requirements for impermeable surfaces, the extension of TMDL compliance dates, and public trust responsibilities. In this presentation, I will provide some background on the State Water Board's involvement in the Irrigated Lands Regulatory Program. I will then address significant issues in the revised order, particularly those relating to inconsistencies between the general WDRs and the State Water Board's precedential direction in the ESJ order. The State Water Board has been actively engaged in developing the Irrigated Lands Regulatory Program in recent years, most recently and significantly with the adoption of the ESJ order. The ESJ order was a result of several years of extensive stakeholder input and implemented recommendations from the Agricultural Expert Panel regarding the collection and use of nitrogen applied and nitrogen removed data. In the ESJ order, the State Water Board provided extensive precedential direction to the regional boards, which was reinforced through follow-up by board leadership and staff. In the proposed order, the board explains that a prior board decision or order may be distinguished or overturned by a later decision or order, but that the treatment of our decisions and orders as precedent helps provide greater consistency and predictability and contributes to both the actual and perceived integrity of the Water Board's regulatory programs. The field of water quality regulation is constantly evolving, including the Irrigated Lands Regulatory Program. We benefit from programmatic experimentation by the regional boards, but once we determine that such experimentation has run its course and we resolve a technical, policy, or legal issue by issuing a precedential water quality order, we fully expect that the regional boards will carefully follow our direction. In the ESJ order, the State Water Board directed the regional boards to incorporate in their irrigated lands regulatory programs order requirements that growers or their third-party representatives collect and report nitrogen applied and nitrogen removed data, and calculate and report A over R and A minus R as measures of the potential for nitrogen to reach groundwater. The board directed regional boards to develop a methodology for identifying and following up with outliers based on reported A over R data, and endorsed the agricultural expert panel's recommendation to use growers' A and R data to develop acceptable multi-year A over R ratio target values. However, the board also clearly stated that, quote, "It is premature at this point to project the manner in which the multi-year A over R ratio target values might serve as regulatory tools. That determination will be informed by the data collected and the research conducted in the next several years. If we move forward with a new regulatory approach in the future, we expect to do so only after convening an expert panel that can help evaluate and consider the appropriate use of the acceptable ranges for multi-year A over R ratio target values in irrigated lands regulatory program statewide." We directed the regional boards to revise their existing irrigated lands regulatory programs within 5 years to be consistent with the precedential direction in the ESJ order. The regional boards were made aware of the precedential nature of the ESJ order and specific provisions through a board staff roadshow at a number of the regions, including the Central Coast, and regional board staff roundtables. Throughout its consideration and adoption of the general WDRs, the Central Coast Water Board was aware that many of its provisions were implicated by our precedential direction. However, the Central Coast Water Board adopted a number of provisions that are at odds with the ESJ order. The general WDRs incorporate requirements that growers report A and R data, but deviate from the direction in the ESJ order about how A and R are to be calculated. Per the ESJ order, nitrogen applied includes all nitrogen practically added to a field from any source, and nitrogen removed includes the nitrogen present in all harvested materials removed from the field, plus, in the case of perennial crops, the nitrogen sequestered in the permanent wood. The general WDRs provide discount factors for nitrogen applied in compost and organic fertilizer, and create new categories of nitrogen removed, such as R scavenge for cover crops. The general WDRs also modify the A minus R calculation by excluding nitrogen applied in irrigation water in 2 of 3 compliance pathways. These modifications were made to incentivize certain practices, but have the potential to reduce A and increase R, thereby reducing the A over R ratio and the A minus R calculation, and will yield inconsistent data across regions and within the Central Coast. More importantly, the proposed order concludes that incentives should not come at the cost of accuracy in determining the true impacts of the growers' nitrogen practices on water quality. While the ESJ order embraced the agricultural expert panel's recommendations to focus on the A over R ratio as the simplest metric of good management that can be performed simply, repeatedly, and with relative accuracy, the general WDRs eschew the use of the A over R ratio. Instead, the general WDR's emphasis is on the A minus R calculation, using it and fertilizer nitrogen applied as regulatory tools. The Central Coast Water Board established targets and limits on fertilizer nitrogen applied and A minus R that can result in additional requirements for growers, including obtaining additional education, irrigation and nutrient management plan, or INMP certification by a qualified professional, implementing additional or improved management practices, increasing monitoring and reporting, and most notably, progressive enforcement action. Focusing on fertilizer nitrogen application alone without reference to other sources of nitrogen added to a field or nitrogen removed from the field does not provide meaningful insight into the amount of nitrogen left in the soil with the potential to reach groundwater. As such, there is not a clear connection between the amount of fertilizer nitrogen applied and impacts on water quality. Using A minus R as a regulatory tool is premature and is inconsistent with the State Water Board's direction in the ESJ order. As the board clearly stated in the ESJ order, and as I will discuss in a few minutes, we expect to convene an expert panel before moving forward with any new regulatory approach. Accordingly, in the June version of the proposed order, we remanded these portions of the general WDRs to the Central Coast Water Board with instructions to bring them into conformity with the ESJ order. We also directed the regional boards to refrain from using fertilizer nitrogen applied and A-R targets and limits for any enforcement purpose or to require any additional action by growers. Based on widespread support in the written comments that we received for the continued use of the discount factors for calculating nitrogen applied, the new categories of nitrogen removed, and the use of the 3 compliance pathways, staff revised the proposed order to allow for the Central Coast Water Board to continue to collect that data and to use its A-R compliance pathway formulas, but only for the limited purposes of requiring growers obtain additional education and INMP certification by qualified professional. We are also aware of the need to maintain some continuity and momentum toward reducing fertilizer and nitrogen application rates in the short term for growers that are currently required to collect only nitrogen application data. Therefore, the revised proposed order allows the Central Coast Water Board to continue to use the existing fertilizer nitrogen application targets for growers who are not yet reporting nitrogen removed, but only for education purposes. Any grower impacted by this provision may opt to collect and report nitrogen removed data and comply with the A-R targets. Use of the A-R compliance pathways and fertilizer nitrogen application targets apply only during the interim period between the adoption of this order and when the State Water Board acts on the next expert panel's findings. The proposed order continues to preclude the use of enforceable limits pending further direction from the board following the next expert panel's recommendations. But it also recognizes that the regional board may still enforce other provisions of its WDRs, and that the regional board may also require additional information if a grower reports exceedingly high nitrogen application data. The proposed order also directs the regional board to incorporate final time schedules for the ongoing discharges to cease causing or contributing to exceedances of nitrate water quality objectives in groundwater. As I mentioned earlier, the proposed order contemplates the establishment of another expert panel. Given the amount of data generated and other progress made in implementing the ESJ order, State Water Board staff would be tasked to work with the regional boards to review the data that has been collected to date and other progress that has been made by CDFA, third parties, academics, and others in the furtherance of regional boards' irrigated lands regulatory programs to determine whether sufficient data has been collected for review by an expert panel. Staff will report back to the board in a public meeting as soon as reasonable, but at least within the next 12 months. As soon as we determine that sufficient data has been collected for review by an expert panel, staff will initiate an expert panel process to advise the board on next steps for our irrigated lands regulatory program. The public will have opportunities to provide their input on the data to be reviewed by the panel, the questions to be posed to the panel, and the areas of expertise of the panelists. The expert panel will be comprised of scientific experts drawn from entities such as academic institutions, scientific and policy institutes, and government agencies. The work of the expert panel will include opportunities for public participation and will be reviewed by the board with the expectation that its recommendations will be used to provide additional precedential guidance to the regional boards. We are committed to acting promptly to initiate a new public process to give further precedential direction if the expert panel recommends any significant revisions to our irrigated lands regulatory program. While it is premature to determine the full charge of that expert panel now, we foresee that we will task it to evaluate the suitability of expanding the use of the multi-year A/R ratio target values and A minus R difference values, and also to review the modifications to measuring A and R advanced by the Central Coast Water Board and the general WDRs. The proposed order also notes that addressing nitrate contamination through the Irrigated Lands Regulatory Program is a long-term project. Even if growers ceased applying nitrogen today, in many places it would take decades for nitrate levels in groundwater to fall below the applicable maximum contaminant level. Because of the critical drinking water impacts associated with groundwater nitrate contamination, the proposed order directs the Central Coast Water Board to incorporate a requirement or to reach an agreement in which dischargers or their third-party representatives provide short-term and long-term alternative water supplies to residents relying on groundwater in areas where the MCL for nitrate is exceeded as a result of agricultural operations. The Central Coast Water Board could incorporate a requirement for alternative water supplies in its water quality control plan or in cleanup and abatement orders, or could reach an agreement with the dischargers in connection with the revised waste discharge requirements in order to justify a longer final time schedule for ceasing to cause or contribute to nitrate water quality objective exceedances in groundwater. The proposed order instructs the Central Coast Water Board to invite representatives of impacted communities, environmental justice organizations, and other stakeholders, as well as state water board staff with experience in alternative water supplies, to participate in the development of such a requirement or agreement and to report its progress to the State Water Board semi-annually. Before I conclude, I would like to address two comments raised by petitioners that did not result in any modifications to the proposed order. GSA petitioners raised concerns regarding the Central Coast Water Board's consideration of economic impacts under Water Code Section 13241. They argue that the regional board ignored the economic impact of the general WDRs on agricultural production by merely considering costs. However, Water Code Section 13241 does not specify how a water board must go about considering the specified factors, nor does it require the water boards to make specific findings on the factors. The Central Coast Water Board addressed compliance costs to growers and costs to the public and environment resulting from water quality impacts from irrigated lands, including public health costs and alternative water supply costs associated with widespread nitrate contamination of drinking water in many areas of the Central Coast region. We conclude that the Central Coast Water Board complied with its obligations regarding economic considerations. CCKA petitioners assert that we failed to comply with the requirements of Assembly Bill 2108. Because we are exercising our Water Code Section 13320 discretion to not revisit our prior precedential direction or amend the general WDRs, we are not engaging in the permitting process or issuing or reissuing waste discharge requirements. Therefore, the adoption of this order is not subject to the requirements of Assembly Bill 2108. Nonetheless, we feel it is important to note that we fully support the goals of AB 2108, which are consistent with our own values as expressed in our Racial Equity Action Plan and our Human Right to Water Resolution. In particular, our direction to the Central Coast Water Board to develop an alternative water supply program to assist residents who rely on nitrate-contaminated groundwater and to involve representatives of impacted communities and environmental justice organizations in doing so demonstrates our commitment to these values. Thank you for your attention. This concludes my presentation, and I would welcome questions now or after the panels. But before moving on to the next piece, we'll pass it to Phil Wiles, who has some proposed edits.
Thank you, Eric. Phil Wiles, Assistant Chief Counsel for the State Water Board. And as the clerk's bringing up a page for the screen, this is about the alternative water supplies that Mr. Gilman just spoke about. And we realized with the revisions that we made to the proposed order on September 8th that we lost a little bit of the distinction between requiring alternative water supplies through a cleanup and abatement order or a water quality control plan on the one hand, and reaching an agreement with dischargers to provide alternative water supplies as part of waste discharge requirements on the other hand. And so we just wanted to add some clarifying language here. And what you see is the September 8th revised proposed order with the revisions incorporated and just the additional revisions that we are proposing today. And those revisions on the screen are in the third sentence. And just for the benefit of the non-English speakers, I'll read that third sentence. It would now say, the Central Coast Water Board could incorporate such a requirement in its water quality control plan or in cleanup and abatement orders, or reach an agreement with the dischargers that is incorporated into the general WDRs in order to justify a longer final time schedule for ceasing to cause or contribute to nitrate water quality objective exceedances in groundwater, similar to the maximum 35-year time schedule authorized under CV salts. And that's the one change that we're proposing to the revised order as of now. And I do want to emphasize a timing issue, and that is that we do expect it will take some time for the Central Coast Board, working with state board staff and all of the other stakeholders, to develop this alternative water supply program. And we are not saying that the Central Coast Water Board needs to wait to act on the remand while it works on this alternative water supply program. They can act on the remand and then later incorporate the alternative water supply program if they reach an agreement. And so with that, that concludes the staff presentation.
Thank you, Mr. Wiles. I appreciate that. And apologies, was remiss to needed to introduce our executive director and yourself at the top of the meeting. We can then begin to move on here to the Central Coast Board, but before we do, I just want to make comment. These programs and this work are certainly unique to the state insofar as you look nationally, and the ability to have a discussion with ag here to regulate nitrates, to here ensure communities are being protected, comes very seriously. And so I appreciate everyone's time here, the amount of folks that we have that are gathered to contribute to this discussion, and looking forward to hearing the input here as we make a decision and determination here. But just at the top, wanted to note and thank everyone for what really is cutting edge discussions and cutting edge work nationally and here within the state. And just thank everyone for their part in leadership here in contributing to it. Additionally, if you're not here at the top and didn't hear, we have staff that are available in case you have any issues or need interpretation services, and just wanted Mandy Roman to kind of flag herself so as to let folks be able to get to them. Okay, so Amy Cronson for now. Okay, Mandy Roman is there in the back if you need any help with any interpretation, and thank you, Mandy, so much for that. Let's go on and hear now from the Central Coast Water Board, and I invite Matt Keeling up to carry us on in our discussion here. Good morning, and thank you for traveling down, up, whichever direction you want to really look at it. Yeah, for speaker, you always get the, thank you, Mike. Matt.
Right, are we good? All right. Thank you, and good afternoon, Chair Esquivel, members of the board, and just for the record, again, my name is Matt Keeling. I'm here today representing the Central Coast Regional Water Quality Control Board as its executive officer. I'm also joined today in person by our Irrigated Lands Program Manager, Elaine Saul, and our section manager, Mary Hamilton, as well as our legal counsel, Ms. Stephanie Yu, who I believe is joining us via Zoom. So I'm really grateful for the opportunity to speak to you today regarding the proposed order before you in response to the 2 petitions that you received regarding the 4th iteration of our agricultural order. So I'm going to, throughout my talking points here, I'm not going to refer to it as a general waste discharge requirements for irrigated lands program. I call it our agricultural order. That's, what we call it, and this is our 4.0 version specifically. I'd also just like to note, in starting my comments that, the Porter Cologne Water Quality Control Act petition process provides an administrative remedy for regulated entities and communities to express their concerns about regulatory actions taken, or in some cases, perhaps not taken, by regional water quality control boards. And this is something that I see as very foundational to our public process in developing requirements. And so, I appreciate that we're having this conversation today. And as is the case for the regulation of irrigated agriculture, the petition process also facilitates a broader dialogue and transparency with respect to issues of statewide significance. So I think it's a very valuable discussion and opportunity that we're having today to discuss this before you, the State Water Board. We'd like to thank your staff for affirming several important agricultural order requirements that were challenged by the petitioners, particularly 1, 2, 3 trichloropropane monitoring and on-farm domestic wells, the use of numeric receiving water limits for pesticides based on narrative water quality objectives, among other numeric receiving water limits based on total maximum daily loads, and requirements addressing discharges from farms with impervious surfaces such as plastic mulch or hoop houses. We also appreciate that the proposed order acknowledges our extensive consideration of economic factors when developing the agricultural order, and affirms that specific finding on public trust was not required in the agricultural order. Nonetheless, protecting and restoring public trust water resources is at the core of our mandate, and it was seriously and thoughtfully considered by our staff and our board in the preparation of our agricultural order requirements. We'd also like to thank your staff for responding to our request for clarification regarding various aspects of the original draft proposed order, and particularly as it relates to the interim use of our modified nitrogen applied and nitrogen removed, or A-R formulas, and the associated discount factors and credits that are widely supported by the agricultural community, agricultural service providers, and researchers, as documented in many of the comment letters that you received in response to your proposed draft order. The modified A-R formulas are intended to advance multi-benefit management practices that will help reduce nitrogen loading to groundwater. And they're also in line with California Department of Food and Agriculture's Healthy Soils Initiative. And the formulas are also consistent with nutrient cycling at the farm scale as a result of various management practices that are currently being implemented. So we think it's important to include those moving forward in our order. And I think they're also going to inform the expert panel process by way of having us being able to still collect that information and analyze and report out on it. We also appreciate the interim, albeit narrow, use of our statistically and agronomically defensible 90th and 85th percentile fertilizer nitrogen application outlier approach to help address over applications of fertilizer nitrogen in excess of California Department of Food and Agriculture fertilization guidelines. And I'd also like to point out, and as some of you are already aware, our staff have developed some really amazing online dashboard tools that are interactive and graphically show the nitrogen applied data that we've been collecting since 2014, and as well as comparing it to California Department of Food and Ag fertilization guidelines. And so for those of you who haven't had a chance to take a look at those, I suggest you go to our Irrigated Lands program website and pull those up and play around with the interactive functions to look at these data and what they say about agricultural practices and nitrogen loading in our region. We're confident that the statewide data review and expert panel process laid out in the proposed order will affirm these approaches as viable and effective regulatory mechanisms to address significant ongoing nitrogen loading and associated water quality and beneficial use impacts from irrigated agricultural activities. The meaningful and effective implementation of our irrigated lands program is paramount to our success in achieving our mandate to protect water quality and beneficial uses in the Central Coast region. As a predominant land use, second only to open space, irrigated agriculture is responsible for significant and widespread impacts to entire watersheds associated with sediment and pesticide discharges and pesticide toxicity, and nutrient discharges and associated eutrophication. The most recent integrated report approved by this board clearly show this within our region as well as other parts of the state where there's significant irrigated agricultural activities. Irrigated agricultural practices resulting in ongoing and significant discharges of nitrogen to groundwater also render major portions of entire groundwater basins unsuitable for drinking water purposes without the removal of nitrate. As the most groundwater dependent region in the state, effectively reducing nitrogen loading to groundwater needs to occur as soon as possible to protect the municipal and domestic supply beneficial uses of groundwater. As stated in our comment letter, we urge expedited review of statewide data while concurrently planning the expert panel process so as to prevent any further delay in developing meaningful and effective statewide regulatory requirements addressing the ongoing and significant loading and the associated drinking water beneficial use impacts. We also strongly advocate for an open and transparent expert panel process that includes participation with impacted communities, environmental justice representatives, as well as in-house regional water board experts from around the state. So state water board staff and regional water board staff, some of which have been working on this issue for quite some time, and in some cases, well over a decade. Addressing the significant drinking water impacts through the provision of free drinking water, well testing, and replacement water programs has been a priority for our region for well over a decade. As such, we'd like to acknowledge the directive in the proposed order for us to develop requirements to reach an agreement with agricultural parties or to include requirements to provide replacement water to communities with nitrate polluted drinking water supplies. And we appreciate the proposed order's emphasis on the need for both short-term and long-term alternative water supplies and the need to engage with representatives from impacted communities, environmental justice organizations, among others, to ensure the resulting replacement water programs effectively meet the needs of the impacted communities. And as alluded to in our comment letter, the development of a replacement water program is going to require support and participation from a variety of state water board divisions, including Division of Drinking Water, Division of Financial Assistance, Division of Water Quality, Office of Public Participation, Office of Chief Counsel, and Office of Enforcement. And so we're looking forward to our coordination with your staff across your programs to develop an effective replacement water program. You know, we did seriously consider the precedential requirements of your 2018 Eastern San Joaquin Order. The precedential requirements were just one of the many factors that our staff and our board considered in the balancing test required of the water boards pursuant to Water Code Section 13,000 when developing requirements to protect the health, safety, and welfare of the people of the state. The other factors we considered included decades of water quality data, particularly nitrate impacts to water quality supply wells, nitrogen applied data collected since 2014, indicating no appreciable decrease in nitrogen application rates since that time, peer-reviewed scientific studies and articles, written testimony, and countless hours of verbal testimony received from growers, agricultural service providers and associations, agricultural researchers, community members, environmental justice advocates during 4 years of agricultural order-related meetings, workshops, and hearings. We also considered court decisions and writs of mandate associated with our previous agricultural orders and that of the Central Valley Water Board associated with the Eastern San Joaquin Order and the Dairy Order. All these factors are detailed in the findings attached to our agricultural order and within the administrative record. We also considered the State Water Board's definition of precedential requirements that clearly provides latitude in applying precedential requirements with respect to new information before a regional water board. Central Coast Water Board engaged with experts and considered a lot of new information and data since the adoption of the Eastern San Joaquin Order 5 years ago. I think it was 5 years ago last month. So you and your staff are now applying an additional balancing test to our agricultural order based on the information before you and testimony you received today. And I can assure you that we will expeditiously implement the approved order that comes out of this petition process. So just thank you for your time. I'll be available along with Mary Hamilton, Elaine Saul, and Stephanie Yu throughout the hearing today if you have any questions. Thank you.
Thank you, Mr. Keeling. I appreciated that and your leadership here amongst it. As we go on through the day here and have discussion, I'm sure we'll lean on and have question further, but none from my seat at this point and looking to colleagues in case there are from them. Thank you, Mr. Keeling. Let's now then move to the ag petitioners. And I believe first up we have Tess Dunham. I believe it is a panel. So I think it's Tess, Carrie Fisher, Claire Weinman, and if necessary, Gail Dalenhart and Jennifer Spalletta.
Yes, I don't believe Gail Delahant's going to be joining at all. I don't know that Jennifer Spalletta will be either. Two of our panel members are here on video. We're actually going to start with Claire Weinman, and then I'll come in, then we'll go to Tim Burrell, and then Carrie will finish this off.
Great, thank you.
Good afternoon. My name is Claire Weinman. I'm the president of the Grower Shipper Association of Santa Barbara and San Luis Obispo counties. I'm pleased to introduce our panel representing the agricultural petitioners. The ag petitioners have continued our longstanding partnership and includes Grower Shipper Association of Central California, Grower Shipper Association of Santa Barbara and San Luis Obispo counties, Monterey County Farm Bureau, Western Growers Association, Western Plant.
I'm sorry to interrupt real quick. For the PowerPoint presentation, should I have Claire say to go to next slide? I'm sorry, we do have a PowerPoint that's up there.
Yeah.
Sorry, Claire, you'll need to ask them to advance the slides.
Oh, and apologies, Claire, you got muted. You should be invited here to unmute again.
Thank you.
Thank you. Sorry for the interruption.
Thank you. As I was saying, so our partners include Monterey County Farm Bureau, Western Growers Association, Western Plant Health Association, California Strawberry Commission, and the California Farm Bureau on behalf of its 7 farm bureaus on the Central Coast in San Mateo, Santa Clara, San Benito, Santa Cruz, Monterey, San Luis Obispo, and Santa Barbara counties. Collectively, our members represent a significant majority of the irrigated lands on the Central Coast and are directly impacted by the adoption and requirements of Ag Order 4.0. Next slide, please. Thank you. Today, representing the Ag Petitioners panel, I would like to introduce Tim Burrell with Blanco Farms, who will also be joining remotely, and with you in person, Tess Dunham with Soaries and Conway, and Carrie Fisher with the California Farm Bureau Federation. We have coordinated closely with our agricultural partners and growers to prepare and submit our comments today and throughout the adoption process. Next slide, please. Agriculture has made tremendous advancements in technology and best practices since the first Ag Order was adopted, while also feeding our state and country with fresh fruits and vegetables. Although it's a very challenging region to grow in for a number of reasons, Central Coast agriculture is also tremendously innovative and will continue to advance through collaboration, innovation, and technology. Next slide, please. The COVID pandemic highlighted the important role of agriculture in our communities. Agriculture is essential, critical infrastructure and a leading source of income and employment for many people and businesses throughout the Central Coast. Although agriculture experiences significant economic challenges and downturns, they aren't always concurrent with those of other economic sectors, which can provide important baseline economic stability for our largely rural communities. The Central Coast interdependence with agriculture goes beyond the family businesses directly involved in farming to companies such as finance, restaurants, mechanics, and hotels. Next slide, please. Central Coast agriculture provides both first opportunities for employment and building a career path, and also care and stewardship across multiple generations. Because of its important role in our communities, we want to advance win-win solutions for the future of agriculture and our communities where we live and work. We know that we will go farther together through collective efforts. Agriculture has and will continue to provide leadership to our communities to advance solutions. We want an order that we can implement and that works and that does not jeopardize the long-term viability of agriculture along the Central Coast. To speak to some of those specifics, I will pass it to Tess Dunham. Thank you.
Thank you, Claire. Go ahead and go to the next slide, please. Thank you. So just a little bit here, we really do appreciate the State Board's revised draft order. Non-point source pollution is unique, it's complex, and it comes with different challenges than other types of point source entities that this board and others throughout the state have been regulating for a number of years as well. And I thought that the 3rd District Court of Appeals said it very well in its recently published opinion with respect to your presidential order on the East San Joaquin. At the very beginning of the opinion, the court says, regulating waste discharges from irrigated agriculture involves an unusually complex set of policy judgments and trade-offs. Regulators must balance the need to ensure a reliable food supply and preserve the economic viability of agriculture against the need to protect waters of the state. And that is what we're all here about, right? Is finding that balance between your role in protecting water quality and also the role that agriculture plays in the Central Coast and throughout California. And so next slide, please. Specifically with respect to the revised draft order, we as the agricultural petitioners, we do support and appreciate the direction that is in the revised draft order to the Central Coast Board on the remand to remove the nitrogen application targets and limits and the nitrogen discharge limits. That was part of what we petitioned. We had considerable concern because it did not reflect the State Water Board's presidential decision in the East San Joaquin. And also, we do think that nitrogen application rates is a totally different issue into itself as well. And we actually do not believe that any board, water board, has the authority to regulate nitrogen application rates through Water Quality Authority. So with the next slide, please. Now, in your order, we appreciate the revisions. And we support some of the clarifications with respect to what happens here in the interim. But in all honesty, we don't think that the order is as clear as it should be with respect to nitrogen application. We don't think that there is a role that nitrogen application should play even in this interim period. And in fact, we think the language should be revised to reflect that nitrogen application limits and targets should not be used for any purpose. As Mr. Gilman said in his presentation to start with, there is no direct correlation between nitrogen application and the potential impact to water quality. Obviously, when we're talking about A over R ratios and A minus R, there is a much different correlation and connection than there is with just how much nitrogen is being applied. Doesn't take into account removal, uptake, nitrogen transformations, any of the other important components of the nitrogen cycle, which is very complex. So we would ask that the remand actually be revised slightly to remove reference to the use of the interim use of nitrogen application, even in this interim time period for any purpose. So that is one change that we would request. Also, with respect to drinking water, my friend Tim Burrell is going to take over here in a minute and talk about a couple of things. But with respect to the revision that Mr. Wiles just put up on the board, we appreciate the clarification. We had very concerns of our own that as written, the language suggested that the board had the authority to require a drinking water program within waste discharge requirements without it being coupled or tagged somehow to an alternative compliance pathway through an agreement with the agricultural community. And so we do appreciate that clarification. We find it helpful in order to make sure that that is clear as to what is the direction to the Central Coast Water Board with respect to the drinking water program. So thank you, Mr. Wiles, for providing some clarification. We are here today to help answer any questions you may have for agriculture as well. And for now, I'm going to turn it over to Mr. Burrell and then Ms. Fisher, and then we'll be back to answer any questions that you may have. Thank you.
Thank you.
Good afternoon, Chair Escobar and board members. Appreciate the chance to speak to you today. I'd like to go over some expert panel considerations for you. Next slide, please. Thank you. We ag practitioners feel that for the ag panel, we would love to see some good knowledge of actual Central Coast agriculture and most definitely expertise on irrigation, fertilization, and the use of practices that increase the removal of nitrogen from the system. Furthermore, panel members should have a good expertise and a handle on the complexity of the nitrogen cycle. And for a successful panel, we feel that these three considerations should be met. Next slide, please. And then with respect to the drinking water programs, us in agriculture are willing to work with the water board to reach an agreement that includes incentives such as long-term compliance schedules. We feel that growers cannot be required for this. As was stated by Tess, the clarity of language is much appreciated as we move forward, working towards an agreement. And then growers can assist in facilitating long-term drinking water alternatives, but we feel public funding needs to remain an option for that to be successful. And then terms of any agreement would have to be reasonable. With that, I'd like to turn things over to Carrie.
Next slide, Carrie Fisher, California Farm Bureau Federation. So we do have just a few comments we'd like to make on two different points within the revised draft order. We appreciate these changes, but would like a few more clarification statements. And one is with regard to economic considerations. And our point that wasn't necessarily understood or reflected in the revised draft order is the actual difference between what the water code requires, which is an economic consideration, versus a cost consideration, and the fact that those are two vastly different things. And although there were a lot of costs that were in the appendix of Ag Order 4.0, those did not actually consider the economics and how individuals, growers, businesses make their decisions and then allocate those resources, and also the impact that then has on the physical environment as well. So we just like to stress that those are two separate things between economics and costs, and would like the state board to remand to the Central Coast Board to actually do an economic consideration as evidence was put before the Central Coast Board on how those types of studies are actually done, and the type of information that you use and the analysis you use. Next slide. And this just highlights a few of the points on why there are differences between costs and economics. Costs just in themselves were understated, or there were conclusions such as an increase would only be to 5 to 6% for a grower, and alluded to that being a very small amount, when actually those are quite large amounts when you look at the entire economic operation and industry on the Central Coast. Also, the fact that there's our environmental regulatory costs that were not adequately represented in the cost considerations. And then the studies that were relied on and the conclusions that were drawn with the cost considerations under Ag Order 4.0 had various conclusions, such as that management costs were only $45 per hour. And we had put forth evidence that that was grossly underestimated, and it was more like $120 to $141 per hour. Next slide. And the other issue that we have is with regard to the TMDL compliance dates. We do appreciate the revised drafts orders clarification with regard to TMDLs adopted as a single permitting action versus TMDLs adopted as basin plan amendments. However, we do have some concerns with the second category, those TMDLs adopted as basin plan amendments, and the ability to use Water Code 13263C, which is the time schedule provision in which regional boards can incorporate a time schedule within their WDR. And the way that the revised draft order is currently written would nullify 13263C so that no waste discharge requirements could ever have a time schedule. So we are asking for clarification on that and for the state board to instruct the regional board to properly consider TMDLs with their compliance schedules. Next slide, and I'll hand it back to Tess.
Thank you, Carrie. And yeah, just a couple of clarifications too on a couple of the issues in particular. Let's take the TMDL compliance schedule. We do disagree with the revised proposed order and its statements with respect to the authority of regional boards and their ability to include compliance schedules for TMDLs, even if the TMDL is in the basin plan with the compliance schedule. We don't believe that the Water Code 13263C has the limitation that the proposed order suggests it does. So we have a fundamental disagreement with the logic contained within the order and the statutory interpretation that's being taken within the revised draft order. So wanted to make sure that was understood. We appreciate that there is a further compliance specifically in the revised order that talks about there being final TMDL compliance schedules, but nothing else within the revised order addresses the logic that as I read the revised draft order, it suggests that if there's a compliance schedule, or what about if there's a lack of a compliance schedule in the basin plan, does that mean that the basin plan is supersedes and that there is no ability for a WDR to ever have any type of a compliance schedule for constituents within the basin plan? Let's take nitrate, for example. Nitrate is a primary drinking water contaminant. It is in the basin plan as a water quality objective. There is no program of implementation or time schedule associated with it within the basin plan. Does that mean under the logic of this order, as currently written, that there can't be a compliance schedule within the basin plan or within the WDR? If that's the logic in the case, then the statutory provisions are nullified, and we would disagree with that. So we do think that's an important component of concern, not just for the Central Coast region, but just generally, and that is one of the precedential statements within the proposed order. So just wanted to make an additional clarification on that. But with that, we are willing to take any questions from any of you on behalf of the Ag Partners. I guess we could check real quick to see if Jennifer Spalletta wanted to add anything, since we have plenty of time, and I don't believe Gail was going to be able to join us.
This is Jennifer Spalletta, and I have nothing further to add. Thank you.
Thank you, Ms. Spalletta. Thank you, Ms. Dunham. Vice Chair?
Well, I did have a couple of questions, but I'd like to pose them to Mr. Wiles because two of the points on the final compliance date on TMDLs and then also on the other clarification. Oh gosh, I'm losing it. The other one. Oh, that's right. With adding limits and targets, it seems like a clarification. That was sort of my sense of what it meant. So I just want to give you an opportunity to respond.
Sure. Thank you, Board Member Diadamo. First, with respect to the issue about final compliance schedules that both Ms. Dunham and Ms. Fisher mentioned, we actually believe that we did address one of their two issues in the revisions to the order, and it's at page 33 and footnote 140. And we do think that that language addresses their concern about the situation where the water quality control plan does not have any final compliance schedule. And what we say there is that in that footnote, that our concern and the rationale that we express herein applies only to basin plan TMDLs that have final compliance dates. In all other cases, the Central Coast Water Board may use the authority granted by Water Code Section 13263, Subdivision C. So we think that that language actually does clearly address the concern they raised about the situation where the water quality control plan has, for example, a water quality objective, but no corresponding implementation schedule. In that situation, the regional boards can actually, in fact, use their waste discharge requirement authority to include time schedules in the waste discharge requirements. But I should point out that we do have a fundamental disagreement about the other issue they raised, which is the situation where the regional board goes through a rulemaking process as part of the water quality control plan to adopt a final compliance schedule. In that situation, our view is that the regional boards are then constrained from extending that schedule by using the waste discharge requirement authority. And rather, they would have to go back and amend the water quality control plan, engage in a rulemaking to change the final compliance date that they initially adopted via the water quality control plan. So I do think we just have a fundamental disagreement about the relative importance and primacy of the water quality control plan vis-a-vis waste discharge requirements, which are required to be implementing the water quality control plan. We do point out that there's an alternative, which is that the regional boards can adopt a time schedule order to provide additional time and at the same time go back and amend the water quality control plan if that's what they think is actually necessary.
Okay, but you're saying that sort of this do loop that Ms. Dunham described doesn't exist in this case. I'm just concerned about, beyond this WDR.
Sure. So this is precedential. She's absolutely correct. And what we're doing here is we're providing our view of how the regional boards should be looking at their own water quality control plans. And if they do include a final time schedule, they should not in the future, they may not in the future adopt waste discharge requirements that provide extensions to those schedules. And so I agree with her about the effect of it, the effect of the language in terms of that one issue. But I think what you're hearing from Ms. Dunham and Ms. Fisher is that they just disagree with that conclusion. So I think we're on the same page on the first issue, but definitely not on the second issue.
Okay. Do you concur with that description? You just are in disagreement.
Yes, I would concur that we disagree on the statutory construction as applied to time schedules, even if when they're in the basin plan with the final TMDL compliance schedule.
Thanks. Okay, and then on the limits and targets.
Sure. So this issue is, quite frankly, we did a bit of a flip-flop from the original June order. In the June order, we said that the targets and the limits that are based solely on fertilizer application of nitrogen, that those should not be used for any purpose. We received comments that that's actually all that the regional board has to rely upon in the short term for quite a few of their growers, because their growers are not reporting nitrogen removed yet. And so we essentially changed in the revisions on September 8th, we changed the approach so that the regional board could continue to use just that fertilizer application data by itself and compare it to the two numbers that they developed, which are roughly based on the 85th percentile historic use of nitrogen fertilizer application and the 90th percentile. They could continue to use those numbers as essentially outliers or anybody who exceeds those numbers could be required to take additional education. That's the only purpose that they could use those numbers for in the revised draft order. We can certainly, if you'd like, talk about the relationship between those numbers and the California Department of Food and Agriculture fertilizer guidelines. And Ms. St. Pierre is available to do that if you'd like, to do sort of a technical comparison. You did hear from Mr. Keeling that the 85 and the 90 percentile numbers are actually consistent with their guidelines. We've confirmed that they're very, very similar. So what you're hearing is, at this point in time, your staff would be allowing, in the revised proposed order, would be allowing the regional board to continue to use those numbers only for education, and also only until those growers actually start reporting nitrogen removed.
One correction, Mr. Riles, I believe also for INMP certification, it could trigger a requirement to have the irrigation and nitrogen management plan certified, is what I believe I read in the order. So it's not just additional education and outreach.
I'll need to check that, because if they're not reporting nitrogen removed, and we said that then they won't be doing an irrigation and nitrogen management plan. But let me check in the interim and just see if we said that by error. We would take that out if that's what we said. But again, the point being limited purpose, limited time, and allowing the regional board to continue to use that metric just during that period of time and just for that purpose, just to continue with some continuity for those growers who otherwise would not have any metric against which to be measured.
That's helpful. Thank you. I think maybe for me, I just need to go back and take a look at the language that you're citing and the recommended change on page 17. Maybe there needs to be just some further clarification, because there is circumstances in which it could be used, but maybe there just needs to be some further clarification to link it up, or maybe think about, as we close things out, how to help us crosswalk, if there is any confusion.
So I think what you're hearing, and maybe Ms. Dunham can confirm this, is there actually is just a disagreement here, not a clarification that's warranted. What I'm hearing Ms. Dunham say is that the grower shipper petitioners do not want the fertilizer and nitrogen application data used for any purpose whatsoever. So they would not agree with the approach that's spelled out in the revised draft order.
Even for the limited purpose, Ms.
Yeah,
Dunham,
that is correct. In our response to the original order, we were supportive of the nitrogen application not being used for any purpose, and I actually commented that nitrogen application targets should also not be used for any purpose. So the flip-flop to then say, well, we're going to allow it for an interim purpose is inconsistent with the position that we've taken all along, that nitrogen application itself is not reflective of what is the potential impact of water quality, and it's an inappropriate metric, even in this interim component.
I guess what I'm struggling with is that I understand why the flexibility is in the order, but the point that Ms. Dunham, you made regarding that it doesn't account for other factors such as removal and soil uptake or plant uptake. But for this limited purpose, it seems appropriate. So I just want to make sure, are you concerned about the precedent that sets, as opposed to it's for the limited purpose of education and these other aspects?
We've always been concerned with the precedent that even the suggestion that the water boards have the authority to have some control over the amount of nitrogen that a grower applies, because we think it exceeds the authority that's based upon protecting water quality, especially because, again, with an A-R, you're then connecting it to what is that potential impact to groundwater, how much fertilizer in the gross form that a grower applies without any consideration of any other management factors is unrelated to that. And so we've always taken a very hard stance since the beginning of this process against the use of nitrogen applied as any type of a metric within this program.
Yeah, thank you, Vice Chair. And if I can, It's interesting because I think we all agree that these are very complex natural systems. And, our regulatory programs are coarse compared to the complexity of what actually happens within the ground, especially with application. And I hear the same thing coming from the regional board as well, where, part of the flexibility they were looking for is an ability to account for these other processes that aren't just the AR, what's removed from the property, what's applied in that space. And so it's just interesting because I think, there's some commonality between you there. But I think, ultimately, when we think about this program, it's a little hard to draw too hard a line and say, well, we can just don't have, absent any removal data, we can't do anything. And we can't see that there's, and I won't use the word, but perhaps over application compared to neighbors, and especially, larger amounts, which, yes, we can argue that there are other factors that are removing, but, large over application kind of to the natural mind would be something in a place that you might want to target, all things being equal on the removal side. I think the challenge becomes with saying, don't engage, don't even have a discussion around a data point that is missing, the removal side, and say, well, the hard line is here until you have removal, you can't really get to here. What I think we're saying is just outreach and in a way to start to try to address things. So
I think there's one clarification to that, though. There is
Please.
still the program, which includes education and outreach and everything that goes with it. Here it is an additional effort, right? So the nitrogen application information becomes an additional bar. So the growers are still in the program. They're still having to participate in trend monitoring. They're still having to do their education and outreach requirements regardless, right? So it's not that there is nothing happening for those until they have removed data. It is that additional trigger that then they are subject to additional education and outreach because of a amount of fertilizer applied that has no context in relationship to the crop and their management and what goes on with it. So that is our concern. They're still part of the program, should be. I've been a big advocate for that for years. So I just want to make sure it's clear that we're not saying that nothing is happening. That's not the case.
I appreciate that. And
Yeah.
I do mean to overstate on that part. And I guess it's just, the appropriateness of being able to say amongst your peers, you're in this very higher percentile of application. But anyway, I appreciate it. Yeah, please, Vice Chair.
But through that educational opportunity, wouldn't that be an opportunity for the grower to say, there are unique circumstances on my farm, and to in turn educate the educators or the regional board or whomever it would be?
Depending upon how it's used, right? I mean, because this is kind of being added in, there's not, as far as I know, no specificity to it as to how it has been even used in the interim for an additional trigger for education or outreach. So I don't know how the regional board would then utilize this information on what that program would be or look like.
That's correct. We don't specify for the regional board on remand exactly what that education would look like. I did want to follow up on the point, though, that any grower who does have perhaps uniquely high removal rates is absolutely welcome to submit those removal rates, even if they're not required to. And under the existing targets and limits for fertilizer application, there's a statement in the waste discharge requirements that say that those don't apply if the application rates, when combined with removal rates, are consistent with the other three compliance pathways that we're allowing the regional board to continue to use for A-R in the order. So that might ameliorate some of the concern. Another thing that you might want to ask Mr. Keeling, because this sort of debate applies only to growers who are reporting nitrogen applied and not yet reporting nitrogen removed, he may have some thoughts about when they may be having more growers start reporting nitrogen removed on remand, because of course then the issue just goes away if everybody's reporting nitrogen removed. And if I can, just the last issue, I did go back and check, and the order is correct for fertilizer. Excuse me, I should say we wrote it the way we intended. For fertilizer application, the only consequence of exceeding the 85 and the 90 targets is education. what I think you were referring to, Ms. Dunham, is for the A-R compliance pathways. In the interim, the consequence is either education or irrigation nutrient management plan certification.
Thank you for the clarification. Appreciate that. Got them mixed up. Okay.
Nothing further. Thank you. Thank you, Ms. Dunham. Looking forward to, I know what will be further discussion through the course of this afternoon. Next, I'd like to call up the California Coastkeeper Alliance petitioners. And I believe we'll be started off here with Chelsea 2.
Good afternoon, Chair Esquivel, Vice Chair D'Adamo, and board members Firestone, McGuire, and Morgan. My name is Chelsea Tu, and I'm the Executive Director of Monterey Waterkeeper. And I have the privilege of speaking to you before, on behalf of the California Coastkeeper Alliance et al. Petitioners. So before I continue, I'm going to first pass the microphone to my colleagues Horacio Mezquita and Anthony Miranda to talk to you about the extent of the nitrate crisis that the Central Coast region is facing and the detrimental impacts of nitrate contamination that the San Gerardo community has suffered.
Good afternoon, Chair Esquivel and board members. Thank you for having us. I'm just going to read some points. So my name is Horacio Mezquita. I live in San Gerardo for 34 years and worked for San Gerardo for 16 years. Last year, I stopped working for them. I went to my family farm. I've been farming since I was a kid. But I'm still helping the San Gerardo community because they are working on a transfer of the water system from the county to the community. The San Gerardo project was built by farm workers and their families in order to have a place that they can call home, not just a room on hotels or pile up in garages. They needed a home. And many volunteers help us to build that community from everywhere near the Salinas area. We did it with just our hands to have a home. The Central Coast depends on groundwater for drinking, showering, and everyday uses. 90% of the Central Coast domestic water comes from groundwater. Yet, many communities, including San Gerardo, has or is suffering from too many nitrates in our water for many decades. The community experienced dangerous levels of nitrates beginning in the 1990s. Visible health impacts in the skin were inflicted to the residents by nitrates and TCP. Other members of the community developed cancer. 7 members already died. 3 are getting chemotherapy. The community was forced to rely on bottled water for 5 years, plus 4 years on a filtration system, which was not 100% reliable. Because it failed a few times, and every time it failed, the contaminated water went again into the pipes of the water system. Moreover, the cost of filtrating polluted water was $17,000 to $18,000 a month, which the State Water Board and Monterey County paid. Now, can you imagine relying on a decade of bottled water and communities that in the Central Coast, they haven't had clean water for more than 30 years. They're still relying on bottled water. So nitrate contamination does not just result in significant health costs. Polluters have passed down the significant economic costs to the San Gerardo community and the public over the years. For 11 years, San Gerardo Cooperative could not refinance its loans. The property had no value because of contaminated water. This was a major setback because the community was paying $170,000 a year on its principal and and interest. It was too much money for the community. The cost of digging the new well, which is 1.8 miles away from the community, it was $6 million, which the state board paid and the Obama administration. I came like 17 years ago for that to request that the state water board help us. This is just a drop of the public dollar that would not have been spent if there is meaningful regulation on the amount of nitrates and other chemicals that growers can pollute. So they are not continuing to contribute the contamination of our groundwater. The cost of the new water system increased our water rates by 500%. That depends on the poor or the poorest of the poor, the ones that have to pay higher rates. Some residents are paying 16 to 18% just on using the water that the water board helped us to construct. I am here to share that bottled water is not an adequate solution. Filtration systems can fail and can harm people because it goes inside the pipes again. And digging a new well for us will not work for San Gerardo because the nitrate levels on the new well are increasing. With the most recent data showing nitrate concentrations over 8.25. We started this well in 2010 and it started at 3 points. Now it's 8.25. And the problem was that it wasn't even, the sample was not even taken at the highest level of contamination, which is when the growers extract the water, put so much chemicals in the soil, and you're supposed to take those samples before the rains. That way you know which is the maximum contaminant level. That's why the board must stop pollution at the source so that nitrate levels do not continue to climb and exceed the maximum contaminant level of 10 milligrams. There is a factual and legal support for Act 4.0, enforceable fertilizer nitrogen application and discharge limits. If you delay the process by asking an expert panel to look at the information that you already have, you will be allowing nitrate levels to increase at San Gerardo, which will directly harm our health and further increase the cost of cleaning up our water. I hope you find the courage and the wisdom to maintain these limits because enforceable regulation is the only way to get the growers to reduce how much fertilizer they apply on their farms and into our waters. Your decision on maintaining enforceable limits will save lives and costs for communities in the San Gerardo, the Salinas Valley, and the entire Central Coast. So just to close, I just want to say that we need to take care of our water. It's making us sick. People are dying. We cannot see the cancer and where is it coming from. But the people of San Gerardo has experience in getting sicknesses in the skin that we demonstrate to the health department, to the county, and to the state water board, and to the federal government. that any pollutants can harm us and can kill us. Thank you.
Very much, Mr. Amisqueda. I appreciate that. And thank you for traveling up here and sharing your voice on this issue here.
Afternoon. Thank you for your time. I have lived in San Gerardo for over 35 years, born and raised. It is a quiet place to live in, magnificent mountain views surrounding beautiful agricultural fields. Yeah, can we go actually to the 2 slides? I'm sorry. One more. Thank you. It is a wonderful place to raise your children, a place where you can start your family roots. But most important, we are a strong community. A community that has been through a lot of trials and tribulations. Both my parents came from Mexico, and like many who immigrated to the United States, they chose this great state of California. They hope for a better life, not only for themselves, but for their growing family. Like many, they had the American dream. They wanted to build a life here in California. They saw what this beautiful state can provide. When my parents had the opportunity to move to San Gerardo, they saw this as the American dream coming true. Little did they know that having clean water was going to be the challenge and a fight from the same people whom they worked for. San Gerardo already went through 3 contaminated wells that had elevated levels of nitrate. Those contaminated water wells led to many health issues, from rashes all over our bodies to some other losing their hair, and more serious health issues like tumors and cancers that led to some residents in my community passing away. In late 2009, my father was diagnosed with stomach cancer and unfortunately passed away in 2010. My nephew, as a little kid, got appendicitis, and during the operation, surgeon found a tumor wrapped around his appendix. This is only 2 people in my immediate family that were impacted by high nitrate levels. There were many families in my community that their health issues were compromised due to the levels as well. And some of those people passed away and some of them survived, thankfully. Having such a long-term deadline of 2025 brings many concerns to us who live in San Gerardo, but it should also bring concerns to the residents of this beautiful state. By shortening the timeline to 2041, we believe it gives both parties feasible time to produce innovative ways to help replace these dangerous nitrate levels that are harmful. In 30 years, a lot can happen and will happen if we do not act now and shorten the deadline to 2041. San Gerardo residents do not want alternative water supplies. If that means growers have longer to pollute residents' wells. This political trade-off is unacceptable, not only to San Gerardo residents, but other Central Coast residents, and does not fulfill the board's own commitment to achieve the human rights to water. Instead, the State Water Board must direct staff to amend the revised draft order to require growers to comply with Ag 4.0 faster. In particular, the board must ensure that all Central Coast Water Board establishes a final compliance timeline for all growers. Instead of allowing growers the option to create a final time schedule for themselves, the board should direct the Central Coast Water Board to determine the final schedule. Finally, we urge the board to set compliance time schedule to be no longer than 2041 to protect our community residents as soon as possible while still allowing growers almost 20 years to adapt their practices to meet their final limit. Finally, the State Water Board must address the root cause of pollution by requiring growers to stop contaminating the water as soon as possible, not just propose a band-aid solution. I want to thank you for your time.
And thank you for yours, Mr. Miranda, and for coming up here and sharing your voice in the communities. Really appreciate it.
Thank you. Could you advance to the next slide, please? Thank you, Horacio, and thank you, Anthony. Unfortunately, San Gerardo, as you know, is but one of many communities in the Central Coast region that are suffering from severe and widespread fertilizer nitrate contamination. As you can see on this map, recent data from Preservation Inc. shows that 1 out of 4 on-farm domestic wells within the region exceeds the drinking water standard. Nitrate contamination, as you know, can lead to serious health impacts, including blue baby syndrome and birth defects, as well as various illnesses in adults like thyroid cancer, stomach cancer, and colon cancer, just to name a few. And as the resident of San Gerardo and Anthony's family knows too well, too much nitrate can be lethal. Next slide, please. The nitrate crisis in the Central Coast region disproportionately impacts communities of color. The epicenters of the nitrate crisis are the Salinas Valley, Gilroy-Hollister Valley, Pajaro Valley, and the Santa Maria River Valley basins. As you can see in this table, areas with high nitrate concentrations are correlated with areas with high Latino populations. I do want to state in the record a correction on Road 3 related to Pajaro Valley for the chart. So this table should be updated to say that 30% of on-farm domestic wells in the Corralitos sub-basin exceed the drinking water standard, not the entire Pajaro Valley. And similarly, I'd like to state in the record that Latinx people make up 22.9% of the population in the Corralitos sub-basin area. Next slide, please. As we discussed earlier, growers have been submitting data on how much nitrogen that they're applying on their farms since 2014. Years of this data has demonstrated that many growers, as we've discussed, are over-applying fertilizer nitrogen above the guidance levels. The record also is clear in showing that growers in this region are discharging 340 pounds of nitrogen per acre per year in the Central Coast region. This is 10 times the maximum amount they could discharge without worsening the already bad nitrate groundwater contamination in our area. It is also important for us to recognize that the Central Coast Water Board in Ag 4.0 concluded that its past efforts to educate and help growers improve their management practices without further enforcement has not been effective. As well, Ag 4.0's findings demonstrate that the nitrate crisis is getting worse. Studies have shown that increases in nitrate pollution, this is incorporated in Ag 4.0 findings as well, will cost at least tens of millions of dollars statewide over the next several decades. And we want to note that this is probably an understatement, just given San Gerardo's experience that Horacio just shared. Next slide, please. Although Ag 4.0 is not perfect, we do applaud Central Coast Water Board for setting enforceable application as well as discharge limits. However, Ag 4.0's 2051 timeline for growers in the individual compliance program is simply far too long. Under this timeline, growers in the Salinas Valley, which is one of the worst hit nitrate contaminated areas, will not be cleaned up for another 50 to 115 years. That's 2 to 4 generations from now. In fact, the timeline for cleanup may actually be indefinite, given that 98% of growers are currently part of what's called a third-party program under Ag 4.0. This third-party program currently does not have a final compliance timeline. Next slide, please. So given the pervasive human and ecosystem impacts of fertilizer and nitrogen pollution, it is imperative that this board today take action to stop nitrate pollution. The most important action you can take to protect communities' health is to uphold Ag 4.0's enforceable application as well as discharge limits. These requirements are the legal backbone of Ag 4.0 and are necessary to protect the health of communities as well as our rivers and aquatic ecosystems. With all due respect, the East San Joaquin Order did not set a statewide precedent that prevented the Central Coast Water Board from establishing these limits. We discussed this in detail in our August comments submitted by CCK petitioners and other environmental and EJ organizations. We also want to note that regardless of the East San Joaquin order, the board must comply with the non-point source policy, which encourages pollution prevention as well as reduction, including through enforcement. In particular, key element 3 of the non-point source pollution policy requires waste discharge permits to have a specific time schedule as well as corresponding quantifiable milestones. The Central Coast Water Board created enforceable limits as quantifiable milestones in order to comply with key element 3. And if the board strips these limits today from Ag 4.0, it would be violating key element 3 and applicable 2018 Monterey Coastkeeper case. I just want to take a moment to say that non-point source pollution is admittedly different from point source pollution, but it's actually much more simpler than what previous speakers have talked about. When the farmers apply nitrogen, fertilizer, and pesticides on their land, we know that half of it goes into our surface water and groundwater. There's a simple scientific correlation between application of nitrogen fertilizer and nitrogen discharges. And this is, of course, documented in the record under Ag 4.0's finding. So we urge you not to let the insistence on quote unquote accuracy come at additional cost of the health and the lives of Central Coast communities. So instead of basing your decision on an outdated order for the Central Valley, you have this opportunity to use your legal authority and the supported facts before you to uphold Ag 4.0's enforceable limits. Next slide, please. We're also very concerned that staff proposed to allow the Central Coast Water Board to extend Ag 4.0's final timeline so long as it creates a regional alternative water supply program. As Anthony stated, this is a false solution that is simply not acceptable to communities like San Gerardo and other communities that are suffering or are being threatened from the impacts of nitrate and other types of water pollution in their drinking water. Communities need and have the right to clean water today and tomorrow. We urge the board, therefore, to strike out any mention of a longer timeline, including deleting portions of page 26 and footnote 103 that refers the reader to CV SALT's program that has a 35-year timeline. 30 years is far too long, and 35 years is simply unacceptable. Instead, the board must direct the Central Coast Water Board to require all growers, whether they belong in an individual or third-party program where most growers are currently enrolled in. We urge you to direct all growers to meet a much faster compliance timeline of 2041. This faster timeline is necessary to truly advance your commitment to achieve the human right to water, while still reasonably allow almost 20 years for growers to adopt practices to reduce their discharges over time. Next slide, please. So we do appreciate that the revised order included long-term solutions as part of the proposed alternative water supply program. And as stated in section 13263G of the Water Code, water pollution is a privilege, not a right. Therefore, we also propose language that you see before you and clarifies that growers as polluters must pay for this program. We agree with the Central Coast Water Board that the program can be most effectively administered at the state level in coordination with different agencies, for example, through the SAFER program. So we are submitting proposed language on this as well for your consideration. Again, we urge the board to consider a faster timeline of 2041. The longer you wait, the worse the problem will get. A longer compliance timeline may also not be in the interest of growers, because the longer the timeline, the more growers will have to pay to clean up contaminated water. Next slide, please. I would like to close my portion of the presentation with the board's duty to achieve the human right to water. Starting with Water Code section 106.3, That is the human right to water law, which declares that every human being has the right to clean, safe, affordable, and accessible water adequate for human consumption, cooking, and sanitary purposes. This law also requires all relevant state agencies to consider the state policy when revising, adopting, or establishing policies and regulations, such as this order today. In its 2016 Human Right to Water resolution, this board also committed to realizing, not just considering this right, as its top priority, and also to consider the human right to water and all of its activities that could affect drinking water, such as this order before you today. AB 685, the board's commitments, along with AB 2108, means that the board must consider the impacts of this order on communities experiencing or being threatened by drinking water contamination and other vulnerable communities. The revised draft order states that the board exemplifies its human right to water commitment by proposing to involve impacted communities and EJ organizations in the creation of an alternative water supply program. We appreciate the intent, but unfortunately, engaging communities on Band-Aid solutions does not fulfill the board's duty to achieve the human right to water. Next slide, please. In order to begin to meet your duty to achieve the human right to water, the board must conduct, at the very least, an analysis on the health and economic impacts of this order on environmental justice, tribal, and communities of color under the laws that I mentioned and the commitments that you have made. All of the major changes to Act 4.0 that we've discussed today, including the removal of enforceable limits and possible extension of the finals compliance timeline in exchange for an alternative water supply program, and more, could have detrimental impacts on these vulnerable communities. So the impacts must be studied so that the board can meaningfully weigh the costs and benefits of these proposals before making your final decision. The bottom line is that the board has the legal obligation and you have the moral responsibility to honor your commitments to consider the impacts of the many changes that you're making or that staff is proposing to Act 4.0 on the most vulnerable communities. Ultimately, communities like San Gerardo have been waiting a long time, decades, for the board to not just pay lip service to, but find the courage to follow through with your commitments to prioritize and realize the human right to water. Today, this board has the authority and the opportunity to achieve the human right to water by upholding the enforceable limits, creating a uniform, faster 2041 final timeline, and mandating a regional water supply program without subjecting communities to more pollution. Finally, we urge the board, next slide, please. Finally, we urge the board to direct the Central Coast Water Board to reinstate mandatory riparian and wetland setbacks under Act 4.0, which my colleague Sean Bothwell from California Coastkeeper Alliance will speak more on. Thank you for your time.
Thank you, Ms. Tu. Mr. Bothwell.
Good afternoon, Chair Esquivel, board members. My name is Sean Bothwell. I am the Executive Director for California Coastkeeper Alliance. I have to say, sometimes I feel like I'm working with two different water boards. On one hand, there's the water board that created this racial equity plan. And then on the other, we have this draft order that's here today. This racial equity plan talks about the commitment to center your work around BIPOC communities that are disproportionately represented in vulnerable communities. The racial equity policy talks about reaffirming your commitment to the human right to water and demonstrating that every human being in California, including BIPOC communities, deserve safe, clean, and affordable water. This resolution talks about reaffirming your commitment to protecting the public health and the beneficial uses of water bodies, particularly for BIPOC communities. And then we have this order today that spends the entire introduction talking about the importance of agriculture without any discussion about the impacts to BIPOC communities. It talks about removing enforceable limits and therefore any deterrence to stopping the over access of fertilizer that's polluting their groundwater. And it's this order that supports the goals of 2108, but refuses to do the 2108 analysis. And so I ask, when are we going to start seeing action over just statements about racial equality? Let me start with the application limits. As a reminder, Water Code Section 13263 requires the water boards to prescribe requirements to achieve the water quality objectives and protect beneficial uses. The regional board decided that enforceable limits was necessary to protect water quality objectives, or to achieve water quality objectives and protect the beneficial uses. And yet this proposal proposes to remove the enforceable limits, and again, along with any deterrence over the application of nitrogen and the continuance of nuisance to domestic well pollution. Now, on the draft order, it admits that the East San Joaquin order never contemplated the use of enforceable limits. Good or bad, it just wasn't part of the discussion. And yet they staff insists that enforceable limits are precluded based on, this is a punishment for last time.
Yeah, apologies, everyone. We'll, it looks like it stopped, so we'll hope that it does. Just one moment.
Pull station pulled on the 20th floor. The 19th floor. Areas.
You know, let's unfortunately calmly file out to Cesar Chavez Plaza, and we'll all gather there and await further instruction. Thank you, everyone. Well, let's see if we can actually hear what the announcement is here. 1 second. Sorry to be getting everyone up and down.
You can hear it. You've been hearing it for the last one.
Yeah. I think we're okay here for now. It sounds like it was 3 floors higher above us. We'll see if the emergency makes its way to us here. Let's.
I know. Maybe that's their secret now. Like Sean's annoying us.
Yeah.
Chair Esquivel.
Cut Sean off right now.
We're checking with the building right here. So
Yeah, the security desk just reported we do not need to evacuate.
thank you. Thank you, Mr. Wiles. Everyone can stay seated. Thanks. Appreciate that. And apologies to the interruption, Mr. Bothwell. You setting the place on.
All right, so back to enforceable nitrogen limits. So the draft order admits the East San Joaquin never considered one way or the other whether enforceable limits were appropriate at the time. So it was silent on that. And yet staff insists that enforceable limits are prevented by the East San Joaquin order. So I want to point you to section 11 of the East San Joaquin order. And that is where you'll find the justification both in the order and in today's staff presentation as to why the justification for why they don't believe enforceable limits are allowed. They point to a paragraph in section 11 and it was cited again today. Section 11 is the title of it reads Direction to Central Valley Water Board regarding the use of submitted data. That section then goes on. Sean's getting good. Oh, okay.
May I have?
Oh, yeah.
4 has been determined to be a false.
Yeah, it was a false alarm. So I think we should be good after
Floors
this.
19, 20, and 21. And you can now.
That may be the end of it there. And so thank you, Mr. Bothwell, for the patience.
All right. So the justification for the fact that staff believes enforceable limits are prevented comes from section 11 of the East San Joaquin order. That section is titled Direction to Central Valley Water Board regarding use of submitted data. That section then goes on for a couple pages, and no less than 10 times does it say, we direct the Central Valley Water Board to do X, to do Y, to do Z. 0 times does it say anything about that section being precedential or that other regional boards need to follow that section. I'll also point you to page 9 of the East San Joaquin order. Page 9 says, and I quote, in the sections that follow, we indicate which of our conclusions have precedential effect and will guide irrigated lands regulatory programs statewide. Meaning, if it's going to be precedential, we will say it in the section of the order. There's a footnote connected to that, which says generally the State Water Board petition orders are precedential unless otherwise designated. Here, because of the significant variation in agriculture practices statewide, automatic application of all requirements endorsed in this order to all agriculture discharge programs statewide is inappropriate. So essentially at the top, we set up that unless we say it's precedential, it's not necessarily precedential for this circumstance. And as I said, section 11 says nothing about enforceable limits, and yet that is the section that staff is relying upon to say that enforceable limits are completely prohibited based on the East San Joaquin order. Real fast, I want to talk about riparian setbacks. I know that's not in this order, but it was part of our petition. So according to the Regional Water Board in draft orders, and I quote, riparian areas play an important role in achieving numerous water quality objectives established in the basin plan to protect specific beneficial uses. Then goes on to discuss temperature, toxicity, dissolved oxygen, TSS. The draft order also talks about how degraded riparian and wetland areas are along the coast and at the current status unable to achieve water quality objectives. And yet without any justification, the Water Board removed those riparian setbacks from the final order. And again, as I mentioned, was not addressed here today. So I felt the need to flag that. And then lastly, on the lack of a 2108 analysis, staff justifies it, as they said in a footnote, and talk about this order being modest compared to the East San Joaquin order. Honestly, I don't see any language in AB 2108 that differentiates a general order that's modest versus one that's major and more precedential. And the entire point of 2108 was for staff to disclose trade-offs, right? Whenever there's a permit or policy, there's always trade-offs of what we're going to do. But the point of 2108 was for staff to identify those trade-offs, the impact it might have on communities and potential solutions to those trade-offs, and present them to you all, the decision makers, so that you can know what those trade-offs are. Again, you guys are the decision makers in this case. The order is going to be remanded back to the regional board. There's no to little discretion for the regional board to change their mind on what's going on here. You're asking them to remove enforceable groundwater limits, which directly disproportionately impacted communities. And yet we're doing no analysis to determine what those impacts are, what possible solutions there might be. And then lastly, and I kind of wish I found a way to capture this in the legislation, but a good rule of thumb is if we're going to have community members from the Central Coast drive all the way up here to use their day to speak on how important this issue is, then it should be important enough for your staff to identify those impacts and do the proper environmental justice analysis. Thank you.
Thank you, Mr. Bothwell. Looking to see if there's anything from the dais and seeing none.
Yeah, actually I do. Sorry, would like to spend, if it's okay, just a little bit of time talking about Mr. Bothwell's comments in 2 areas. And one is, and I'm looking at Mr. Wiles. One is because this is such a significant decision. And I think the way that the board's orders on precedential requirements is very important to clearly articulate. And I think it's been done in different ways over the years. And I do think in some instances has introduced some confusion. It's a little complicated to understand what applies to what regional board under what circumstances. So I am going to look to you, Mr. Wiles or Mr. Gilman or whoever would like to respond in terms of, in this case, to Mr. Bothwell's point about enforceable limits being not directed necessarily towards the Central Coast Regional Board. Can you help me and maybe the audience understand a little bit better how you read that differently here in this case?
Yes. Thanks, Board Member McGuire. So I think what's missing is sort of the, if you will, the context of the East San Joaquin order. And in the East San Joaquin order, the board took into account the expert panel report at the time and a lot of public testimony from growers, from environmental groups, from the Central Coast Board, from others about what the next level of approach for regulating irrigated lands should be. And in the East San Joaquin order, the board made some very important decisions with respect to, we will now do something that's not done anywhere else and has not been done here in California in the past, which is to require the collection of nitrogen application data, nitrogen and nitrogen removed data. And we will, as we spelled out in a lot of detail in the East San Joaquin order, we will direct the development of things like crop removal coefficients and other tools so that we can better understand how these two variables, application and removal, actually work. And we did very clearly direct all of the regional boards to use this approach, including target ratios. So these are target ratios that the regional boards are required to include in their waste discharge requirements going forward. And we said with respect to those target ratios, and Mr. Bothwell cited the correct page, and it was certainly spelled out in the draft order. We said that for this target ratios, we are not ready yet to determine whether or not these can be enforceable, because we didn't yet have the experience collecting the data and analyzing the data to see how it could be used in the future. Quite honestly, our hope is that this is the right approach and that there's a scientific basis for using application and removal data so that we can, as promptly as possible, reduce impacts to groundwater from nitrogen. But the state board set out on a path, and what we're doing now is some course correction because it's still the path. And our view is that the state board East San Joaquin order, if you read it in context, you will see that these target ratios are just targets. They're not enforceable limits. They're target ratios for a reason, and we spell out why they're just targets at this point in time. So I do take the criticism, though, that we could have used the precedential word in that same sentence. And I think we probably need to be much more careful going forward. I thought we did a very good job at the time, but clearly not everybody read it the same way that we intended it to be written. I can offer that the revised draft order attempts to be very precise. I hope we hit the right level of precision with respect to this order and which provisions in this order are precedential to avoid any confusion in the future. But I think we just have a fundamental disagreement about the larger context for the application and removal targets that are spelled out in the East San Joaquin order.
Yeah, well, I appreciate that. It's something I've struggled with to understand clearly. I accept your explanation there and also just emphasize the importance of being clear as we go forward with what the expectations are for various regional boards in terms of precedential designations. So I think this is an area, I appreciate your flag, Mr. Bothwell, and certainly as we make these decisions, don't take that lightly at all. The other question I wanted to ask while we're here on this area is on the riparian and wetland setback provisions. Could you comment on that?
Sure, happy to. So as the board members know, and I think most of the commenters know, we are the state board is acting in its review capacity here. And so in that capacity, reviewing an action by the regional board, the State Water Board has discretion to pick the issues that it wants to address. And in this particular proposed order, we did not pick riparian setbacks as an issue to address. Our focus was more narrow. It really was essentially the catalyst for the review was the precedential issues in the East San Joaquin order. The remainder of the discussion in the draft order, excuse me, the revised draft order before the board today is not based on sort of resolving scientific or technical issues or even policy issues. Rather, it's spelling out whether or not the regional board had authority to do what it was doing from a legal perspective, and in some cases, the policy perspective of just, yes, this board agrees that it was an appropriate approach for the regional board to take, but we did not do anything as significant as in the East San Joaquin order, where we actually revised the waste discharge requirements or even directed the regional board how to revise the waste discharge requirements in this proposed order, other than to conform to the precedential direction already directed by this board. That also essentially explains why we don't view this action, if adopted by the board, as either issuing or reissuing waste discharge requirements. And that's why, although clearly the board's very concerned about groundwater impacts and developing a new alternate water supply program, we're not talking about that so much in the context of human right to water or AB 2108, because that's not a revision or an issuance of the waste discharge requirements. So it may be, I can understand why somebody might think it's splitting hairs, but we are trying to be pretty careful in terms of applying the statutes that apply to us.
Thank you.
Thank you, board member. Board member Firestone.
Yeah, thanks for that discussion. And just along those lines and furthering on the theme, I think we've seen this in a lot of cases where we do a lot of really substantive rulemaking, frankly, through the petitions up here and through our orders. And certainly the East Side San Joaquin order was one of those. And I'm glad that we make it clear in here that we would, in that case, we would be applying or interpreting to apply 2108. I will say, along the same lines, it's hard when if you're in the Central Valley or North Coast or Southern California, you're probably not paying attention to the petition of a Central Coast regulatory WDR petition if you're impacted by nitrate, but it will impact you. And so I think we do need to be thinking about how we better incorporate outreach and engagement on our water quality petition processes so that we can be incorporating engagement and analysis, regardless of whether technically AB 2108 applies. So I guess I would say, first of all, I appreciate that we're recognizing that it does apply to our actions when even if we're not issuing a WDR ourselves, but we're substantively in factoring that through our orders, but also just recognizing that I think we could have here, and I think we should in the future be looking at how we do a better job of engaging and looking at that within our water quality order and petition review process, because it's a different animal. There isn't the same types of public noticing and rulemaking process. And so I think, but there is, as we've seen with East Side San Joaquin, real statewide implications. And so I just would like us to figure out how to do that better. I also think, there are a lot of good points said today, and I know there'll be a lot more to come. I think many of us are in the have been in this work for a very long time. And, but I do think stepping back and just reading the order, it does stand out that, I think we are giving more of the context around agricultural impacts than around community impacts, just even in the way that the time spent in terms of the introduction and acknowledging those impacts. And I think that's certainly not, I don't think that that's reflective of the values of the board and the reason that we're working on this, but I think that is how it reads now that I'm standing back and looking at it. And so I think that's important for us to make sure that we do a better job on next time, because words matter and the time that we spent really acknowledging those impacts matters. And I know that that's why we're all focused on this work here today. And so we should be acknowledging that in the orders that we write, I think, a little bit more explicitly.
Thank you, board member. Vice Chair.
I'll just chime in as well, and I do appreciate Mr. Bothwell, your comments. I too think we could have done a better job on this, and this is with respect to community impacts, but for me as a board member, I was threading it together with all the work on East San Joaquin, the expert panel, and we were doing that because of community impacts, of drinking water impacts. And there is on page 2 a reference to drinking water impacts. And so I agree. I think probably we need to do a better job telling the story. But I did just want to reflect on, as I read through it and connecting it together with previous decisions. And then the other point that I wanted to make, having been here when we adopted East San Joaquin, it was very clear to me as to the precedential nature of it, because there were certain areas. I'm a big fan of coalitions. I really wanted the coalition piece to be precedential, but the rest of the board didn't concur. And so we really did have a lot of dialogue. It's there in the record as to what was precedential and what wasn't. And then we directed a team of people. I know Amel Wadwani and Darren Polhemus to spend time going around and doing a presentation to all the regional boards because of that very concern, Board Member Firestone, that you note that not everybody's following the precedential decision that happens to be before us at the time, because it's, it may come out as precedential, but it's related to a specific set of facts in a specific region at the time. And so I do think that I thought we made it clear, and that's one of the reasons I was quite surprised by the decision at the regional board. And I know we'll get into more details as we close out later today, but I did just want to throw in my perspective on the development.
Thank you, Vice Chair. I really appreciate the discussion. I know certainly here for me as well, it's a narrowing of the issues so as to, ultimately, the policy discussion around the aggressiveness and the need to continue to advance this work because it's so critical to communities is really important. And this isn't a place where that will be decided. And I think, for me on this decision, as uncomforting as it can be, it's around the nature of the precedent order on the Eastern San Joaquin and conforming around it. But I look forward to what will be continued discussion around this. But it's central to how we're viewing this action and this decision before the board. And I appreciate that it's very difficult to unpack what is the larger context of these policies. But when you look at the order and you look at what we're trying to determine here, it's again consistency with previous decisions of this board and ones that are important again around the aggressiveness here. And I look forward to what we can continue to have come out of this. But look forward to what will be further discussion here. Next, I would like to call up Sarah Lopez with the Central Coast Water Quality Preservation Incorporation.
Thank you. Thank you. Can you hear me okay? Great. Great. Well, good afternoon, Chair Escavella and members of the board. I also want to acknowledge and thank the State Water Board staff for their efforts on the proposed order and all of the stakeholders who've commented in and traveled here today. For the record, my name is Sarah Lopez. I'm the Executive Director of Central Coast Water Quality Preservation Inc. We go by Preservation Inc. on the Central Coast. And we are the third-party group that's approved by the water boards to assist Central Coast growers in complying with the Irrigated Lands Program. My slides today deal primarily with a single topic that came up in the changes to the proposed order when it was revised on September 8th, I believe. But before getting into that, I just wanted to acknowledge and thank the State Water Board staff for being responsive in the revised proposed order to several items in the comment letters, in particular from stakeholders. So one of these items is the discount factors for high organic carbon amendments. Those are quantitatively important to estimating nitrogen loads or loading risk, and the devil's certainly in the details as to how we ultimately do those calculations, but certainly it's quantitatively important, and so thank you for allowing that to stay in. I also wanted to thank you for the direction given to the Central Coast Board that targets and limits may not be used to remove growers from third-party programs. We are working so hard to build these programs, in particular for the growers, the very growers who are struggling to meet water quality targets. And so this layer of predictability is going to be really, really helpful to us in our work going forward. Finally, I'm not going to comment on it today, but I did want to acknowledge the evolving discussion on an alternative water supply program, and that will no doubt be a topic of active dialogue as the order development process goes on. Next slide, please. So with this slide, I just want to give you some background information about our third-party group members, because this is important context for the issue that I will raise in my next few slides. Our third-party membership typically exceeds 95% of the operations or by acreage enrolled in the Central Coast Irrigated Lands Program. And the other 5% are not a subgroup that are complying as individuals. They're typically operations that are in the process of terminating, or they're in the process of getting back into the third-party group. So really, in a general sense, we have the entirety of the industry enrolled in our third-party group. Our membership, you can look at the top pie chart there and see that over 2/3 of our membership by acreage farm vegetable and berry crops. And so that's one key point I want to make, is that for INMP in the Central Coast region, vegetables are not the exception. They're actually the rule. They're the predominant crop that we need to run programs for. And the other pie chart towards the bottom of the slide just breaks our membership down by operation size. And so this is just another point I wanted to make. Over a quarter of our membership are growers who farm less than 10 acres. Another third or more farm between 10 and 49 acres. And then there's another significant percentage that farm between 50 and 99 acres. So as a whole, the vast majority of our members are farming small, very small, and really tiny farms. And the vast majority of the acreage in our region, again, is vegetables. So for INMP reporting, for the science that goes into informing that reporting and into the regulation, on the Central Coast, we have to confront the complexities of vegetable cropping systems to be successful. So we're talking about crops that are annual with multiple plantings per acre per year, highly diverse. So it's not just grapes or walnuts. We can sometimes have 30 different vegetables, in the same field. And there's high nutrient requirements relative to some other crops. Let's see. Next slide, please. Now, an issue that arose in the revised proposed order from September 8th, as opposed to the original version of the proposed order, is direction to the Central Coast Water Board regarding enforceable limits on nitrogen applied. And this slide just shows the relevant language before and after the change. One thing I want to make clear is that with these comments, Preservation Inc. is not taking a position on the inclusion or exclusion of enforceable limits on nitrogen applied. It's simply that in the first iteration of the proposed order, the fact that they were removed relieved us of a complication that we face when we try to help our members who grow very diverse mixes of vegetables in a single field. And while that hurdle is not limited to small growers, it's certainly amplified in those cases. And it's greatest among growers who have limited technological and/or English skills and also limited financial resources. So at this point, I would just mention that I've tried where I can to engage with both water boards in their racial equity initiatives. And I've appreciated those opportunities, in particular to engage with the Central Coast Water Board and their staff. And those equity initiatives do include elements related to equity with respect to discharger communities. And I just want to point out that we face those equity issues and that they are amplified in the case of this INMP reporting when we have non-native English speakers, when we have monolingual speakers of other languages, when we have folks who, don't have a higher education, have limited access to computers and other technologies. These folks face really disproportionate hurdles to comply with the reporting requirements of the order. Next slide, please.
Sorry, I just want to make sure I'm following that point. Is that, are you concerned that allowing use of or recognizing the ability to use nitrogen application targets for educational purposes is going to be, I'm just trying to make sure I understand the concern or request.
Yes, thank you for that question. I will try to make that clear in my delivery of this slide. And I will also say that my specific response to that question has changed probably 3 times in the last 24 hours as I've become better and better acquainted with the language in the ESJ order. So at the end of the day, I'm trying to raise an issue that is, it's just a big challenge for us as we try to assist our members, and it's amplified. I just also want to point out that it's amplified for growers who fall into certain socially disadvantaged categories. And I'll try to get to clarity on the ask towards the end of the slide. So this is at the upper right of this slide is the table from Ag Order 4.0 as it currently reads with respect to the fertilizer nitrogen application targets. And you can see that 5 of the 6 named crops are grown in high diversity, rapid succession production systems. Actually, you can't see that from this table, but I will tell you, you can see that 5 of the 6 named crops are vegetables, which are grown on the Central Coast in high diversity, rapid succession production systems that could also be described as mixed vegetable or diverse vegetable crops or crop types. Many aspects of management, even irrigation and fertility, may in some farms they do treat mixed vegetables as a single crop, especially on the smallest, most diversified farms. So you might plant a row of bok choy next to a row of vegetables. You might even plant half a row of bok choy, and lettuce, and half a row of bok choy, half a row of lettuce, and use the same line of drip tape with fertilizer in it to irrigate both. And right now, Ag Order 4.0 mandates vegetable-specific compliance evaluations for nitrogen applied, and that's written into the order, so it doesn't allow any discretion to perhaps apply a diverse vegetable crop type for training or education purposes for growers who are struggling with reporting. And that raises 2 issues for us. One is feasibility, and the other is data quality. The feasibility issue is that when you are training a grower who doesn't have advanced education to do basic irrigation and nitrogen management, the lift is so heavy just to get to that water applied or that nitrogen applied value for that field, which the grower, even though it may have lots of different vegetables in it, they may be farming it as a single crop or only a few crops. So to then have to break it down between what went to the half row of bok choy versus what went to the half row of lettuce, not only is it impractical, but it can result in the need to guess. And then you end up with the data quality issue because you end up with a data set, which on the Central Coast is submitted into the public record under penalty of perjury. But when you get into these guessing situations, the data aren't real. And so that's a significant concern for us that was kind of alleviated when this element was written out of the first version of the proposed order. And my concern is really not whether it's in or out. It's just that the Central Coast Board is able to exercise the discretion and flexibility that's precedentially written into the ESJ order. And when I first developed this slide, I was referencing footnote 33 from the proposed order. It says that the regional boards can exercise discretion to apply alternative requirements to diversified, socially disadvantaged growers who do not operate more than 45 acres, have annual sales less than $350,000, and grow no fewer than an average of 2 different crops per acre. And then there's another exception for growers who don't operate more than 20 acres and grow no fewer than an average of 2 different crops per acre. And when you look at on the Central Coast, this very small group of growers who have still not submitted their total nitrogen applied reports from last year, I see, and I'm ballparking here and making a few assumptions, I'll just make that caveat, but I see roughly 40% who are not, 70% who are not native English speakers, with about 30% of those being monolingual Chinese speakers, another 40% being monolingual Spanish speakers, and almost all of them growing diverse mixes of vegetables. So these growers are really struggling with the reporting requirements, and we are struggling to assist them, and having to break everything down at the individual vegetable level right off the bat makes everybody's job that much harder. And the way that Ag Order 4.0 was written arguably prevents the Central Coast Water Board from exercising any discretion on these reporting requirements. So getting around to my ask here, again, I don't have a position or an ask one way or the other on having these, targets or limits in or out of the order. I just would really like to see in the remand, the rewrite of the order at least allow us the flexibility to have that discussion, especially in the implementation, especially in the short term, and especially as it relates to these disadvantaged categories of growers. I'm sorry that was so long-winded. I have one more slide, if that's all right. Great, thank you. And so this is my last slide. It's just a placeholder. I just wanted to restate a concern that I listed in my comment letter related to data quality with the INMP data set. That's the A and the R data. So because the proposed order directs that targets and limits be used only for the enforcement of education, this issue feels much less urgent if the proposed order is to be adopted as written. But as this is a regulatory process, I fully expect that we'll be faced with it again in the future. And as we look forward to scoping topics for an expert panel, and as the Central Coast Order evolves, we need to be mindful that A and R values can't be measured in a laboratory the way we do with a water sample. So when and if we do get back to setting enforceable limits, and particularly if those limits are to apply at the ranch level as opposed to, a township or a landscape level, we need to consider the data quality needs of an enforceable limit, and we need to consider what aspects of INMP reporting can actually be measured and reported with sufficient precision, accuracy, and confidence to serve that purpose. So is there a scientific basis for that A and R data? Absolutely. Are they valuable management tools? Absolutely. And do we ultimately need, a regulatory process that can be enforced? Absolutely. I acknowledge all those things, but I just, I deal with this data on the daily. I also deal with water chemistry data on the daily. I have for my whole career, and it's just not the same kind of data. And it's not the same kind of data that the water board typically uses to assess compliance with limits. And if we use it inappropriately or require that growers report with an inappropriate level of specificity, we run the risk of creating data that aren't real. So I just want to encourage careful consideration and expert panel discussion on this topic moving forward. Thank you very much for the opportunity to make these comments.
Thank you, Ms. Lopez. I really appreciate the comments and your work in this, all this in leadership. Mr. Bishop.
I just want to make sure I understood you correctly. I think your ask is that there's some flexibility in the size of for reporting on mixed vegetables. Your examples were small farms with mixed vegetables, and you also showed on the slide the requirement in the ag order now that reduces the requirements on less than 45 acres. And are you saying that you want to make sure that that's upheld, or that something similar is put in? Or I'm just trying to.
Thank you. So I'll respond kind of in two ways. One is with respect to size, I did focus my presentation on the smallest of the small and the most diverse of the diverse vegetable mixes, and also socially disadvantaged farmers. And I think that the needs are most compelling in those groups. I hesitate to put a limit on size only because I know of a few what might be called medium scale operations that also that are more kind of regenerative agriculture in nature and plant their crops in more of a mixed way rather than like, a field by field. So I'd be disappointed to see the discussion limited to only the 20 and the 45 acre farms, but those are certainly the most compelling needs. And then again, with respect to what I'm asking for, it's really just to have the flexibility and the discretion to tailor the reporting to those needs. And it's not so much whether or not they need to report R. It really has to do more with how specific you get on crop type. And so I was going to maybe try to avoid getting into this level of detail here. And I don't know the ESJ order well enough. But for example, all of Preservation Inc.'s challenges in the short term, at least, would for assisting these smaller, more diverse vegetable growers would go away if they could report diverse or mixed vegetables as their crop type, and we could focus with them on their irrigation and nutrient management, for their very small ranch, without focusing on, okay, well, how much of that water went to, like I said, the bok choy and the lettuce. If we could report them as mixed vegetables as opposed to every single kind of vegetable.
Can I ask a question on this? Sorry. So just Mr. Wiles, based on what's in and I appreciate calling attention to footnote 33 on this. So is this something that we both allowed in the East Side San Joaquin order and reiterate in this footnote is at the discretion of the regional board to consider when they readopt?
Yes. So just to provide a little bit of context, these were issues, and by the way, I think you said them very articulately, so thank you.
Yeah, I agree.
Better than I did. These are issues that the board struggled with during the Eastern San Joaquin proceedings. And as a result, the Eastern San Joaquin order does, as Ms. Lopez pointed out in footnote 33, identify the areas where the State Water Board explicitly gave discretion to the regional boards to do different things. Mm-hmm. And I think that the most applicable one here is, because we didn't spell it all out in the footnote, in the East San Joaquin order, it says that the regional board may exercise its discretion for growers with a maximum acreage of 20 acres and a crop diversity greater than 0.5 crops per acre. So that's essentially the same as one crop for every 2 acres. If they're more diverse than that, they can start with reporting only A, and the regional board has the opportunity to decide to accept different approaches for estimating R. So I think that's essentially the discretion that Ms. Lopez is looking for in the next version of the Central Coast order.
That and and again, I apologize, this is me getting an on-the-spot education on the ESJ order. Once it was brought to my attention that discretion really applies to the reporting of R, I will just say in my experience, these growers tend to be more challenged in reporting A, or water applied in the manner required by the Central Coast reporting forms. The struggle, because with R, at least you have your sales records to look at. And you probably want to know how, if your bok choy is not selling, you might not plant it next season. So growers at least have maybe some sales records to look to report R, but it's the nitrogen applied and the water applied, where the grower is not necessarily managing to the specific vegetable. And so when you ask them to report that way, they or whoever is helping them really just has to guess. Not that it should always be that way, but that's the reality of the situation.
And that was an issue that was raised. That is why we gave the opportunity to give more time even to start reporting the A. It was with the recognition that there might need to be additional communication, perhaps in multiple languages, about how to calculate the A.
And so we're there now. We're faced with the need to start reporting A, and we are. So I mean, just from experience, we've held a few, like we held a Spanish only workshop, and this is largely folks who are farm workers now moonlighting as farm owners, trying to become farm owners. And so you hold these workshops in the evenings or on weekends because folks can't take off of work. And you spend the whole time, you can do a workshop on how to complete the total nitrogen applied reporting form, but then you realize you need a whole other workshop on just how to back out A from the way folks are managing their field. And yet you've already called people away from their families. You've already spent someone's whole evening just trying to do the basic part of the reporting. And now there's just, nobody has any bandwidth to continue breaking it out with more specificity. I'm really rambling here. I apologize.
Well, just to make sure, because I think obviously we think this is an important issue. We did with Eastside San Joaquin. We do here. I think we would expect, and this is one of the benefits of 2108 process, is as they do the readoption, should be incorporating engagement with EJ and BIPOC communities on the discharger side as well. I think particularly the group that you're talking about that are very small landowners. So it seems like this is something that there's a lot of time to work out. I just want to make sure that there's nothing we need to do here in this order just to carve out enough flexibility for regions to design alternative programs that meet the needs of this group that we already are seeing. My sense is the intent that we have here is to allow for alternative options, recognizing that it's a different situation. And so maybe we can just double check that there's nothing that we're doing here that would limit the Central Coast Board from making a reporting program that would work for this very different context.
Yes, and actually I think there's nothing in the order that purports to take away the discretion that was given in the East San Joaquin order, and I'm certain that's the case. Right. It might be useful just to ask either Matt or Mary to come up and talk a little bit about whether they would be whether they would be interested in taking into account the community concerns, the small disadvantaged grower concerns, et cetera, in using that discretion when they take the order back on remand.
Yeah, or just, I think mostly what because I think we're pretty clear here that we think that's important. And knowing the Central Coast Board, I know that they would want to take that into account, but I think just to, because I know we got a lot to get through here. Does the Central Coast Board feel like there's anything in the East Side San Joaquin or this order that would prevent you from consideration of a alternative reporting program to address this complexity for this particular subset of growers? Is there something that you would need us to clarify in this that would help you, that would enable you to do that?
Thank you for the question, Mary Hamilton, Central Coast Water Board. We, as you can't hear? Closer. We raise it up. Sorry. Thank you, close. As you suspect, we are very interested in figuring out what makes sense for reporting so that we can get at the nitrogen applied and nitrogen removed and what's actually being discharged to groundwater. So that flexibility, as we were reminded, is already in the ESJ as a precedential requirement to allow that flexibility. The question we have is the way we read ESJ is that is only applying to the R reporting, removed reporting. And our question or the clarification we would like to ask is there flexibility in the ESJ precedential requirements for applying that type of flexibility for these smaller growers to nitrogen applied reporting?
And maybe I'll just throw out here, because I feel like maybe there's more thinking to do on this, to give ourselves some time as we keep going through commenters. There's a lot that we're doing. So overall, this whole program, starting with East Side San Joaquin and before East Side San Joaquin with the Central Coast program and many other regions, this is really an evolving area. That's at the core what this is about, right? Is we have a problem, we are working to figure it out, and we're trying to do it in a transparent and really deliberative way. And I think one of the ways that this is evolving is understanding how we work with disadvantaged farmers and small farmers. And so I just wonder if there's a way to, in the same way that we're recognizing that there's sort of this interim piece and learning that's going on, if there's a way to recognize some flexibility within this interim process while we're it's not the same as the expert panel, but while we're learning from how do we best work with small disadvantaged growers, like the situations that you're describing, to get the type of data that is relevant for protecting groundwater in those circumstances. So maybe we can just think about how we might be able to build that learning piece in. And I think this is a great opportunity to be very deliberate about providing some ability to reflect and learn and develop best practices around that for the state and certainly the region. We can think about that.
Just to take that one step further, I think, first of all, I want to correct something I said. I did say that the East San Joaquin allows discretion to not start reporting A. That's incorrect. It says discretion to not start reporting R immediately and how to report R. What we could do, though, is at the end of the day today, maybe we can put our heads together and make a suggestion to the board about whether there's something we can say in the order along the lines of what you just said, Board Member Firestone, about taking, trying not to open up too much the precedential direction the board has already set, but it's a new issue. And I have to say, my memory is more that the concerns were about coming up with R, figuring out what the yield is on a half row by half row, et cetera. Sounds like that's not so much what the issue is that water quality preservation is encountering today. So
yeah, and
I think we'll come back with a proposal.
okay, yeah, and I definitely don't think we should, I don't want to reopen these sites, and Joaquin, I don't want to push back timelines, but I do think, part of what this order, the overall message here in this order is that there are some interim things that we're still learning, like our use of applied when we don't have applied outliers when we don't have R yet, and how we're allowing use of or collection and use of other ways of calculating removed for certain purposes. And so I think in that same vein, like if there's some way that we can carve out, we're still in the process doing these expert panels of updating and reflecting on how best to do that. And maybe we can add this component as one of the things we're still learning on for that interim period without kind of reopening the whole issue or timelines.
Appreciate that, board member. Vice Chair.
I just wanted to say I'm very much open, but at the same time, a little concerned because with this coming up at this late point in the process. And so just as you think through different ways to address this issue, I would also include that if there's a challenge, and there is with this smaller growers, especially where there's language barriers, the anecdote to that is more education and more education targeted with appropriate language services. And so, that might be one way to deal with it in terms of, do we really need to open it up in terms of applied, or do we pose some direction to the regional boards to be looking at this challenge through additional education? Because it sounds like Preservation Inc. is trying to grapple with this already. And so, perhaps through some additional work with the regional boards, if you have someone that appears to be an outlier, I don't see any big harm that they receive additional education services.
So I think what I heard from is that we're not really trying to solve this problem here and in this order, that we just want to make sure that we provide some flexibility to address things like mixed vegetables on small farms with language barriers without creating an incentive for a 1,000-acre farm to put in a row of lettuce in their field to say it's mixed vegetables that now doesn't have to reply. So I think we want to talk amongst ourselves about a way to provide that flexibility without opening a too big a can of worms.
Yeah, I appreciate that. Again, for me, the reality is that the Eastern San Joaquin does need here a refresh. We are a number of years in. There are a number of issues that are advancing and that we need to get to. The question is, how do we go about that process? And regrettably today, we're going to hear a lot around how we can improve the policy writ large, but we're trying to keep this contained. So I think it's a balance there, and I appreciate the discussion around it. And thank you, Ms. Lopez, again, for your very direct work in helping to execute and make this all implementable.
Thank you very much.
Thank you as well. Let's move on to the Community Water Center and a number of commenters we have. I want to get through this tranche of Spanish-speaking commenters, especially because folks have taken so much time, and then take a break. We do need a break here amongst us to keep us fresh and keep us engaged. And so I'd like to call up Kaya Rivers from the Community Water Center, and who will start to kick us off in this tranche of folks, and also Mayra as well, who I believe will be doing translation for the Spanish speakers in Community Water Center.
Going to go after.
Okay, I appreciate that then. Apologies, Kaya. I didn't see you were going to be at the end of the list of folks. Okay. Then I'd first like to call up and Appreciate everyone. Ileana, to come up first. I believe it's Ileana Miranda. Thank you.
Good afternoon, Chair Esquivel, board members. Really appreciate my time here today with you guys. My name is Ileana Miranda. I am currently serving as an advisory group member for the SAFER group. I have been a resident of San Gerardo Cooperative for 8 years. And about 1.5 years ago, I started working for San Gerardo as their general manager. As you've heard before, San Gerardo is a beautiful community that is surrounded by agricultural fields. And as you've also heard today, we've had 3 on-site wells become contaminated with nitrates and other contaminants. A new water well was drilled about 2 miles away from the property, but we continue to live in fear of our water becoming contaminated again. Although our water is safe to drink at the moment, many of our residents don't trust it and continue to purchase bottled water to drink and cook with. I'm urging the Water Board to help us protect this vital resource, not only for San Gerardo community and the Central Coast, but the entire state of California. We want our residents to be healthy and to live and not to live in fear of all these invisible poisons. I am currently expecting my 3rd child, and I am concerned of all the possible illnesses and birth defects linked to nitrate contamination. Please strengthen Ag 4.0. The proposed timeline for reducing nitrate applications, it should be shortened from 2051 to at least 2041. It is not fair to my children and future generations to keep fighting the same battles we are today. We need long-term solutions to really help protect our groundwater. Thank you for your time.
Thank you, Ms. Miranda, for being here and for your service on the SAFER committee and advocacy for your community. It means a lot for you to be here. Thank you. Next, I hope I have my list here correct, but I'd like to start to go through some of our Spanish speakers and would first call up Miguel Estrada. Fabian Estrada, listed here as Miguel, unfortunately. Apologies. Okay. If there's been, okay, I'll go up, apologies everyone. I'll go off my list here instead of the printed list of names sent. And so I'd like to call Fabian Flores, please. Thank you. Sorry, apologies.
Hello to everybody. Just want to let you guys know that I've been living in San Gerardo practically all my life and pretty much surrounded with frequently manicured landscape that is high in nitrate and can drift through our groundwater. The nitrates application has become an issue with our water. The nitrate is a threat to the human health. The biggest risk for nitrate is to those who are living, working, and attending schools near these large fields that apply nitrates. This affects the people, our children are especially vulnerable to this given that they are young and still developing. Really appreciate it if we could have a change soon. Thank you.
Thank you very much. Next, I'd like to call up Aldo Ortega.
Good afternoon, ladies and gentlemen. Okay, my name is Aldo Arteaga. I lived in San Gerardo since 1979 when it first opened. My family and I have experienced health issues, and it's mainly due to poor water quality, like skin rashes, allergies, et cetera, basically all health issues. And the stress from these issues have been mentally, it's taken a mental toll, in other words, because we're afraid of what's going to happen in the future if the nitrates keep on going up. We don't drink the water, the tap water. even though it's in a safe level. But we just had so many issues in the past with the water being so contaminated that we're just spending money on water bottles and, bottled water. So it's not a very good long-term solution. There's a lot of money spent. We've already been struggling with these issues, like I mentioned earlier, for a long time. And for better, I wish that the address of nitrate should be changed from 2051 to 2041 for different generations, not just the seniors, not just the middle ages, but especially for the children. We're calling for stronger testing and stronger accountability of agricultural companies. Water is life. Water is very essential, especially drinkable water that's not contaminated. Thank you for your time and listening to our experiences, listening to our concerns. Thank you.
More importantly, thank you for yours, Mr. Ortega, and for your time here, and importantly, for your voice amongst all this discussion. It's really critical, and I really appreciate it. Thank you. Next, I'd like to call up Maria Medina, and believe we'll have translation service. Thank you, Myra.
Tardes. Mi nombre es María Medina. Yo soy residente de San Gerardo. Tengo 25 años viviendo ahí. Y pues nuestras preocupaciones son pues los nitratos, los pesticidas que tenemos pues ahí, que nosotros vivimos alrededor. Hemos pasado por muchas enfermedades en nuestras familias, y ahí en San Gerardo que hemos visto personas que han pasado por cáncer. Mi hermana tiene un niño especial que tiene ya 21 años. Pensamos que también fue a causa de eso. Yo sufro de roncha, de asma, de alergias, y pues más que nada queremos pues un buen futuro para nuestros niños que vienen atrás de nosotros, que tomen un agua saludable, sin nitratos ni pesticidas, que vivan una vida mejor para ellos. Muchísimas gracias.
Gracias a ti también.
So, I'm Justine Massey. I'm supporting with translation. Maria says, good evening. My name is Maria Medina. I'm a resident of San Gerardo Cooperative, and I've lived there for 25 years. We've been suffering because of nitrates and pesticides. We're very concerned about this because it's contaminating the water. We've experienced so much sickness because of these nitrates and pesticides. As an example, my sister has a child who's special needs, and we ask ourselves whether that might not be a result of the water. I've also personally experienced rashes and asthma. We want a better future for the generations that are coming. We want health and want to be able to drink the water. Thank you for your time.
Thank you for providing the translation. Next, I'd like to call up Juan Medina.
Buenas tardes, mi nombre es Juan Medina y he vivido en la comunidad de San Gerardo por más de 25 años. Nosotros ya hemos pasado por una situación de agua contaminada por nitratos y pesticidas. Pasamos por mucho estrés y varias enfermedades. Queremos proteger nuestro recurso de agua potable. Sabemos que hay una línea de tiempo para el 2051, pero es mucho tiempo. Queremos algo más a corto plazo y pensamos que el 2041 es más considerable. y así poder dejar un recurso confiable a nuestras futuras generaciones. Muchas gracias.
Gracias a ti también.
So, good evening. My name is Juan Medina. I've lived in the community of San Gerardo for more than 25 years. We have already gone through a situation with our contaminated water full of nitrates and pesticides, and this has caused a lot of stress and various illnesses. We want to protect our resource of drinkable water, and we know that there's a proposed timeline for 2051, but that is a very long time. We want something that comes sooner. We think that 2041 is a more reasonable time for this to happen. And by doing that, we can leave a reliable resource for the future generations. Thank you.
Thank you again. Next, I'd like to call up Rafael Coronel.
Mi nombre es Rafael Coronel y vivo en San Gerardo por 38 años. Hemos tenido el problema del agua contaminada y a diario siempre, pues cualquier enfermedad surge. Cuando nos bañamos, pues hay anormalidades en el cuerpo. Y llega uno de trabajar a tomar agua porque a veces hay embotellada y a veces no hay. Tenemos que tomar de ahí porque nos agarra lejos el agua embotellada. Otra cosa, tenemos muchas pesticidas por el viento y por abajo. Realmente estamos en medio de la muerte, se puede decir, porque hay contaminación por los pesticidas y hay contaminación por los nitratos. Entonces es preocupante y queremos que tomen pues cartas en el asunto, todos, porque pues yo ya estoy mayor de edad, pero vienen mis hijos, mis nietos, y no quiero verlos así. Yo ya voy de salida, como se puede decir, pero no quería no verlos sufriendo, porque han muerto de cáncer ahí en nuestra comunidad. Y como se ve, pues toman mucho tiempo la mesa para decidir. Yo pienso que deben recortar más. Gracias.
Gracias a ti, señor Coronel, para tu voz y por tu voz y tiempo aquí. Gracias.
Hi, my name is Eric, and I'm going to be translating for Mr. Rafael Coronel. So Mr. Coronel shared, good afternoon. My name is Rafael. I have lived in San Gerardo for 38 years, where we've had contaminated water. When we shower, there's abnormalities on our bodies. And he shared that he comes home from work and sometimes has to drink water from the tap because the bottled water is far away and often a challenge to access. He shared that they live close to pesticides and that they're close to death because of the pesticides and nitrates that are applied nearby their communities. He wants the board to take into consideration the conditions and the realities that they live in. He shared that he's older and on his way out, but he doesn't want to see his children and the next generation suffer. He shared that they have seen people in our community suffer from cancer, and that he would like to see a change happen.
Thank you for providing that translation. Next, I'd like to call up Santiago Villegas.
Santiago has asked me to read his statement because of his asthma. Creo que tengo aquí.
Okay, gracias.
Yeah. You can let me know if it's appropriate for me to then translate in English or if you have the alternate service.
If you're going to, for those that are online, there is an interpreter. So, but for here in the room,
I'll translate afterward. Okay, thank you.
Thank you.
Hola, buenas tardes. Mi nombre es Santiago Villegas y vengo representando a la comunidad de San Gerardo. Yo he vivido aquí desde 1988. Yo trabajo en la agricultura toda mi vida y me he dado cuenta de todo lo que echan y ahora lo estoy viviendo en carne propia, las consecuencias de todos los químicos que se aplican y luego contaminan nuestra agua. Debido a eso, yo tengo problemas de salud como asma y a mis hijos que han crecido con agua contaminada también les ha afectado. Se necesitan límites lo más pronto posible. No podemos continuar así. No solo me afecta a mí, sino a mis hijos y nietos que viven en donde el problema existe. La fecha límite que existe ahorita para el 1051 no es justa porque nuestras comunidades, para nuestras comunidades, ya que es demasiado tiempo y durante los siguientes 28 años, los niveles de nitrato seguirán incrementando si no se hace algo al respecto ahora. Una fecha justa sería 2041, así ambas partes se beneficiarían de esto. Alrededor de nuestra comunidad, los rancheros causan el agua contaminada por donde quiera y nadie controla lo que están haciendo. Esa agua contaminada con nitrato y pesticidas luego se va a nuestro pozo y ese es el temor que tenemos, de que nuestra agua se contamine de nuevo debido a que no hayan controles ni límites. No se puede vivir de agua embotellada, no es justo que paguemos doble por agua. No queremos que se quiten los incentivos para fertilizantes orgánicos, porque a la hora de utilizar los fertilizantes orgánicos no se contamina tanto nuestro suelo. Ustedes tienen la oportunidad de ayudarnos y evitar la contaminación del agua con nitratos. Se lo pido por favor que ayuden a nuestras comunidades y si no nos creen, los invito a nuestra comunidad a ver la realidad en la que vivimos. Muchas gracias. So I'll do my best to capture this in English. Hello, good afternoon. My name is Santiago Villegas, and I'm here representing the community of San Gerardo. I've lived here since 1988, and I have worked in agriculture all of my life. And I've noticed all that they've applied to the earth, and now I'm living it in my own skin, the consequences of all of the chemicals that have been applied and that have then contaminated our water. Due to this, I have health problems such as asthma, and my children also, who have grown up with the contaminated water, have also been affected. We need limits as soon as possible. We can't continue this way. It doesn't just affect me, but also my children, my grandchildren that live in the area where this problem exists. The timeline that exists now for 2051 is not fair for our communities. It's too much time, and during that time, during the next 28 years, the levels of nitrate will continue to increase if we don't do something about it now. A fair date would be 2041, which would allow all parties to benefit. Around our community, the farmers and ranchers have caused contaminated water wherever they please, and no one controls what they're doing. That contaminated water with nitrate and pesticides then gets into our well. And this is the fear that we have, that our water will become contaminated again due to the lack of controls and limits. You can't live off of bottled water. It's not fair either for us to pay double for water. We also don't want the incentives to be removed for organic fertilizers or organic processes because using those organic techniques doesn't contaminate the soil as much. You all have the opportunity to help us and to avoid further contamination of our water with nitrate. We ask you please to help our communities And if you don't believe what we're saying, I invite you to our community to see the reality in which we're living. Thank you.
Thank you both. Next, I'd like to call up Rosa Carrillo.
Buenas tardes a todos. Mi nombre es Rosa Carrillo y vivo en la comunidad de San Gerardo ya por 11 años y el año pasado comencé a trabajar en la administración. Hoy estoy aquí frente a ustedes, no solamente por mí y mi familia, sino en representación de todos los ancianos de nuestra comunidad, los cuales no pueden estar hoy aquí para hacer escuchar su voz, de los cuales su salud fue afectada por causa del agua contaminada, por los nitratos que han sido aplicados en exceso por los agricultores y rancheros. Ahora no solo ellos enfrentan varios problemas de salud, sino también una inestabilidad financiera, ya que ahora ellos solo se sustentan por su pensión, la cual es muy reducida. Y ellos tienen que limitarse en muchas cosas para así ellos poder pagar sus cuentas de agua, la cual ahora tiene una cuota mensual de $72 por cargos de uso. Y también para poder comprar agua embotellada, ya que aún tienen el temor de consumir el agua en las tuberías. En la comunidad, aún la cual es sana para el consumo en estos momentos, por lo que ellos pasaron en el pasado con la contaminación de los pozos, y es el temor que todos tenemos de que se vuelva a contaminar. Por esta razón es que estamos aquí pidiéndoles que impongan más regulaciones en la aplicación de los nitratos y que acorten el tiempo para que los rancheros cumplan con esas regulaciones, las cuales estamos pidiendo. Gracias por el tiempo que ustedes hacen hoy para escuchar nuestras preocupaciones en este tema tan sensible para todos nosotros. De nuevo, muchas gracias.
Muchas gracias a ti por tu tiempo y vos también. Gracias.
I'm Mayra with Community Water Center. So Rosa just said, hello, my name is Rosa Carrillo. I live in the community of San Gerardo. I've been living there for 11 years. And about a year ago, I started working in the co-op's administration. And I'm here today with you all, not just for myself, but my family, or not just for myself and my family, but also representing the elderly folks that live in our community, which couldn't be here today to share their story, which many have had health effects due to the water contamination from nitrates, which have been applied in excess by farmers and ranchers. Now, not only do they suffer from health problems, but also financial instability due to the fact that they live off their pension, which is not much, and they are limited with many things due to the fact that they have to pay their water bill, which currently has a monthly fee of $72 just for the meter. And also, you know, the fact that they have to buy bottled water because they still fear drinking tap water. In the community, even though it is or it has safe drinking water currently. But this fear comes from their past experience with contaminated wells, and they fear that it may happen again. So for that reason, we are here asking you to implement more regulations with nitrate application and to shorten the timeline for farmers to comply with these regulations, which we are asking for. Thank you for the time you're taking today to listen to us, to listen to our concerns about this sensitive subject for our community. Thank you.
Thank you for providing that translation. Thank you so much. Next, I'd like to call up Valentin Cornejo.
Buenas tardes, gracias por escucharnos. Mi nombre es Valentín Cornejo, vengo de la comunidad de Royal Oaks Community, condado de Monterrey. La razón que nos encontramos aquí es para que seamos escuchados de nuestros problemas, ya que los niveles de nuestra agua potable es demasiado alta en nitrógeno. Sabemos que los problemas vienen de varios factores, que son fertilizantes agrícolas, fosas sépticas y estiércol de animales. Posiblemente las sequías de varios años. Yo sé que todos los factores no se pueden evitar, pero sí controlar. Amo la agricultura por la razón que toda mi vida he vivido de ella, por más de 50 años. Por eso digo que sí se puede tener control, ya que los pesticidas se reportan cada mes. Igual se puede con los fertilizantes, aunque no se hable español, se pueden hacer los reportes. ¿O cuál es la razón de que no haya control? Necesitamos límites que nos protejan. Gracias.
Gracias, señor, por tu voz y participación en esta discusión.
So, good afternoon, everyone. My name is Valentin Correjo, and I come from the community of Royal Oaks in Monterey County. And the reason we are here today is because we want you all to listen to the problems that we face, because our drinking water has high levels of nitrate. We know that this problem is due to many factors, which are the use of fertilizers from agriculture, septic tanks, animal manure, and possibly the many years of drought. And I know that all of these factors can't be eliminated, but they can be controlled. I love agriculture because I lived off of agriculture all of my life, and it can be controlled. Hold on, let's see. And that's why I'm saying that there can be control. Currently, pesticides have to be reported monthly. And so the same can be done with fertilizers, even if you only speak Spanish. That's not a limitation. And with that, he asks for better control and protective limits. And thank you.
Thank you for providing that translation. Next, I'd like to call up Jesus Calvillo.
So Chair, Jesus Calvillo wasn't able to come in person because he was feeling a little ill today, but we do have him on the phone.
Perfect, thank you.
All right. ¿Me escucha, Jesús?
Sí.
Ok, ya está.
Sí, buenas tardes. Hola. Mi nombre es Jesús Calvillo y vengo representando la comunidad de Royal Oak en el condado de Monterrey. Y por la razón que venimos queremos llevar lo mejor posible, ser agua potable, porque tenemos muchos contaminantes que dañan nuestra salud, como el cromo, el cobre, los nitratos. La principal razón por la que estamos aquí es porque necesitamos agua saludable. Queremos que haya control de lo que se aplica en la agricultura. He sido agricultor durante toda mi vida por 45 años. Estoy de acuerdo con que haya un control porque yo siempre he utilizado coberturas orgánicas y sí es posible producir buenas cosechas sin necesidad de utilizar demasiados químicos que al final dañan nuestra salud, nuestra agua y hasta las cosechas. No estoy de acuerdo con que dejen de contaminar agua embotellada en las comunidades afectadas. Porque nuestro ambiente y salud son los que pagan las consecuencias. No podemos vivir con agua embotellada toda nuestra vida. Los límites son buenos, y más si de esto depende nuestro futuro y nuestra salud. Muchas gracias. Que tengan un buen día.
Gracias, señor Calvillo.
Gracias, a ver. Ahorita le hablo para atrás. All right. So the translation there is, hello, my name is Jesus Calvillo. I'm here representing the community of Royal Oaks in the Monterey County. And we would like for you all to do the best that you can do to provide safe water, because we have many contaminants that affect our health, like lead, chrome, and nitrate. We would like to see, or the main reason we're here is because we need safe water. We would like to see better control of what's being applied in agriculture. I have been involved with agriculture all my life, over 45 years, and I am in favor of there being better control, because I have used organic cover crops, and it's possible to produce good crops without the necessity to apply too many chemicals, which in the end affect our water, our health, and even the crops themselves. I don't agree with the fact that you will let ag continue to pollute our water, just with the simple fact that they will be providing additional water sources like bottled water to the communities that are affected, because it affects our environment and our health, and we are paying with our environment and our health. So we can't live with bottled water every day. So limits are good. And they're good because that's what our future depends on. Thank you.
Thank you so much. Really appreciate providing translation here. Next, I'd like to call up Oscar Barreto, and I believe then Kaya Rivers, rounding out Community Water Center panel.
Hi, thank you for having me here. I'd like to thank the board for listening to our opinions and our concerns. My name is Oscar Barreto. I'm here not only for myself, but to speak on behalf of many of the Spanish-speaking community, members of the Royal Oaks, who are being affected by the high levels of nitrates in their well water. We live in California, one of the most attractive states. Here locally, we are known for agricultural. We provide the community with fresh carrots, lettuce, berries, and beautiful flowers. These people that work on these farms are some of the most vulnerable due to the language barrier. These same people work long hours, in difficult circumstances, a job not many of us would do. These same people are the ones being directly affected by the high nitrates in our drinking water. As many of us know, high nitrates levels can affect us in the following ways. Blue baby syndrome, a potentially fatal disease, birth defects, thyroid disease caused by nitrates blocking the uptake of iodine, nausea, diarrhea, vomiting, dizziness, blurred vision, and breathing problems, and eventually muscle paralysis. Skin turning bluish or gray color, weaknesses, excess heart rate, fatigue, and dizziness. We're talking about innocent children or babies possibly dying or being born with birth defects. We must care. We must do whatever we can to resolve this issue. I am here asking you to care by having protective limits to reduce nitrates in our drinking water and protect our communities to provide a simple life necessity of clean drinking water. Thank you.
Thank you, Mr. Barreto. Really appreciate you traveling out here and raising the voice of the community and participating in this discussion. Thank you. Next, I'd like to call up Kaya Rivers. It's good to see you. Good afternoon.
Good afternoon. Good to see you. Nice to see everyone. I believe that we have short slides. We have a petition signed by communities, our residents from the communities on the Central Coast, So next slide, please. We have Kelly Hutton from Moss Landing reading the petition. Thank you.
Hello, my name is Kelly Hutton. I'm a resident of Moss Landing, California, and I'm going to be reading a letter on behalf of the Central Coast community. Dear Chair Esquivel and State Water Board members, we, the undersigned community members across the Central Coast region, ask you to guarantee the revised Ag Order 4.0 prevents further contamination to our drinking water sources. Though we support some aspects of the State Board's draft proposed order, like monitoring for 123 TCP, many of the board's proposed reversals are detrimental to our community's access to safe drinking water. Because of our long history of enduring nitrate contamination, we have been put at risk for negative health impacts for years. The State Board's proposed order makes it increasingly more difficult to make the change we need in order to have access to safe drinking water. Consuming nitrate contaminated drinking water can cause serious health impacts. Short-term exposure to nitrate contamination can cause the blue baby syndrome, which can be fatal. Additionally, short-term exposure can also cause stillbirths, spontaneous abortions, and sudden infant death syndrome. Chronic exposure to nitrate contamination increases risk of hypotension, premature births, and certain cancers. All of these health impacts are heightened due to the fact that nitrate contamination in drinking water can only be detected with a well test, and our communities may not know their water is contaminated. We are concerned about how the removal of enforced application and discharge limits will impact our groundwater basins and ultimately our drinking water. Without enforceable limits, growers will be able to further contaminate our drinking water sources without any repercussions. Some communities who are burdened with contaminated water have been working for many years towards long-term solutions, which would finally provide safe and sustainable drinking water for the future. However, with the removal of enforceable limits, these long-term solutions will be at risk of contamination again. The removal of enforceable limits puts families and communities at health risks. Furthermore, we ask the State Water Board to reduce the timeline in which growers must stop polluting groundwater. The current timeline unjustifiably allows for further contamination of our drinking water and violates our human rights to water. Allowing for further nitrate contamination puts our communities at risk to exposure to nitrate contamination and the many health impacts that may arise because of the contamination. The proposed compliance timeline would burden future generations with unsafe drinking water, and our human right to water must be actualized in the shortest time frame possible. It is concerning that the State Board has proposed to extend the already prolonged compliance timeline if growers provide alternate water sources. We need both a shorter timeline and for growers to provide short-term and long-term drinking water solutions. Our communities should not have to choose between drinking water solutions and groundwater free of nitrate contamination. We urge the State Water Board to revise their draft proposal in order to ensure that Ag Order 4.0 adequately prevents further contamination of our drinking water and provides the necessary drinking water solutions to our communities until we have water that is safe to drink. Sincerely, the community members of the Central Coast. Thank you.
And then we have a copy of the petition on the next slide, as well as following it, signatures of residents from the communities. Thank you for sharing that. Kelly really wanted to be here today, but couldn't make it up. But good afternoon again. My name is Kai Rivers. I'm a policy advocate at Community Water Center. And communities on the Central Coast do not have access to safe drinking water. And because of this, I echo and I emphasize my community members and colleagues' concerns about the potential changes made to Ag Order 4.0. Communities of color are disproportionately burdened by unsafe drinking water. Because of chronic nitrate contamination, communities are forced to rely on interim solutions for indefinite amounts of time, along with a swift compliance timeline with enforceable limits on fertilizer and nitrate discharge. Impacted communities need an adequate alternative drinking water program. Drinking water programs already exist under CV salts and the Salinas Basin Agricultural Group. However, many residents unknowingly exposed to nitrate contamination fall through the cracks and aren't provided with the just safe drinking water that they need. To put things into perspective, under CV salts, only about 13% of the 13,000 estimated nitrate contaminated wells within the 5 management zones have been tested. And since the Salinas Valley Bottled Water Program started in 2019, only 17 water systems and 17 domestic wells belonging to disadvantaged communities receive bottled water. While we don't have an estimate, it is very unlikely that that is a significant portion of impacted wells on the Central Coast. Knowing this, we urge the proposed order direct dischargers to contribute funds funded by fertilizer fees into SAFER, and have a community-based organization adequately implement the alternative water program. Additionally, proposing that already long compliance timelines be extended when growers provide alternative drinking water is unacceptable. Providing communities with drinking water solutions does not and should not further delay growers' abilities to reduce their nitrate discharges. The state board has a duty to uphold the human right to water. And we ask the state board to include a human right to water and racial equity analysis, and to make the necessary changes to the proposed order to ensure communities have the safe drinking water solutions they need until groundwater basins are restored as soon as possible. Thank you for your time, and we hope the board will protect drinking water today. Thank you.
Thank you, Ms. Rivers. Appreciate the engagement both here and obviously at the regional board, and importantly, organizing voices within the community to come in and engage in this process and this discussion with us here. It means an incredible amount and difference here within our discussion. And so just thank you for that. Anything board members want to comment or leave question on? Let's take a break, give ourselves a refresher, and come in back in about 12 minutes at 3:40. And we'll continue on. We still have, let me take a quick glance, about roughly 20 commenters to still go through. So probably a little plus. And so we'll continue on. So thank you, everyone. We'll come back here at 2:40 after a nice break. Okay, everyone, it is 3:45. A few extra minutes and appreciated that. We'll get back to here our list of commenters. Next, I would actually like to go, I know we have a number of scientists that are not on a panel, but are sort of self-organized a bit around here. So I'd like to go to them and would call up Richard Smith, who would then be followed by Michael Kahn and then Eric Brennan. And we may be waiting for folks to come back in the room, so we'll see if they're actually here currently.
Okay.
Yes, it looks like Richard Smith at least is here on Zoom.
Yeah, okay. Well, thank you.
Have you?
Yeah, thank you, Chairman Esquivel, and to all the board members. And I want to, well, you know, a lot of people have already talked about the uniqueness of the Central Coast area and of the agriculture and just how intensive it is. And that's a problem because you know, the double cropping or triple cropping, you know, it creates opportunities for inefficiency in nitrogen application. But then also the cities are all dependent on groundwater. And really, since the early 1990s, the university has been engaged in research looking at trying to help growers be more efficient in their use of nitrogen or in scavenging nitrogen. And the USDA folks have also been involved, the NRCS and the Natural Resources Conservation Service, the Resource Conservation District. So all these, we've all been working together as a very nice team addressing this problem. And next slide. So what I want to do, just look at the yellow highlighted verbiage on these slides, is lay out the year, the production cycle. And it really starts during the fallow period, you know, during the winter, when typically nothing is growing out there. And what we see is that that's actually a little bit of a tricky time to manage nitrogen because the conditions are really not under our control. You know, we're subject to heavy rain, which can leach nitrates down. And so this practice of using cover crops and getting that into growers' practices is a really useful technique as much as they can because of the economic constraints, but it is very, very helpful. And so we were, you know, disappointed in the remand of that technique. Next slide. And then also during the winter, a lot of times compost is applied, but you know, not all the nitrogen that's in compost is becomes available. You know, it all goes back to the C/N ratio, and maybe only 5 or maybe 10% of the nitrogen contained in compost might become available as nitrate, which is the form of nitrogen that we're concerned with. So that's the techniques that we proposed for the winter fallow period. Next slide. And then as we get into the production season, you know, and what I've laid out here is, you know, 2 crops, you know, might be lettuce, broccoli, or broccoli lettuce, or, you know, whatever the grower's rotation is. But one of the techniques that we've worked on for many, many years is using a nitrogen quick test to help the growers know how much nitrogen is in the soil, and then they can adjust their fertilizer practices accordingly. And that can help them be more efficient in the use of applied fertilizer. And then they can finish out the season without such high levels of nitrate in the soil. And in organic production, this is the other thing, and I think that the new remand letter took this into account, that the organic materials break down at a certain rate. And again, all of this is in the letter that I provided and with the references to this research. And so, for instance, a material like 442, which is commonly used by growers, it may only release 50 to 60% of the nitrogen as nitrate, and then the rest of it stays in the system as an organic form, which is not subject to leaching. And then just one little thing, I put an asterisk there. These denitrification beds is a very good practice that was developed here, and some growers are beginning to use that. And but that was remanded, and I think that needs to be reconsidered. And then just the last slide. You know, and then at the end of the season, the nitrogen-rich residues get incorporated in the soil, and then that's where you build up that high nitrate in the soil. And so this starts the whole cycle again, where we would like to have a cover crop in there to take up that nitrogen. And then the final slide. You know, this these remanded practices, I think these practices that were remanded really give a very important insight, more precise insight into the level of nitrate. And just one final comment is that the expert panel, I think, should take, like Tim Burrell mentioned, they should take all of these things into consideration, and that they should also, I would recommend that you guys make that a much more streamlined process, so that it's not such a clunky thing where where you have to remand the practices of a regional board because you didn't have an expert panel that looked at these practices, because if they do, they're going to approve them. So that's all I'll say. Thank you for your attention.
And thank you for yours, Mr. Smith, and the contributions to all of this work. As I said at the top, it is very much a cutting edge and ultimately exciting, the discussions and understanding of the complexity of these systems that we're all managing, that we're able to have here, and do our best to make sure that our regulatory programs are reflective of that. And your participation and contributions to that are incredibly appreciated for that. So thank you.
Thank you.
Next, I'd like to call, thank you. Next, I'd like to call Michael Kahn, who'll be followed by Eric Brennan.
Good afternoon, Chairman and board members. Hopefully you can hear me okay.
We can. Good afternoon.
Yeah, thank you. I think I have some slides also to show. Yeah, so the main message is that, first, let me introduce myself. I'm a farm advisor practicing with UC Cooperative Extension for more than 20 years on the Central Coast, based out of Salinas. I work on the Central Coast, and my specialty is irrigation, nutrient management, water resource management. And I've worked with the Central Coast Regional Water Quality Control Board over the years in as they've drafted regulations, and they've been very good at listening to the science. And I would say that, you know, as you adjust Ag Order 4.0, it needs to be crafted to encourage growers to implement best management practices, many of which Richard has just outlined, that will reduce the loading of nitrogen to the aquifer. Next slide. So both on the A and the R side of the A minus R equation, we have practices that help reduce the loading. And these were outlined by Richard, like the soil nitrate testing using the quick test, which can account for mineral N in the soil that might already be there, crediting nitrate in your irrigation water, because many of our wells have high nitrate levels, or we use recycled water, improving irrigation management, and the use of organic amendments, such as compost, organic fertilizer, that have a slower release of N. And then on the R side, winter cover crops are very important in sequestering nitrogen that's built up into the soil in the fall and keeping them from leaching during winter storms. And then denitrification bioreactors have been well proven and can be optimized to take all the nitrate out of effluent from tile drains. And the use of high carbon amendments, although it's still a little experimental, it does show a lot of promise and also in sequestering nitrogen that would be high in the soil. Next slide, please. So this equation that was proposed in the Ag Order 4.0 is more complex than was in the East San Joaquin order. But it allows a lot of flexibility in helping growers and encouraging them to use these management practices, which are expensive, not only in cost for the grower, but also trying to figure out how to implement it in a very complicated farming system. Next slide. And one of the unique problems we have on the Central Coast is we are growing many vegetable crops one after another. We only harvest a portion of the crop and we leave a lot of residue behind. And in that residue, we have a lot of nitrogen. And so just one lettuce crop might leave 40 or 60 pounds of N per acre behind. Next slide. And so the soil nitrate quick test has been a way that growers have been able to identify when their field has high mineral N in the soil and they can reduce their fertilizer amounts. And many grower operations have really embraced this tool and are trying to implement this on as many fields as possible. But it is a cost for them. Next slide. And then, as I mentioned, we have well water or irrigation water that's high in nitrogen. And so this is something we want to encourage growers to take credit for so they can reduce their fertilizer applications, but also they're removing nitrate from our groundwater. And we've had to add some flexibility in how this is calculated. Next slide. So for vegetable growers, if they had to account for all the nitrogen in the water they applied, a portion of that nitrogen they really can't manage because a portion of the water they put on to start a vegetable crop is at the time when the crop's not taking up much water or much nitrogen. So that's the establishment period when we're germinating up the crop. And so for vegetable growers, they have the option to use the volume of water equal to the evapotranspiration of the crop. So that would be the amount of water the crop uses after establishment, really, for that calculation. But for crops that are already established, like vineyards or tree crops, where growers usually apply less than evapotranspiration, then they can use the applied water volume. So just adding that flexibility helps encourage growers to better manage that nitrogen in the irrigation water. And finally, water management is really critical for using N efficiently. The next slide. And one of the tools that growers need to use, you can change the next slide, is the CIMMYS weather stations. And this is a network of stations operated by the Department of Water Resources throughout the state. But on the Central Coast, we have a lot of holes in this system because of the land costs. And they have to be sited on well-watered grass with a large fetch. And the land is just too expensive to site these stations. And so there needs to be more work to be more flexible so we can have more of these stations and more evapotranspiration data available, not only for water management, but also for the reporting that we have to do for the ag order. And that's all my comments. Thank you.
Thank you, Mr. Khan. I was going to ask Mr. Smith or yourself, when it comes to the science and the ability to really translate a number of the activities that we're talking about, cover crops, or the desire here from the region to create other incentives here for activities that ultimately reduce nitrate. That's what we're trying to do. How comfortable are we around being able to numerically translate those, like making those implementable around our work. And I know here the order is structured to allow an expert panel to really provide that basis and flesh that out, but just trying to get a sense from you how ripe, I guess, is that work, because it is promising and it is important, and it's a balance here, as we hear, even with just the applied and removed ratios and work is sometimes not as easy to incorporate or see, seeing as how we're still trying to get that component done. So yeah, just wondering if there's kind of reflection on what you've seen insofar as science and the ability to translate that science into numeric values here in the regulatory side that continue to drive us to the outcomes we're wanting.
Yeah, that's a very good question. And I don't want to take Eric Brennan's thunder, but I think we have really good ideas of, you just measure how much nitrogen is in the cover crop, and then that's how much the R scavenge value would be. And then that's incorporated in the spring. So then it starts to mineralize and becomes available for the spring crop. And so that mineralization process is something that we need more research on. And I think the expert panel will definitely hit upon that. They will probably have to grapple with it, because it's not as that part, how much does it becomes available is not, that's a little trickier to answer precisely, but in my opinion, it doesn't matter, because you're measuring the nitrates in the spring. Like Mike said, use a nitrate quick test, and that tells you how much nitrogen is becoming available from the mineralization of the cover crop or prior crop residues or whatever. So that's kind of my thoughts on that.
Really appreciate that, Mr. Smith. And maybe that's a good segue for Mr. Eric Brennan here then. And Mr. Brennan, yeah, you should be invited to unmute.
Okay.
There we are.
Good morning or good afternoon, I should say, and thank you for giving me the chance to present here.
Thank you as well.
Yeah, it's a real pleasure to be able to speak to the board. I'm going to share my ideas on how cover crops can help us to solve the nitrogen pollution problem in ground and surface water in the Central Coast region. I've been doing research here on cover crops for more than 20 years, and in both organic and climate smart systems. And I would say that in April 2021, the whole region entered a new era of sustainability. And the reason that happened was because of the passage of Ag Order 4.0. Next slide, please. Can you switch? There we go. Thank you. So this was historic because for the first time, farmers in the region were given incentives for using best management practices like cover crops. And there were also limits placed on the amount of nitrogen discharge that was allowed. Next slide, please. So over the next few minutes, I'm going to talk about these three things: straws, sponges, and speed limits, and how they can help us think about the value of cover crops as scavengers and problem solvers in these systems with nitrogen excesses. Next slide, please. So you might be wondering, what does a speed limit have to do with the Ag Order? Next slide. Hopefully when you go home today and you're driving, you think about this. So I like to think of the Ag Order as a speed limit. It's a speed limit that slows the movement of nitrogen from our systems down into the aquifers. It's also a speed limit that helps us to make our nitrogen use much, much more efficient. And that can help us to reduce our greenhouse gas emissions in both organic and conventional systems. Next slide, please. So here's a picture of a field, one of my research fields where we're growing broccoli. When we grow broccoli, we use lots and lots of nitrogen. And like Michael Kahn, my colleague, said, a lot of the nitrogen in a crop like this is left over after the harvest because only a small portion of that is taken out of the field. Next slide. Thank you. And so the challenge is when a field is left bare fallow, which is unfortunately what often happens in the Salinas Valley, often for good reasons, because of the complexity of using things like cover crops. But the challenge with this is that when this happens, we have large amounts of nitrogen leaching from these bare fallowed fields. And that's really what creates the problem of nitrate contamination in our groundwater. It's a big part of it. It's not the only part of it, but it's a huge part of it. Bare fallow fields over the winter are really challenging. Okay, next slide, please. And this is where cover crops can help. They can come to the rescue. Next slide. And the reason is that the science is so clear on this issue, and it has been for decades, that cover crops, non-legume cover crops like rye or mustard, they can reduce nitrate leaching by huge amounts, you know, somewhere upwards of say 70% or so. That's a huge reduction in leaching. Next slide, please. So I'm going to talk a little bit about now sponges. So, and I brought a little sample here. This is just a sponge, but I want you to think about this when you go home and you're washing dishes or something. Basically, a cover crop is like a sponge that can soak up water. And then when we incorporate that cover crop back into the soil, that nitrogen in the water in the cover crop tissue is released back in the following spring, and it allows us to make very efficient use of our nitrogen. Next slide. Same thing with straws. This is a cover crop straw here. Cover crop straws, they can hold nitrogen, and then when we incorporate that straw back into the soil the next spring, it releases it back into our systems. Okay, next slide, please. So here's the challenge. For farmers to get a fair credit, not a one-size-fits-all credit, which I would consider a measly carrot, but a nice, juicy, generous, fair credit, they have to get, we have to have limits, because I don't actually see any way to have limits or to have fair credits without having limits in those systems. Okay, next slide, please. When the ag order passed, there was a huge increase in cover cropping in our region. And this is extremely exciting. If these cover crop nitrogen scavenging credits are taken away, we're going to take several steps backward in the momentum that's building, and that will really slow the movement towards more sustainable systems, whether they be organic or conventional, and also the movement towards protecting the groundwater. Next slide, please. So in conclusion, I hope that you keep these three things in mind: straws, sponges, and speed limits, and how I wish there was a way to get fair credits for growing cover crops without having speed limits, but I don't see any way to do it, to do that without having those limits in there. I hit on many other issues in my letter, which I'll be happy to talk about if you want to, but this is basically all that I wanted to share right now. So thank you very much again for your attention. I'd be happy to answer any questions you might have.
Thank you for your participation and contributions here, Mr. Brennan. Looking to fellow board colleagues in case there are any questions for the scientists amongst us right now. Hearing none, just thank you so much, truly. Next then, I'd like to call up Asan Tusi, who will be followed by Charles Delgado. And I'm not sure if Mr. Tusi is available. Okay.
Yes.
All right. Thank you. Sorry about that. Good to have you here, Mr. Tusi.
Sure. Let me just. Okay. Good afternoon, everyone, and thanks for giving us the time to comment. I was disconnected for a period of time. Just got back now. So just to introduce myself, my name is Ehsan Tusi. I'm a researcher at True Organic Products. I'm here on behalf of my colleague, Rami Kalfer, who couldn't make it today, but he has put a short presentation together, which I can present it, I can share screen, but I understand that we have a copy of his presentation, and if you could play that.
Yes, thank you, Mr. Tusi. That should be coming up here momentarily. Great, thank you.
I'm with True Organic Products with Ehsan Tusi, and we thank you for enabling us to do a presentation today for the State Water Board. True Organic Products is the largest organic fertilizer manufacturer in the United States, and we supply organic fertilizer to a wide range of companies on the West Coast. Today, I'd like to talk to you about specific topics. Some key topics are organic fertilizer requires many farming practices that are in line with State Water Board environmental goals and should be encouraged. State Water Board is proposing to treat all nitrogen applied equal. This does not reflect our current understanding of nitrogen and soil science. Synthetic mineral nitrogen is not equal to organic nitrogen. Use of C to N ratios and scientifically based mineralization rates allows different organic amendments to be treated differently than synthetic/mineral nitrogen. Organic farming and organic amendments should be promoted by the State Water Board due to the benefits to the environment in line with other California state agencies. And lastly, new developments in nitrogen management need to be taken into consideration by the next expert panel. California has a growing organic farming sector that's a large percentage of the overall farming production in California, and this is especially true in the California Central Coast. Organic farming has rules and requirements that are in line with State Water Board goals and to minimize environmental pollutions. Looking at the difference between conventional/mineralization, mineral nitrogen versus organic nitrogen, what we see is that mineral nitrogen is 100% plant available and more likely to leach, where organic nitrogen comes with lots of different carbon, is composed, is embedded in protein form, and needs to be broken down by soil microbial activity before it becomes plant available. And only a fraction of the nitrogen in these amendments becomes available. For compost, it's somewhere between 0 and 35%, and for organic fertilizer, somewhere between 40 and 60% for most. Treating synthetic and organic nitrogen the same would disproportionately penalize organic farming if A/R is regulated in the future. One example of how organic nitrogen differs than synthetic or mineral nitrogen is looking at soil organic matter, where there's a high amount of organic nitrogen in the soil that is quite stable and not prone to mineralize or leach. Only about 1.5% of organic nitrogen mineralizes per year. Last couple years ago, UC Davis did a study looking at a range of different organic amendments and nitrogen mineralization rates, which is critical for solving the nitrogen mineralization problem the State Board is facing. They looked at a range of different organic amendments from yard waste compost to manure-based compost to organic fertilizers, both in liquid and dry form. And they found that there's a tight relationship between carbon to nitrogen ratio and predicted nitrogen mineralization rates. Taking this information, putting it in table format, one could add a factor or organic fertilizer or organic amendment discount factor to pathway 1 using the A/R format. In the yellow is the common range of mineralization rates for organic fertilizers, and the arrows show where a compost generally lies. For the fate of nitrogen that does not mineralize in the first 80 days, UC Davis scientists believe it behaves like organic nitrogen found in soil organic matter. Studies have shown that this organic nitrogen stays in the soil for long term and is not prone to leach. Organic amendments also come with a large amount of carbon, which is very critical for building up soil organic matter, which has many benefits to crop systems and well as reducing pollution. Other state agents such as CDFA and CARB are promoting organic amendment use and as well as organic farming, and so should the state board. And we thank you for letting us make a comment.
Thank you, Mr. Colfer. And Mr. Tusi, anything further add?
No, but thanks again. And if there is any question and if we have time, I'm happy to answer.
Really appreciate that. Thank you, Mr. Tusi. I appreciate, again, you and Mr. Colfer's contributions here. Look forward to further discussion around it. Looking to see, and I believe the Vice Chair has a question.
I just wanted to say real quickly, in case the experts here are going to be taking off. I just want to thank you for your input. This is really interesting. It's exciting to see how things have evolved, not just in the ag order world and some of the ideas that are out there, but specifically on the science. And as we've said, the appropriate place for this is the expert panel. And so I think we're all really looking forward to the opportunity to dive in real deep on these issues. So thank you so much.
You're here. Thank you, Vice Chair. And thank you again, Mr. Tusi, and again, our expert panelists here. Next, I'd like to call up Elliot Grant, or Charles Delgado, who will be followed by Elliot Grant. Good to see you. You may need to turn the microphone back on. Yeah, thank you.
Apparently it's been too long. Good to see everyone. So good afternoon, Chair Esquivel and members of the board. My name is Charles Delgado, Policy Director for Sustainable Conservation. We're an environmental nonprofit organization with a track record of seeking policy solutions and incentivize responsible agricultural processes that protect water supply and quality. So I'm here today to provide our comments along the lines of cover cropping, and mostly you've heard from the scientists. We're going to speak more from the regulatory aspect of this. So firstly, while we might not necessarily have wished for the timeline to see these incentives move forward in the regulatory sphere, we also understand that there's definitely a need for a permit that ultimately can be approved by the state water boards. So we don't have any specific comments on the remand order itself, but we absolutely understand the mechanisms and the need for that kind of review. So just in the spirit of respecting the science, mostly, again, you've heard from the experts in this field, and we'll just reiterate and echo, their input and say that the science is clearly established that these practices really do achieve measurable benefits in reducing nitrate contamination. This principle was recognized in the original iteration of Ag Order 4.0, and I'd like to thank the regional board for their leadership on that. And it's resulted in a number of growers and agricultural advocates pursuing these practices, as was mentioned by our prior speakers. We're already seeing adoption and positive results, but this is the beginning, and we really do need greater adoption of these practices. The more we see people pursuing these practices, the more water quality benefits we're ultimately going to see, and that's really the end goal of these actions. So we do request, and this goes along with previous comments that have been throughout the day, that the State Water Board and the Central Coast Regional Water Board work together during the forthcoming revision process of the order to ensure that whatever new permit is drawn up does include these practices and credits for them to further incentivize cover cropping. The data that we've been seeing along with the folks that just spoke continues to confirm that these are having positive impacts And that in the course of revising this order, the vice chair referred to the expert panel. We do agree that this is really a good venue to address this. That as part of that expert panel process, that we solicit the expertise of cover cropping practitioners to best guide how to evaluate the impacts of nitrate scavenging practices, such as cover cropping and some of the other ones that have been mentioned. We just note that the original presidential order from 2018 can be interpreted in certain quarters to encourage a formula that strictly accounts for a measurement of nitrogen applied, such as fertilizers, versus nitrogen removed through harvested materials. Again, as has been gone into by other speakers, this doesn't really tell the entire story of what happens when nitrogen is applied to a field, enters the soil, and makes its way out of the root zone and down toward groundwater. So this complex interaction is already recognized in existing regulatory mechanisms. This is present in the Central Valley's ILRP, groundwater protection formulas and values as part of the CV SWAT tool. Without necessarily speaking to the specific nature of CV SWAT, we do recommend as a possible alternative to be considered by the expert panel as this process ramps up. The evaluation of a tool in the same spirit as CV SWAT that recognizes these values and provides a mechanism to account for the benefits of these practices. Again, without specifically necessarily endorsing that mechanism in particular. The existing version of Ag Order 4.0 has already encouraged the adoption of cover cropping practices that can achieve not only beneficial water quality outcomes in the Central Coast, but also many healthy soil co-benefits. So developing a version of this permit that preserves some sort of mechanism recognizing the nitrogen removed by cover cropping and high carbon soil amendments that can ultimately be adopted by the State Water Board would really add further momentum and increased uptake for these responsible practices that benefit farmers, the community, and the environment. And that's a point that I really want to stress here today, given all the input that we received both from agricultural community, from community members, and environmental advocates. Solutions such as these are really win-win-win. And as we work through some of the larger issues that are going to be covered as part of the remand process and the expert panel, these kinds of solutions where everybody benefits, I think these are extremely important to prioritize. And I'd also like to give some credit to the State Board in the revised version of the order we're considering today. I think that's been recognized by staff and the board. So I really commend the folks working on this. I think that we're all moving in the right direction on that. So just I think that the revisions to what we're considering today have been really beneficial. So I'll close that and say that we welcome any questions regarding the issue that the board may have at this time. With me today to assist on any of those is Elliot Grant, our Central Coast Project Manager. And thank you for the time.
Thank you. Appreciate those good comments and good to see you. Next, I think we can go to Lowell Zielinski.
Okay, I'm here. Can everybody hear me?
We can.
Okay, I've got some slides. I just like to start with the first slide. So obviously these are going to be my comments to the State Board about the Ag Order 4.0. And listening to most of the previous speakers, I'm going to be quite a bit different than what I've heard. Anyway, let's go to the next slide. A little bit about me. I own a consulting company in Paso Robles, but I work primarily in the Salinas Valley. I have a PhD from Davis in soil science, and though I'm old, it wasn't 1975 when I got it, it was 1995. So, and I was a member of the 2015 expert panel that we referred to in previous comments about irrigation and nutrient management. So, okay, next slide. A little caveat, I did prepare this presentation prior to the release of the revised version. So it's going to be a little dated, but not too bad. I wanted to comment on, I guess there were 13 areas that the State Board addressed, and there were 4 that I wanted to comment on. And basically talking as a scientist, not as a policymaker or things like that. I do have this one additional comment I wanted to make. It was under the expert panel section. And you said, or the proposed new order talked about the collection of total nitrogen applied for 8 years. Well, this is kind of true, but it's primarily limited to a certain number of crops, and those are primarily vegetables. So for crops that didn't have a TNA reporting requirement, we don't have that 8 years worth of information. We only have, well, actually 2023 will be the first year that all crops are required to report the amount of nitrogen applied. So like I say, don't think that we've got all this good data that a new expert panel could use. And again, it's limited to vegetables primarily. So, okay, next slide. So modification of the nitrogen applied minus nitrogen removed, the difference values. And there's 3 compliance pathways, which I think most of us are aware of. And additionally, Preservation Inc. is working on a third-party alternative pathway, but it hasn't been approved yet. So there will potentially be 4, but currently there are 3. Each of the 3 involve a discount factor for organic fertilizers and the use of compost. I don't agree that there should be a discount factor. And I agree with the state's finding that the use of the discount factor should not be allowed. And I say that again as a scientist because nitrate in the soil and the groundwater and in plants and being taken up, it doesn't know, the plants don't know where it came from. It has to be in a form like nitrate or ammonia. And even if it's applied as decomposition of a cover crop or organic fertilizers, it still has to be converted into nitrate or ammonia to be taken up by the plant. So next slide. Okay, the lack of the use of the A-R ratios. This is something we talked about in the first expert panel quite a bit and thought it was a very good metric for identifying outliers in nitrogen fertilization. And it'll make the Central Coast reporting consistent with other regions and subregions, like I think the state board has pointed out. If we want to be able to compare different areas of the state, we have to have them all doing the same thing, more or less. And it's not an onerous task to utilize this metric because we are already going to be collecting A-R, that A and R values. Keep in mind, again, that there are groundwater phase protection areas, and there are 3 different levels in the Central Coast, and only the phase 1 areas, which isn't really that much, has to report and nitrogen removed in 2023 for 2023. A lot of the phase 2 areas and phase 3 areas, it's going to be 2025 and 2027 before those areas need to report the removal values. And the next slide. Enforceable limits on nitrogen applied. I don't think they should exist. They don't address the potential threat to water quality. And I think they're reasonable numbers, but I don't think that's what will work well in helping us determine whether too much fertilizer is applied and how much leaching is going on. And additionally, and this one drives me crazy, that those limits in nitrogen applied only apply to commercial fertilizers. You can apply as much inorganic fertilizers as you want, and you don't even have to worry about these enforceable limits. And the next slide. Okay, so this is the enforceable limits on the A-R differences. The like was mentioned in a previous talk too, they talk about targets and limits, and we have the first 2 years we have targets, and then after a while they start going into limits, which means that you can't exceed a certain difference value. It's inconsistent with the presidential East San Joaquin order, and my opinion really quickly, it'll decimate agriculture on the Central Coast, because when you get down to the 50 pounds in 2050, there aren't many crops that can do that. And so it's going to hurt the farmers, but it will also hurt a lot of the non-farming population throughout California, because a lot of the farms or the property is owned by landowners who are not involved in the actual farming operations. So, and finally, the next slide. Thank you. And are there any questions? That's it.
Thank you, Dr. Zielinski. I appreciate your comments here and your participation, certainly in all of this work. No comments from me currently, and unseen from the dais. So just thank you incredibly. Next, I'd like to call up Brent Burchett, who'll be followed by John Swenseed. And Mr. Burkett may not be on the platform, or he may be.
I'm here, Mr. Chair.
Oh, there you are. There you are. We can see you. We can hear you. Good afternoon. Good evening, nearly.
Good evening, sir, and board. My name is Brent Burchett, and I serve as the Executive Director of the San Luis Obispo County Farm Bureau. Thank you for the opportunity to comment today on behalf of our farm and ranch families in San Luis Obispo County. We also thank you for giving time to earlier today to Sarah Lopez and Preservation Inc. to discuss just a few of the real challenges our smaller growers and our socially disadvantaged growers experience trying to comply with the ag order's very, as you've heard, complex reporting requirements. We appreciate the extensive work done on this issue for many years by our ag petitioner partners, and we support the comments they submitted to your board earlier in August 11, 2023. I know they spoke already in great detail on the proposed order, so I will be brief and close by just reiterating one point. SLO County Farm Bureau supports the proposed order's remand to the Central Coast Water Board with direction to eliminate enforceable limits for nitrogen applied and limits based on the amount of nitrogen applied minus removed. Chair, that concludes my comments. Thank you for the time.
Thank you, Mr. Burchett. Appreciate your participation and comments here and the work around all this. Thank you. Next, I'd like to call up John Swenseed.
Mr. Swenseed had to leave around 3, and he asked me to deliver his comments, if that's okay.
Yes, thank you. Thank you for doing that.
My name is John Swenseed. I live in Carmel. I am here as a resident of the Central Coast concerned about our water quality. I support farmers and a right to farm and to determine what to grow and how to do that. But I do not believe that there is a right to pollute. There's no right to harm other people's drinking water and no right to harm our pristine coastal waters. You've already heard much testimony about the harms of this pollution. Farmers and the ag community can be great keepers of the environment. Their work helps eliminate greenhouse gases, and they employ a lot of people. We need what they grow, and of course, we all love to eat. But we do not need or want nitrate pollution. Please stop nitrate pollution. It is very detrimental, as you've heard. To help prevent this pollution, my ask is that the recommendations in the 2021 Central Coast Ag Order that provide enforceable and enforced limits on nitrate pollution be allowed to go into effect. I support all of Monterey Waterkeeper's comments to this board. Thank you for this opportunity to comment.
Thank you, Mr. Appreciate you presenting that for Mr. Swenseed. Next, I'd like to call up Dana Groot and marked as speak if necessary, but Adam Lapitz. And see Mr. Groot on the platform. Okay, that works. And Mr. Lapitz said he doesn't need to speak, and so we can go next to then Valerie Milano, who also was noted as speak as necessary, if necessary, that is. Okay, thank you. Not on the platform. And so we'll move then to Chris Schutz.
Good afternoon, Chair Esquivel and members of the board. Chris Schutz, Executive Director of the California Sport Fishing Protection Alliance, or CSPA. I will speak today about enforceability and about the applicability of the draft order to AB 2108. I'm here today because Bill Jennings, CSPA's Executive Director for 17 years, died late last year. Bill spent the better part of 3 decades advocating for enforceable standards for agricultural waste discharge requirements and for individual accountability by dischargers. Over the last 9 months, I've been sorting through Bill's paper documents so that at least some of his legacy work on water quality will be archived at the University of the Pacific. The amount of documentation Bill generated and otherwise assembled on agricultural waste discharge issues is staggering. Throughout all the proceedings and litigation, the themes of enforceability and accountability shine most brightly. If Bill were here today, he would ask you, "What are you doing?" Though he might put it less politely. You're taking an enforceable standard relating to nitrogen pollution on the Central Coast and eliminating it because it's not perfect or might be somewhat unfair to growers. In what world does that make sense? There's no defense for eliminating an enforceable water quality standard for application of nitrogen because application does not correlate directly to the level of nitrogen contamination of groundwater. If a better standard is indeed required or possible, the reasonable response is to maintain an enforceable standard while showing demonstrable progress in developing a better standard. And let the growers in the development of those standards have the burden of proof to demonstrate that there are circumstances that warrant modification or limitation of the use of application of nitrogen as a standard, and what those modifications or limitations might be. The same principles apply to enforceable discharge limits. This board is walking away on so many fronts from regulation and toward voluntary compliance with everything. Leaving aside the legal issues, doing that in the world of water quality is bad policy. Under the draft order, nitrogen application is to be used only for education purposes. The regional board may collect information, but it can't use that information in any regulatory fashion. Let's talk for a minute about the effects on disadvantaged communities covered under AB 2108 of 2022. The revised draft order says at footnote 12, we are not engaging in the permitting process or issuing or reissuing waste discharge requirements. The footnote promises that an AB 2108 analysis will be forthcoming when the regional board adopts new requirements. Let's be clear. It's this board that is eliminating the only immediately enforceable requirements for the Central Coast region relating to groundwater pollution by nitrogen, the nitrogen applied and discharge requirements. Because you are not saying today what you are going to put in their place does not mean that you are not responsible for that foundational change. It is a de facto issuance of new waste discharge requirements to say that the regional board's requirements do not apply. It is also, as we've heard today, precedential to say that the board's policy in the future is going to be to eliminate or indefinitely hold in abeyance water quality standards when they are not perfect or simply when they need improvement. That doesn't simply redound to East San Joaquin. It is a decision you are giving practical effect today if you adopt this order. That approach is going to have broad effects on the disadvantaged communities that AB 2108 seeks to protect. You need to own those effects. In sum, I ask you on behalf of Bill Jennings and the California Sport Fishing Protection Alliance to revise the revised draft order to maintain enforceable nitrogen applied requirements and discharge limits while the regional board develops new standards, and to direct the regional board on remand to develop enforceable standards for the pollution of groundwater and surface waters by nitrogen. Thank you very much for the opportunity to speak.
And thank you, Mr. Schutz, for speaking and contributing to this, for your advocacy and work and continued contributions, and for bringing the memory to us here of Mr. Jennings and the connection to all this in his work. So thank you. Next, I'd like to call up Emily Gottlieb.
Hi, good afternoon to the chair and members of the board. My name is Emily Gottlieb. I am a Monterey County resident. I'm a new mom. I'm an ecologist, environmental educator, and I also frequently recreate on the Salinas River. I'm here to voice my support for all of the recommendations made today to the board by Monterey Waterkeeper and others to include enforceable limits to the nitrate application and discharge in Agricultural Order 4.0. I'm really proud to live in a place that's so culturally diverse and ecologically rich and agriculturally productive as well. But I'm concerned about nitrate contamination in drinking water for my family, which comes from the groundwater, and for other families in Monterey County too, particularly those who live and work in the agricultural communities of Salinas Valley and South Monterey County, and for families elsewhere in the Central Coast. Enforceable limits on nitrate application and discharge will compel farm managers in our area to continue seeking and adopting innovative growing methods with help from experts, methods such as no-till farming complemented with cover crops, all which could improve soil's nitrogen retention and water quality benefits, plus having added benefits of carbon sequestration without compromising crops. I'd also like to voice my support for the inclusion of mandatory riparian and wetland setbacks of 100 feet or more in this order, particularly along the Salinas River, which is lined by farmland. Healthy riparian habitats there will continue providing valuable ecosystem services, for example, plants that naturally fix nitrogen in their root systems. And these ecosystems will ensure that the river can continue to be a thriving wilderness corridor. So in conclusion, I'm strongly in support of the recommendations proposed by the Monterey Waterkeeper, and particularly the expedited timeline that they proposed to achieve the order's objectives by 2041. I hope that by the time my son turns 18, the agricultural industry in the Central Coast will be thriving without threatening the quality of his drinking water.
Thank you so much, Ms. Gottlieb. Appreciate your contributions and work here today and voice. It means a lot. Thank you. Next, I'd like to call up Barbara Tadeo, which I'm not sure the contact information here is with Community Water Center, so I hope it wasn't someone that we've accidentally left off. But not seeing Ms. Tadeo on the platform or in the room. So we'll go next then to Elias Rodriguez.
Good afternoon, Chair Esquivel, members of the board. My name is Elias Rodriguez. I am a staff attorney with the California Rural Legal Assistance, or CRLA, and I make these comments on behalf of the Comité de Salinas. The Comité is a small group of residents in the Salinas Valley. The Salinas Valley is primarily known for its many Latino farm worker communities. It's also a community known for its agricultural dominance, where in Monterey County alone, the industry makes over $2 billion in annual profits. And these profits are mostly derived from the backbreaking work of primarily Latino farm workers. The agricultural dominance in the Salinas Valley brings with it a degradation of environmental resources. And unsurprisingly, the degradation of these resources has led to disproportionate impact being borne by these Latino farm worker communities. So in my comments, I'd like to make 4 points. First, I'd like to show you the data on ag order findings and how communities of color are disproportionately impacted by nitrate contamination. I ask your attention to the screen in my first slide. This table and photo represent the subbasins that the Central Coast Water Board has designated as groundwater phase 1 areas in its waste discharge order, or the subbasins with the most nitrate contamination and highest priority of the regional board. Those are the darkest areas in the right map. It's the same table, just split by community in the table. As you can see, In these groundwater phase 1 areas, the percentage of Latino residents is over 50%, and in some cases is over 80%. As you can see in the Forebay Aquifer as well as the Upper Valley Aquifer, there's large concentrations of Latino residents. On the next slide, this table represents the amount of on-farm domestic wells exceeding the state's contaminant level for nitrates and is sourced from ag order findings as well. In the areas with the highest level of contamination, and thank you, Chelsea, for the earlier correction on the record, the areas with the highest contamination, the Latino population increases. For instance, in the Forebay and East Side Subbasin, in Greenfield, Salinas, and Gonzales, there are large concentrations of Latino residents, whereas in lower concentrations of on-farm domestic wells exceeding the state maximum contaminant level, there are large, predominantly white populations. This is an environmental injustice. And so in my second point, because of the disparate nature of nitrate contamination, any proposed changes to Ag 4.0 may have a disproportionate impact on communities of color. And as a result, the board must analyze how their proposed changes will impact these residents. However, in its revised proposed order, board staff attempt to evade its responsibility under AB 2108, which requires the board to make EJ and other findings for issuances and reissuances of waste discharge requirements. Board staff concede that if AB 2108 had been in place in 2018, the board would have had to comply with AB 2108 in its adoption of the East San Joaquin order. Board staff assert that because the board's order is more modest and does not provide precedential direction nor make amendments to the regional board's order, that this order is not equivalent and is not under the purview of AB 2108. But this argument is unsupported for two reasons. First, the proposed order does provide precedential direction and directs the regional board to amend Ag 4.0 in ways that go beyond the precedential aspects of the ESJ order. For example, the proposed order removes enforceable limits by referring to a section of the ESJ order that does not claim to be precedential. Additionally, the board asks the regional board to amend Ag 4.0 by creating a region-wide water supply program equivalent to CV salts. And second, as you heard from Mr. Bothwell, AB 2108 does not distinguish between whether issuances and reissuances are modest or substantial. The letter of the law protects communities disproportionately impacted by board decisions based on whether or not the decision is an issuance or a reissuance of a waste discharge requirement, not on whether it's a substantial or modest order. My third point is that regardless of the letter of the law, in AB 2108, the spirit of the law and the spirit of the board's previous commendable actions support the Comite's request that the board conduct a disparate impact analysis in this order. For example, the board's adoption of a racial equity resolution condemning racism and racial injustice, and the board's direction to board staff to create a racial equity plan support the board applying a racial equity lens to all water board decision-making processes. Additionally, in its human right to water resolution, the board committed to considering a human right to water in all activities that affected drinking water. So it is incumbent upon both you board members and your staff to live up to these resolutions and goals. My final point is that state and federal anti-discrimination laws prohibit state agencies and programs with state and federal funding from issuing regulations that result in a disparate impact. And as demonstrated by the data up on the screen from Ag 4.0 and its findings, Latino residents are disproportionately impacted by nitrate contamination. And these residents may also be disproportionately impacted by the board's proposed changes to Ag 4.0. So the board has a duty to analyze and prevent such impacts. Thus, on behalf of the Comité de Salinas, we urge you to conduct an analysis on how the changes the board proposes in Ag 4.0 will impact tribal communities, environmental justice communities, and communities of color. And we also request you direct the regional board to make programmatic findings on all changes in the Ag 4.0, not just those diverging from the ESJ order. If the board is serious about condemning racism, if the board is serious about racially just decisions, and if the board is not in the business of splitting hairs on racial injustice, We ask that you do the difficult work of implementing AB 2108's provisions that provide data and analysis needed to address these issues. Thank you.
Thank you, Mr. Rodriguez. Next, I'd like to call up Nathaniel Kane, and will be followed by Tess Dunham and then Uriel Mendoza. Apologies, Mr. Kane. You should be invited to unmute here momentarily.
Good. Can you hear me?
We can now. Good evening.
Okay,
You
great.
cut off for a moment. You scared us. Good to see you.
Sure. Yeah, it took me a
Or
second
hear from you.
to get off mute. Good afternoon, Chair Esquivel and members of the board. My name is Nathaniel Kane, and I'm here speaking on behalf of Environmental Law Foundation. We've been involved in advocating for an ag order that protects clean water for the benefit of disadvantaged communities and the environment since about 2014. And I'm not here to mince words today. I am speaking in opposition to this draft order. It ignores evidence in the record and clear legal precedent in order to remove well-supported numeric limits on pollution in violation of the non-point source policy and other applicable law with significant impacts on disadvantaged communities and the environment. This order comes to you with specific requirements that will begin to address nitrogen pollution starting later this year. Based on the record in front of this board, Ag Order 4.0 requires application limits set at the 90th percentile grower, going down to the 85th percentile grower in a couple of years. There is no question that these limits are achievable. By definition, 85 to 90% of growers are already meeting these limits. So we're talking about the worst actors here. And the studies in the record show that this level of application is far more than crops need. So we're not just talking about ceasing all pollution today, nor are we talking about an industry-shaking regulation. We're talking about ending the practices of the very worst outliers within a lengthy and gradual phase-in of stricter requirements and continual iteration and continual evaluation over time. Importantly, the Central Coast Board bases these limits on evidence. There is evidence in the record that those limits will reduce nitrogen pollution, including where wells are at risk of exceedances that haven't occurred yet. There's evidence that they are achievable by industry, and perhaps most importantly, there's evidence that other approaches have not worked. 10 years of reporting nitrogen applied data have not resulted in reduced application. 10 years of education, of telling industry that their practices are poisoning wells and polluting the environment, informing them about best practices, none of it has improved water quality. But staff here is proposing stripping out even the minimal requirements of Ag Order 4.0 based on a cramped and legalistic interpretation of its precedent in the 2018 ESJ order. The word precedent applies to similar facts, but Ag Order 4.0 is an order that is based on a different factual record in a different part of the state with different hydrology, different crops, and a far more developed factual record than what existed in 2018. And staff wants to do exactly what the Court of Appeal told this board not to do in 2018 in the Monterey Coastkeeper case. And that is effectively amend the non-point source policy by adding a new procedural step, an expert panel, before requiring polluters to stop polluting. Now, I want to be clear, an expert panel is not a bad idea. It's good that the proposed order directs review of the highly problematic Central Valley groundwater protection targets. But this board has been sitting on this petition for 2 years. It could have convened an expert panel upon receipt. It could also keep the initial level of targets and limits in place while the expert panel meets and then later direct revisions based on the expert panel's report in a few years. This expert panel procedure has no timeline for completion. So this is not a short delay. This is an undefined delay, and this follows years of delay in the nitrate space. And the decision to delete the enforceable application limits simply ignores evidence in the record that the growers can reduce application, that the reductions will have an effect, that doing so will shorten restoration time, will help prevent surface water impacts, and will help keep more wells from exceeding the MCL. Instead, this proposed order does what 25 years of this state board policy has done on nitrate, which is make disadvantaged communities wait to bear all of the risk and see none of the benefits. This board adopted a racial equity resolution a few years ago. Today, it is rejecting the request for supplemental evidence submitted by the communities that it has claimed to listen to. It is refusing to take achievable, scientifically supported steps towards remedying one of the great failures of environmental justice in this state and indeed in this country. The only references to the racial equity resolution and the human right to water in the draft order are in the context of remanding this to the Central Coast Board to simply confirm a decision that this board has already made for it. It's at risk by taking this action of turning that racial equity resolution into the kind of empty promise that we see all too often. So I urge this board to reject the staff proposed order, to order the establishment of limits on pollution in compliance with applicable law and in compliance with this board's own promises. Thank you.
Thank you, Mr. Kane. Greatly appreciate your voice and contributions to all of this. Ms. Testano, and we followed by Uriel
Sorry.
Mendoza and then Heather Billing. Please, yes.
Can I ask staff a question
Board
before?
Member Firestone, please.
Thanks. So just to follow up on one of the issues that not just mentioned and also other folks have, I can maybe Jonathan Bishop or somebody from staff speak a little bit to the timeline in terms of the expert panel review. I know what we're saying is that we are asking for a review of the data in no less than 1 year, I believe. And there's been a request that or a review if there's adequate data to convene an expert panel. But I think we all recognize that there are a lot of things that are teed up here that's why we've gone through. So we've committed to a public process on what questions we're going to ask the expert panel and the types of expertise that we would want represented. Is there a way that to ensure that we're reflecting the urgency and need on this, that we can be doing those simultaneously? I guess to me, they're obviously related, but if we could find ways to expedite this process and narrow in on, really the questions that we're trying to address, that could also help narrow in on what data we need to answer them, because we're clarifying which questions they are. So just, can you speak to what's realistic?
Yeah, I can't tell you what the exact timing is. But I can commit that we can do the process in parallel. They do intersect with each other, and that the final questions to the panel will have to be refined once we've actually had the ability to review the data. But some of the questions we already know, or at least we think we know, and we can start working on those and put them out and get feedback on them. We have a number of issues that we heard today from the scientists. We have a number of issues about that we already signaled in the order itself that we're going to do. So I don't see any reason to delay the start of the process of the questions until we've reviewed the data. And I do want to say that you guys can blame me for this idea because I don't want to commit to you at a board meeting that we will start, we will send the data to the expert panel when we haven't had the opportunity to actually compile it and look at it. And so my hope is that we can convene the panel early based on the data we have from the East San Joaquin. We will not have the same level of data from the Central Coast, but we won't have that for many years. So I don't think that's a good reason to delay. And we have one cycle, and we'll have another cycle coming up this coming year from the East San Joaquin order, which I'm hopeful will provide us enough information. But until we look at it, I can't commit to that. But I can commit that we can start the process about the questions and expedite the looking at the data. And I can tell you, without even submitting it, one thing that the expert panel will tell us is you need more data, because they always say that. But we can push on, do we have enough information to indicate direction? I agree totally with Nat that we need to be moving forward and making decisions on the information we have, and refining that over time. We're looking at long time frames in whatever we do. There's no reason for us to wait until everything's perfect. We're never going to get it perfect. So yes, that's a long answer to your question, but I think that yes, we will be doing that, and we will be reporting back to the board periodically on our progress and on the working with our different stakeholder groups to ensure that the panel makeup and the questions reflect the concerns of both the environmental justice communities, the communities that have been impacted, and the agricultural communities.
Thank you, Mr. Bishop. Thank you, board member. Next, I'd like to call up Tess Dunham, who will be followed by Uriel Mendoza, and then Heather Billing.
Thank you. Tess Dunham with Conservation and Conway. Up here currently on behalf of the Central Valley 13 coalitions who have spent considerable time since 2018 and the adoption of the order, developing groundwater protection formulas, values, and targets. And more than happy at some point to provide updates and presentations on those issues to you all based upon the effort that has been put into that. Primarily, my reason for getting up here today, it actually goes to a little bit of some of the discussion earlier today, and I call out footnote 85. In footnote 85, which was added with the revisions on September 8th, it has been noted that it is this board's intent, if you adopt it as is with the footnote, to grant a request submitted by several environmental justice organizations to have the groundwater protection targets described in Order 2018-002 and recently conditionally approved by the Central Valley Water Board reviewed either by the expert panel or through a separate independent review process. Unfortunately, the 13 coalitions were not engaged with respect to this discussion as far as the potential review of the targets by this board. So there has been no opportunity for them to provide input. And other than the fact that I was involved in this process by my hat that I wore earlier today, would not have been aware of it. So I think it goes a little bit to the process that we're dropping in a footnote that has significant, could have some significant impact to the Central Valley program and investments by those coalitions, very significant investments in time and a public process that happened there that gets dropped in here. So I am concerned about that footnote. I would prefer that it was removed. I don't know what this board's intent is with respect to the groundwater protection targets. A petition was filed, but it's sitting there. So I just think it's maybe what
Hi, everyone. Apologies for those that are online here. We're having technical difficulties in the room. We're trying to get our microphones back and are resetting the system. So we'll take a 10-minute break and we will be back at 5:15. Thanks, everyone.
Hi, everyone. Apologies. We're still continuing to manage some technical issues. We're giving ourselves another 10 minutes, and so we will be back here at 5:25. And again, appreciate everyone's patience as we look to close out this discussion and item here. Thank you.
Testing 1, 2, testing 1, 2. Mic check 1, 2, testing 1, 2.
Okay, everyone, I believe we're back up. Appreciate everyone's patience and thank everyone for the good, quick technical work to get us back on board here. Ms. Dunham, we had dramatically just, paused in the middle of all your comment here. So I'll let you try to pick up. You'll need to turn the mic back on, unfortunately, on the top there. There's a button right on top. Thanks.
Well, I think it was very fortuitous because I probably was rambling and I needed to be done. And so I will just close and say, I think you heard the gist of my arguments and my comments, and unless there's any questions, I will move on.
Not rambling in the least, and apologies again for this interruption.
No
and just
worries.
looking to see if there's any board members with question or comment. Vice Chair.
Yeah, Board Member Firestone and I were having a little sidebar on this. So maybe you could if you could take a moment to remind us.
Yes.
So we're talking about the San Joaquin Order groundwater protection targets in high vulnerability areas based on township. So
Correct.
Maybe just help to put this in context, which as to potential expert panel review or some other process.
Yes. So, we have gone through that process and we developed the formula, went through a public process, and then we did targets, which is kind of what's happening on the landscape today. And then we developed targets, and we've used a modeling approach that includes a couple of different models, and I won't get into the technical details. That was conditionally approved by the executive officer for the Central Valley Water Board, June 30th, somewhere around there, give or take a day or two. So that process is completed for now. Now they have to be updated every 5 years, right? So that it is a ongoing issue and process. And I think there's, questions about the modeling and which we have to address as part of a work plan for our next update, which will be within 5 years, right? So it's always going to be an iterative process. We are open to having conversations with anybody and everybody about the targets and the development of them, and we have and we will, and more than willing to do that. And if that's part of the conversation with the expert panel, that is fine too. I just thought it was odd that there is a footnote dropped into the Central Coast Order about the groundwater protection targets, saying that we, the State Water Board, intend to review them, and without first getting input from those that developed them and others about that, because there was a I mean, I saw the comment in the environmental justice comment letter, basically saying, we hope you, and then at least include review of the groundwater protection targets in the expert panel. And I just think it's unfortunate because that's not really an issue that was before the board, and it was bringing in a side issue.
And just building on that, because I don't, so I don't think it's a side issue. I think it's very much actually exactly getting at the issue that we're looking for the expert panel's input on, is how do we think about metrics for water quality protection for MAG? And I'm just wondering if you can, and I also will just say my understanding, and we sidebarred with Phil a bit, and so happy to tweak the wording to clarify this, but I think this is really a signaling that these are both teed up, very related, and part of the point at time we're in right now to understand what are the right metrics to be setting for agricultural nitrate discharge for groundwater protection. So that's the intent, I think, of the is that signaling. But I agree with you, like anything that we actually do on this would need to be this isn't the right forum to just announce everything on that, but it is a forum where, many of the same people are here. It's on the same topic that we're looking at this issue, and it's good to be signaling now, not have that be a surprise.
And I think there's two different ways to look at it, though. Is if you're talking about it in the metric construct, I think I understand that, but there's been, I can't remember probably how it was put, but I mean, there's been a request to have them disapproved. If it is a process to review the adequacy of the targets as they were approved by the executive officer and the potential to disapprove them, I think that's a different legal process that merits its own process.
Yes.
And shouldn't be determined by the expert panel versus if we're just looking at it from these are the different available metrics. I think that's appropriate.
Yeah, so I think that just goes to the discussion about, can we, as early as possible here, start fleshing out what the questions are that we would be looking to ask an expert panel so that we can get some clarity on that. And I agree, it's a different, this is not to say we are taking up a petition on that. But it is signaling that I think this issue of we do want to look at metrics for groundwater protection, and that's exactly what's at issue, I think, here today as well from agriculture. So figuring out how we get expert review on that is an input on that. Things are different than when we back when Eastside San Joaquin order was issued. I guess I'm wondering, could you, one of the challenging things that I continue to try to untangle in my brain is there's so many different efforts here, but just within the ILRP in the Eastside San Joaquin order, CV salts, I think, there's a lot of different layers and metrics that were contemplated just within that. And then now Central Coast has been trying to look at, has proposed their own. What we're seeing here, I think, is we need to look at what metrics make sense and get an expert panel input. The irrigated lands regulatory program in the Eastside San Joaquin, my memory is there was an initial effort that I think has been underway to develop kind of, I'm going to overly simplify, like best management practices for different crops and maybe some other characteristics, but it's basically management practices for farms and with different crops. And I know there was a coefficient discussion, but I thought that there was one metric, which was, okay, what are reasonable expectations, quantitative expectations for best management that can be developed that was going to be developed by, I think, coalitions or something. So if you can, well, can you help me remember what that is and if I'm making that up?
Okay, so I think I can. So, we started with in the East San Joaquin was the Management Practice Effectiveness Program, which is what you're referring to. Within that, then, as we then went through 2018, we got added the A over R acceptable range on a 3-year average, which was the recommendation from the expert panel. The Central Valley coalitions are right now working on that acceptable range process, and with the Central Valley Water Board, and hoping to have something here early next year. That metric, I think, in large part, how I look at that is because it's more of a nitrogen use efficiency, is it's kind of the BPTC, right? What's best practical treatment or control? And it's kind of more of a grower-based A over R metric to determine what can we do from an efficient agronomic farming perspective. And then I look at the A minus R, metric, if it's on a grower or a field basis, as kind of that localized potential impact to groundwater. But again, it's very general and doesn't have a lot of the complexity. And then you have the groundwater protection targets, which was trying to get at what do we need to do to protect ambient groundwater at the receiving water. And so the groundwater protection targets are about, okay, on this township basis, because the way we know water works and groundwater, what needs to be the, where do we need to be to no longer cause or contribute? So that's kind of how I, in my mind, break out the 3 different metrics.
Yeah, I guess what I'm sort of hoping we can tease out sooner rather than later, and again, I think this is exactly what is at issue here to some degree in terms of the what we need expert panel review on is looking at what is reasonable BPTC and as one thing, and what will it take, and then separately, because we know ag has to use, it needs nutrients. It's a leaky system unless it's hydroponic, and what would it take to not contribute to exceedances of water quality objectives? And I think those are, hopefully we get to a place where that can be the same thing, but I
don't think it will be, to be honest. I think it'll be separate.
I think so too. And so what I want to, what I think would be helpful is as we tease out what exactly we're asking the expert panel on, I think when we're talking about timelines, the timelines for expectations to meet essentially best management practices, at this point, I think the timeline expectations to meet best management practices, I don't know that there's a lot of justifications for an extended timeline to meet best management practices. What I do think there's a realistic or a justifiable need to do extend more extended timelines is to get to a point where ag cannot be contributing to exceedances of water quality objectives, which is more that groundwater protection target. And I do think both metrics need some input now. This is a good point for review on both metrics approaches. And I think just as we're looking at as we're providing guidance on timelines, certainly I think my understanding is what CV salts, and when we talk about as soon as practicable or up to 35 years in CV salts, that was really just for contributing or
to cause or contribute.
To prevent.
Right, to no longer cause or contribute to meet the receiving water levels.
Right, but that's not 35 years to institute best management practices. So I think those two things, right now, they're not super clear and precise. I think they're evolving, but I just want us, I guess I'm teasing that out because I think it's important for us as soon as possible with the expert panel and as this discussion evolves to be able to look at both, and also for the Central Coast as it's considering, discussions on alternative water supplies and timelines to sort of distinguish between those two things.
Yeah, and I would just say that I think that saying that people should be meeting best management practice now it's a little bit more, as I know you know. I mean, it's far more complicated than that, and there's a lot more that goes into it. And so I think that'll be part of the conversation as to what is that range? What do we mean? What is reasonable over a certain time period? Varies from crop to crop, right? It's not going to be the same for apples as it is for strawberries or wine grapes or whatever.
Right. Yeah. I'm not suggesting it's not going to be. I would agree. Yeah.
Thank you, board member, and thank you, Ms. Dunham. No, please, not yet, Ms. Dunham. We have board member Morgan with questions.
Yeah, it's probably more of a comment just for us to discuss later, just regarding the additional footnote. I'm just going to express some hesitation about it. I'm not, at this moment in time, I'm not comfortable with it being added. Understanding, the addition for metrics, I understand that there's supposed to be a public process around the questions to ask to the expert panel at a later date. I think that would be more appropriate to have that conversation at that time, and that way, all interested parties can come and participate at that time, and that we can, hear the questions, and we can, explore what the questions are going to be, and then go through it at that time versus having a footnote added into the Central Coast, our response to the Central Coast petitions. That's my thoughts at this moment. I can hear from, council, later, but that's just kind of while we're here, I just want to note that, hesitation on this footnote being added here.
Thank you for adding that, board member. I appreciate that and noted for sure. Thank you, Ms. Dunham. Next, I'd like to call up Uriel Mendoza, who will be followed by Heather Billing, and then Chris Diauto. Mr. Mendoza, you should be invited to unmute here momentarily.
Perfect. Hello.
Hello, good evening.
Hey, good evening. So yeah, I'll be quick. My name is Uriel Mendoza. I'm here as a community worker for California Rural Legal Assistance, CRLA. As a community worker with CRLA, I work with unincorporated rural communities in Monterey County, some of whom receive their water from contaminated well systems in achieving their municipal service needs. The Human Right to Water Law, or AB 685, statutorily affirms that every human being has the right to safe, clean, affordable, and accessible water adequate for human consumption, cooking, and sanitary purposes. AB 685 also mandates that the board consider the human right to water in establishing policies and regulations that are relevant to domestic water uses, which includes Ag 4.0. The board can achieve its duties to consider the human right to water by upholding the regional board's authority in setting fertilizer application and discharge limits. In fact, the regional board implemented its human rights to water resolution in Ag 4.0 by establishing fertilizer applications and discharge limits. Achieving the human right to water starts with setting better growers practices, fertilizer application limits, and riparian buffers to get us going in the right direction. And it starts with you taking these actions. So on behalf of the predominantly Latino communities with whom we work, we ask that you also follow AB 2108, which requires you to assess how removing discharge limits will affect Spanish-speaking and indigenous Latino communities already burdened by pollution, and whether there will be desperate impact to these vulnerable communities. The Water Board cannot fix racially injustice policy if it does not bother to analyze whether they are occurring. In addition, policies, procedures, and outreach materials that facilitate public input into this process must be provided in languages spoken by our communities. A little bit more and I'm done. In addition to my work with CRLA, I am also a community resident of North Monterey County, which some of my neighbors here, North Monterey County is considered Royal Oaks, and it also lies in Region 3. I live near agricultural fields, share water from a state small system, and wells in my neighborhood have tested for nitrate levels at sometimes double the amount of the state's maximum. So we're talking about 20, 21, 22 nitrate levels. This issue not only affects the community residents for which I work, but also affects me and my family. Before working for CRLA, I was not aware of the water crisis in Region 3. Therefore, thousands of individuals are also unknowingly exposed to harmful nitrates that pose long-term health risks. Therefore, the water crisis demands immediate and sustained actions. It requires leaders like yourselves making the easy decision to exercise the human right to water and to assess whether Latino communities are deprived of the right disproportionately to other communities. Access to clean, safe water is a fundamental human right, and securing it for Californians requires sustainable solutions. This includes fertilizer application and discharge limits, a timeline of compliance as short as possible, and riparian buffers, especially in the areas I represent, who are the most impacted by nitrates. And that's it. Thank you. Thank you for your time.
Thank you for yours, Mr. Mendoza. Appreciate the patience here. I know it's been a long afternoon, and for sticking with us and providing your input and comment and contributions to all this. It means a lot, and no rush at all. We're always here to take the time it takes. So thank you.
Thank you, guys.
Next, I'd like to call up Heather Billing, who'll be followed by Chris Diauto, and then Noel Creamers. And I believe our last commenter there then will be Ted Morton.
I'm not Heather Billing, but we are associates. Good evening, Chair Escobar, Co-Chair Diadamo, and members. Thank you for staying late to hear the remaining comments. We really appreciate it. My name is Christopher Diauto. I'm a soil scientist and agronomist working for Provo and Pritchard. And my coworker is Heather Billing, who's also an environmental specialist. And we both assist Central Coast growers in complying with ag order requirements while focusing on ways to improve the efficiency of nutrient and irrigation management. Our firm works with over 40,000 acres of irrigated lands with operators growing leafy greens, berries, vegetables, and wine grapes. The growers we work with thank the board for responding to the ag order petitions, remanding requirements that were incongruent with the East San Joaquin order, and considering the written comments which ourselves and others submitted. I'm here today to ask on one issue that the board employ more consistency with the East San Joaquin order. The intent of the proposed order that you have is to fulfill the precedential requirements, correct? Yet there is one area that hasn't been implemented fully, which is the area of data anonymity. So we are asking the board to rescind an exception which was written into the East San Joaquin order for the Central Coast and mandate that the region and the third-party group implement data anonymity for aggregated grower data through anonymous member IDs and field locations. The East San Joaquin order in section 2 states, sorry, next slide, completely forgetting that's up there. States that data will be aggregated by a third-party program and then reported anonymously to the regional boards. Next slide. However, the East San Joaquin order did highlight an exception for the Central Coast. At the time, this was predicated on the fact that there was no third-party program in the region before 2018, which could perform the duties outlined in the East San Joaquin order, which Mr. Gilman summarized at the beginning of the day, includes managing reports, performing outreach and education, follow-ups, and creating those AR metrics and outlier metrics. However, since mid-2021, there has been a third-party program approved and in place, which has been working with grower data and reporting it to the regional board. Therefore, we would like to submit that the grounds for that exception are no longer applicable. To this day, the Central Coast is still the only region in the state with a recent ag order that does not comply and makes publicly identifiable the data down to an operator and a field, contrary to the East San Joaquin's explicit directives. Why should the Central Coast now be the only region where growers' data is not protected and anonymous? Making this data identifiable down to that level does not directly improve the effectiveness of the data or make progress towards water quality improvements. The third-party programs that have the data can submit that anonymously to the regional board, and the regional board can request the exact data when needed. And then they can share the pertinent information with the public, as happens in other regions currently. So we ask that you allow Central Coast growers the same type of anonymity all other farmers in the state currently have. The cost of doing business, as you know, continues to rise rapidly, and this adds burden to Central Coast growers that other growers in the state do not face. This has, therefore, more negative impacts on the communities, and as you heard today, the farmers themselves being from minority groups of small scale, and on the economy itself. And we want to see Central Coast vegetable and berry growers remain a viable and vibrant part of the region. So in closing, we specifically ask that the board include a rescission of the exception for the Central Coast and mandate that the data anonymity policy is implemented.
Thank you, Mr. Dioto. I'll let the vice chair kick us off on this.
Well, I just can't help but jump in here. I absolutely agree with you, but I was there in 2018 and we had a robust discussion of this item at that time. And the decision was, let's let regional boards use their discretion in developing these programs, whether they should have coalitions or not. I happen to be a firm believer in them, and I think anonymity helps to have open conversations and very direct conversations with growers, like get your act together, that wouldn't otherwise take place. But the decision was made to let's let the regional boards be laboratories of these different systems, and at some point, as we're saying here, we may find that the coalition-based approach ultimately results in better water quality, but we need to figure out a process by which we could determine that. And I'd be all ears as to, maybe some assistance as to how the appropriate metrics and how we could figure that out at the appropriate time. Thank you for your comments.
Thank you.
Yeah, I appreciate the comments and participation. And we'll have to just provide some counter to, I know the vice chair and I are in different places on this. I recall the discussion in 2018, and it, very much for me, I can appreciate where anonymity can be sort of a bridge to especially these newer programs where we face such strong political resistance to trying to develop the relationship. I sometimes am concerned that the anonymity actually further distances and creates a kind of a permanent not relationship with the regional board that I think through time can actually better develop. And that's why I think it was important that we stayed neutral on this and allowed, especially because it was already direct reporting going on, instead of taking a step back, from my perspective, into anonymity wasn't the right thing. And at least at this point, we remain neutral and allowed here for us to be able to say, well, is there an impact? And if it's time to necessarily tease that out, I'd be open to it. It sounds, again, as we embark on the expert panel, perhaps this is a factor of, are we finding greater implementation because of the anonymity? Is it not? What are the back and forth worth a discussion? But I think there may be definitely differences of opinion on how it could work. Mr. Wiles, yeah, please join in.
So I'm looking at the section in the East San Joaquin order on anonymity, and it actually does read as though for those regions that have a third party, that the A and the R data is intended to be submitted anonymously. So we looked into that in this particular case. And the Central Coast waste discharge requirements, the general WDRs, do explain in the fact sheet that the third party or a third party is welcome to propose an anonymous approach. My understanding, and we have the representatives from both the third party and the regional board here. My understanding is that that was not part of the proposal, and that's how we ended up where we are. So we, I guess on the plus side, we'll be learning more about how the non-anonymous approach goes as a result of that. But I would certainly invite either of them to come up and tell me if I'm mistaken about how we got to where we are today, that there is not an anonymous approach.
So Mr. Weil, so I'm taking this approach here of we're implementing and requiring the precedential requirements from the East San Joaquin order. So you just had a fresh read of this section. Is there discretion there? Was there discretion for the regional board to take that approach?
I think there's an assumption that the third party, certainly the third party in the East San Joaquin was, and the members of the third party in the East San Joaquin were pushing very strongly for anonymity. And I think we need to recognize that the third party has an extra burden. There are, and again, the representative from the third party is here, so you might want to ground truth this, but that there's an extra burden that they would be taking on because they have to maintain all of the records in perpetuity in terms of who the growers are and what the parcels are at a very high level of specificity. We didn't anticipate the fact that the third party may not want to do that in the East San Joaquin order.
Well, for me, I would love to hear more if Preservation Inc. or the regional board wants to chime in a bit, only because I was not on the board in 2018 when this decision was made. I was not involved with the East San Joaquin order at all. So for me, when some of these newer issues to me come up, it will help to understand what we're deciding today.
Yeah, this is Matt Keeling here, Executive Officer, Central Coast Water Board. Phil's description of how it played out for our ag order is correct with respect to it being an option, but not being presented as part of the third party proposal.
Thank you. Look forward to further, I'm sure will be further discussion. And let's Vice Chair, do you have?
Mr. Bishop. I might have misheard, but I thought I heard that, considering anonymity might be a good thing to place before the expert panel. I would refrain from having policy level decisions put in forth to the expert panel and think about trying to keep that more towards expert opinions and not our policy calls. I think that's really more of a policy call. We can look at the quality of the data that we receive from the third party as from the anonymity versus the ones that we receive. And if there's a quality difference, I just worry about scope creep of the expert panel. And so just wanted to throw that out.
That's fair, Mr. Bishop. And I think just generally, this is an issue that will continue to come up in spaces to be able to explore some way to root our policy discussion other than just, preference. Thank you. Hearing nothing more, let's continue on with our commenters and would like to call up then Heather Billing. May need to pop it back on. Yeah, thank you.
Now it's on.
Hopefully it stays on too.
Can I have the next slide? Thank you. Good evening, Chair Escobar and board members. My name is Heather Billing, and as Chris stated, I'm an environmental specialist at Provost and Pritchard Consulting. My comments are focused on the September 8th State Water Quality Order revisions to the nitrogen application targets and limits and support for additional time to explore nitrogen removal credits. With respect to nitrogen application targets and limits, we appreciate the September 8th revision that rescinded the consequence of removal from the third-party program for not meeting a nitrogen application target or limit. We asked for this in our comment letter. However, we ask that the board continue to consider a remand of nitrogen application targets and limits on the Central Coast. We ask this to give state staff and the second ag expert panel the opportunity to weigh in on this topic. Our second related comment is with respect to the new direction in the September 8th order to accelerate irrigation and nutrient management plan monitoring, which will accelerate monitoring and reporting of nitrogen removed. This is currently being phased in gradually under Ag Order 4.0. The dates are 2025 and 2027 for groundwater phase 2 and groundwater phase 3 growers. Next slide. And with respect to the nitrogen removal pathways, we would like to emphasize our support for the continued exploration of the Central Coast nitrogen removal pathways, which are defined in Ag Order 4.0 as R-treat, R-scavenge, and R-other, as Eric Brethren and the other UC Ag experts so eloquently talked about earlier. We also believe that this experimentation needs to continue to develop new technology and tools for not just irrigated agriculture, but also cities and industry to reduce nitrogen impacts. This is the type of forward thinking that results in the innovation of practices and equipment, which may remove nitrogen from discharges at a field and watershed level. This also allows for the mobilizing of funding for programs that install, operate, and maintain equipment and infrastructure. This is really important. In closing, Chris and I appreciate that the September 8th order includes direction to the Central Coast Water Board to further our collective understanding of nitrogen removal pathways, build mutual trust, and use the data gathered for the second Ag expert panel to consider. Thank you for your time and consideration.
Thank you for yours as well. Appreciate the comments and contribution to all this discussion and work. Thank you. Quick amendment. I meant to make sure I referred to my list here. I want to call up Adam Lapitz because I think he wanted to make comment in reference to some of the discussion we had been having in exchange here, and then invite up Noel Creamers, and then again our last commenter will be Ted Morton. Mr. Lapitz.
Good evening, Chair Esquivel, members of the board. Just real quick, I'll be brief. We learned a lot at Region 5 in implementing the East San Joaquin order, and certainly enjoyed participating on the last expert panel. And I would just ask that in crafting the questions for this next expert panel, that we could be involved and engaged so that we can help and provide support. Thank you.
Thank you. Definitely appreciate it. I know the expertise and good work of the Central Valley Regional Water Quality Control Board and all this. So definitely, and thank you, Mr. Lapitz. Next, I'd like to call up Noel Creamers.
Good evening, Chair Esquivel and members of the board. Noelle Creamers with Wine Institute. And I'm here on behalf of our approximately 1,000 members who have wineries throughout the state and are subject, those that have vineyards, which is many of them, are subject to irrigated lands programs in numerous different regions. And so, Board Member Firestone, I want to speak to the point that you made earlier about the policy decisions that are made in these orders and the discussion that surrounds those, because we have members who are subject to Ag Order 4.0. We're appreciative, supportive of the order, appreciative of the change to include the specific provisions allowing the discount factors for organic and compost. But I really want to speak more to the larger issue of how this will impact our members when we move forward to the Ag Expert Panel, because there's a lot of questions. I mean, moving to the Ag Expert Panel, it's unclear what questions will be asked, and then what decisions, and then what implications that will have on agriculture throughout California. So the reason I'm here today is because wine grape growers apply very low rates of nitrogen typically, particularly those on the coast. And so most of the irrigated lands programs are written in a format that applies to all of the agriculture in a region. And most of California's regions are very diverse when it comes to agricultural production. And so there hasn't been a recognition of the different rates of nitrogen applications generally, particularly after the East San Joaquin order was adopted. So the North Coast Regional Board is currently in the process of adopting a vineyard order, and they are having to incorporate the nitrogen requirements from the East San Joaquin order into their order, despite the fact that there aren't groundwater quality concerns from nitrogen applications. So we are hopeful that when the Ag Expert Panel then it considers these issues, they take the opportunity to allow for much greater flexibility to recognize the different rates of nitrogen application. Another example that the scientists talked about, the quick soil testing for nitrogen. Most wine grape growers, they're not using soil tests because instead they are testing the tissue because they really want to know exactly how much nitrogen the individual vine needs versus what's in the soil. And so irrigated lands programs that require soil testing, that provides no benefit. Like I see generally the value of that, but that provides no benefit to the wine grape grower who is tissue testing. So now they're having to do two separate tests. So there's all of these very intricate situations that we hope will be allowed for consideration when the Ag Expert Panel is formed. We also want to request, and I look forward to the opportunity in the future to make this request in further discussions around the expert panel, but that there be someone on the panel with an expertise in vineyard production and particularly on the coast and the different regions, because there's a significant difference in how wine grapes are grown in the valley versus the coast. So I appreciate the opportunity, and I also recognize how late it is today. Just want to make sure that when we move forward, there is this recognition of the differences and there's an opportunity for those conversations moving forward. So thank you.
Thank you, Ms. Creamers. Appreciate it. Appreciate the patience. I know, yes, it's been a long afternoon and with a couple of unexpected interruptions. So thanks to you and everyone for their patience and for your comments. I believe our last commenter here will be Ted Morton. And if there's anyone in the room or otherwise on the platform as well that has not spoken, please do kind of raise a hand and just let me know.
Hi, good afternoon. Can you hear me?
We can. Good afternoon. Good evening.
Great. Hi, my name is Ted Morton, and I am the Executive Director of Santa Barbara Channel Keeper. We work to protect and restore the Santa Barbara and its watersheds and focus a lot of our work on water quality. We work from the Ventura River all the way. First off, I would like to indicate our support for the presentation and the comments made by Monterey Waterkeeper, Central Coast community members, CCKA, the Community Center, the California Sport Fishing Protection Alliance, and other CCKA petitioners. We are discouraged with several aspects of the state board's proposed order. We're deeply concerned that the state board is proposing to remove enforceable limits on nitrogen application and discharges that the Central Coast Board included in Ag Order 4.0. We view this as a significant rollback in implementing effective, accountable measures to minimize and control nitrogen pollution in groundwater and surface waters and protect public health, especially when these requirements are for a small percentage of outliers who haven't adopted BMPs effectively or changed practices that have been part of the educational work for over the past few decades. Haven't we passed the point when meaningful action is needed and required? We're concerned that the proposal allows for longer timeline compliance in exchange for an alternative water supply program. Communities should not be forced to trade greater access to safe, reliable, affordable water for additional years of groundwater contamination and health and quality of life impacts. We are concerned that the state board did not analyze the environmental health and social impacts of its proposed order on environmental justice communities. We believe that the state board should direct the central board to adopt quicker compliance timelines, including a 2041 end date. And finally, we believe that the state board should direct the addition of riparian buffers and wetland setbacks in the Ag Order. Earlier today, staff told us that the proposed order was focused on how Ag Order 4.0 corresponded with the ESJ order. However, in reviewing the proposed order, there's a section 6B on state composting, which is a general order, and it indicates that it was neither precedential as part of the ESJ order, nor part of either petition that was presented to the state board. So it seems like there is an opening for directing the regional board to include riparian buffers and wetland setbacks in a revised order. We'll urge you to make changes in the revised proposed order, and thank you for considering our comments today.
Thank you, Mr. Morton. I appreciate your patience and comments here and engagement around this all. Just thank you. Colleagues, we've heard a lot today. And again, I just want to reiterate my complete thanks for the participation of folks in the Central Coast and the communities that here were before us and made sure that their voices were part of, I know what is always a difficult job at this dais in the balancing of the work that we're committed to do. I wanted to make note because the racial equity resolution of this board, the racial equity action plan, the human right to water, the safe and affordable fund, and all the work that this board does to really bridge the inequities we find in our communities is incredibly serious to us and to me, I know. I hate to always bring up my background, but growing up in the Eastern Coachella Valley and similarly here, if not for the opportunities within agriculture, my grandparents and my family, I wouldn't be here. So the balance and the need to ensure that agriculture continues to thrive in the state, but importantly, that the inequities that certainly I grew up experiencing and knowing are addressed are sometimes here at odds. The reality is here with this order, and I said this here earlier, is that there are a lot of policy work here and ultimately positions that I agree with. But the question is within the context of this order and here ensuring that the regional board's order is consistent with the precedent set by this board and the consistent then legal pursuit that we're all trying to push on when it comes to, again, regulating nitrates, but importantly, regulating agriculture in a way here that bridges what are inequities and a lot of work that needs to be done. It's not, I know that's not fulfilling, certainly for communities that are continuing to be exposed by contaminants, and here see this as the prime opportunity for the board to step up and back up the policy shift that the region went into. It's why, for me, the expert panel will be important, because that is the opportunity to then inform that real discussion. The reality is that, as we know, the decisions here in these programs have impacts statewide. And what we don't have the benefit of here is really a discussion here that can inform the board as to where to go on a statewide basis. And so we're left a little unfulfillingly addressing Ag Order 4.0, the Ag Order here at the Central Coast in the context of our existing adoption of the Eastern San Joaquin Order, which we don't have, again, here an adopted basis to go beyond. So all that to say, I'm comfortable with where the order is here, but I would like to see if we can have some additional language. I know there is some discomfort generally with providing too much direction here to the expert panel, but it would be comforting to me to try to figure out how best we can potentially bridge that with language, if we can, here amongst us at the dais. The other issue that I'll just speak to at the dais here is around timelines. The reality is that 35 years was in 2018 when we established that time frame for the Eastern San Joaquin. It was our desire to set a maximum time, not set the minimum for actual action. And I think that at this point, I'd like to try to understand if there is additional information that gives us some better comfort on what are the achievable timelines
And I know it's different for each of the regional boards, but I think that I'm just, I guess, signaling here from the dais that I'm open to some discussion on that, not in this moment and on this order, but want to explore that and really understand so that folks can have faith that we are being as aggressive as you're appropriate on what are not difficult issues, and that, again, candidly, no other state is making as much progress. And so proud of the record, also acknowledge that it doesn't go far enough here at the dais on what we're doing, and the criticism from folks around, to Mr. Bothwell's, I think, statement, feeling that there's two boards here, or that we're talking out of two sides of where our priorities are. All that hopefully was somewhat useful, but I look to my vice chair and my other colleagues here at the dais around how we feel and what might we decide to here adjust even further amongst what we've heard. So,
right.
Vice Chair.
Well, thank you for that. And I think that I couldn't agree more. I'm comfortable with this order, but it feels a little lacking because of the importance of this issue and because of all the progress that's been made. And we're sort of itching to have more conversation. And so I would just propose that when staff comes back for the conversation regarding an expert panel, that we put it in proper context. Maybe that's an opportunity to have a more robust discussion, an information item where we can look at, I mean, it's, even as the ag member, I get confused frequently on the different irrigated lands programs, CV salts, and then even in this footnote on groundwater protection targets, I had to go back and kind of sort through and take a look at the East San Joaquin order. So I think to best put it in context, we should include an information item where, maybe we just have an entire day where we go through what the different regional boards are doing, get an update on the various programs that the regional boards are doing. I think that would be an appropriate time to look at the timeframes, what we have required versus where we've left something open, a good, a review. And then beyond that, I would just say that I think that it's best to be broad on expert panel, because I agree with board member Morgan that it's best to leave that up to a public process, have staff make some recommendations on, general areas with maybe some specificity where it's more of an immediate need or based on where we've provided direction, some direction. And then let's hear from stakeholders. Let's keep it an open process. But to the extent that if my other colleagues feel differently with respect to that footnote, I think that there's a way to maybe be less prescriptive in there and more general. And then the last thing that I would add is that I think we need to tell the story a little bit better. And Mr. Wiles, I pulled you aside and asked if you could come up with some language, putting it in better context with regard to why we're doing this. We're doing this for communities. We're doing this for drinking water. So thank you, Mr. Bothwell. I don't think we have two different boards. It's the same board. We are absolutely committed to racial equity in drinking water. We spend so much time. It's, one of our top priorities, but we need to better include that in the narrative here.
Board Member Morgan.
Thank you. I agree with the comments that have been made by the chair and vice chair. Also want to just thank everyone for providing comment today, and to the many community members that took their time to travel here to share their concerns. I know that it was a long way to travel, and it took a full day. So nitrate is a concern, and in drinking water, high levels of nitrate, it's not like some contaminants where you can completely tell when it's coming out of your faucet that it is contaminated. It's drinking water is still clear. You don't know, as one community member said, you don't know unless you go, to go get the testing. And so, that is a concern of mine, and definitely, want to make sure that we continue to move forward. We move forward, appropriately and as quickly as we can. I agree with the vice chair with, making sure that we write our orders to make sure that we are not only representing the industry that we are regulating, but we're also representing the environment and the community that we're protecting, so that we're being holistic in that description and making sure that we are correctly representing what the order is to do. And also, with moving quickly and giving that certainty, it's regulatory certainty for the regulated community, because the regulated community will know what's expected. And, as far as I believe it was brought up for the expert panel of there's, the uncertainty of what's going to come out of that and still living in somewhat of a limbo. So moving forward and making sure that we have good timelines set and we give that certainty to the regulated community. They know what to do, they know how to move forward, how to operate a business. But then also that certainty comes for the public that we serve, that they know that, hey, here's the timeline that is set. This is the steps that we're taking to move forward to protect the environment, to protect public health. I believe, it's being clear and really laying out those timelines is really needed. And so having a info item and really starting that process so where we can start going down the road of the expert panel, bringing everyone together to really provide that time frame is important to me. And so, with that, I'm comfortable with the order along with the additions that the vice chair mentioned. And so that, and again, thank you.
Thank you for that, Board Member Morgan, and agree. Board Member Firestone.
Thanks. I think that the outcome of this order could kind of go either way in terms of how seriously we are taking community drinking water protection. This is trying to be a very neutral order, essentially saying we aren't going to tell you exactly what to do, but you do have to, these parts of the East Side San Joaquin order are precedential. And you're right that it's time for us to relook at these things where we were at a different place in terms of our data and knowledge and understanding when we adopted the East Side San Joaquin. But I do think we need to recognize that we are, through this order, in effect, taking away the enforcement that the Central Coast Board built into their order, and we don't have something else to put in its place. A lot of what we're doing is basically putting it back on the regional board to run a process, and putting it on us to do an expert panel process. And so I think depending on how we back this up will determine whether we're really doing justice to our intent here. So in other words, I think, we're committing, and I don't know that what's actually in the order is strong enough. So I think, Chair Escobar, maybe this is what you were flagging. But regardless, I think we as a board need to commit to, as quickly as possible, not just having staff review data, but also pulling together what are the questions for the expert panel, what are the expertise needed, really narrowing down what is it, and that timeline, so that we are not just punting this issue for a long drawn out process that we've seen in the past. And it can easily become that, easily.
And so I think one is figuring out how we're taking that urgent need really seriously and reflecting that on our end. The other thing is we flagged this issue of an alternative water supplies program. I think, that is something that needs to be discussed. We put that in the context of, the Central Coast Board convening stakeholders and us being involved. I do think as the state board, we need to be extremely involved and helpful. We're putting a lot on the Central Coast Board to readopt an order they've spent a huge amount of time adopting, and they've got a lot to consider and do more generally. And, that their programs aren't alternative water supply programs, which is why I think our order and the language we have in this order reflects this, but I do want to say again, if we really are, I know we are really committed to the intent of taking drinking water protection really seriously. We need to, as a state board, really put some significant investment into supporting development of a program over there. And so those are both commitments and things that I think we have control over at the state board. And I don't want to just throw that onto the regional board. So I guess just in terms of thinking about how things actually play out, those are two things that are extremely important to me to feel comfortable adopting an order like this, is for us to have commitment to do that at the state board. Two things I just want to pull out here. I want to be really clear as we move forward with discussions on the expert panel, and also as the Central Coast, just since we have you here as you move forward on your, reconsideration. I think it's really important when we're looking at timelines and metrics for us to be very clear about different expectations within these programs for BPTC, essentially applying best management practices, and justifiably more time needed to meet full groundwater protection. I think when I'm reiterating the discussion with Tess that we had, but when we had approved CV salt, it was because it was time to not contribute to exceedances of water quality objectives. It shouldn't take 35 years to institute best management practices. And I think there's no question that, as you all are considering how you do that, we haven't set a timeline. We've said you guys need to set a timeline. But I do think we should we should consider those two things. And I wanted to highlight the difference there. The other issue also in the interim, because even if we're moving quickly on our end on the expert panel and alternative drinking water supply program, we need to be able to see folks that are over applying, or not just over applying, but are contributing significant nitrate into the groundwater, that is being reduced, and that the regional board is able to take action to ensure that groundwater is protected, especially with those, what I think we often call outliers. If there are gross polluters, the Central Coast Board, or any regional board needs to be able to have the tools to take action. I really appreciate us including the ability to recognize that when we don't have nitrogen removed, we need nitrogen removed. We all know that that's part of this, but in the interim, if you've done a lot of work, we have a lot of data on nitrogen applied, that can be a first step for education and also for getting more information to see, is there, some amazing remove data that means that this isn't a gross over application, and asking for that data. I appreciate just flagging in this that, the Central Coast does have investigatory order authority to be able to get information. When you've got outliers where there's evidence that, that indicates there may be gross pollution, you should be getting information on, getting more information from them, and that could include nitrogen removed. So I just want to encourage the Central Coast to be using all the tools available and flagging that it was important to me in this order that we ensure that the Central Coast has all the tools that they can, despite not being able to have the limits that were in this otherwise. Let's see, I think otherwise I would agree with the comments. I think I'd really like to see us be able to have more of a process around questions and scope for expert panel. I very much think that the Central Valley's groundwater protection targets fit in this same bucket of what are the right metrics here with ag to protect groundwater. And so I just really look forward to us, having that really already starting to narrow down and engage with the public on what those questions are and the expertise needed within the next year. That's it.
Thank you, board member. I echo the desire to have urgency around the work and not let this drag on. Again, my response now to where we are on this order is only because I see the real work needing to be prioritized and to get to that discussion here. And so completely echo your desire for urgency. Board member McGuire.
Yes, I'll keep this short because I concur with the vast majority of the comments, including the sense of urgency on the expert panel. And obviously, I think we heard that loud and clear, that that's an important next step in this. I'll look forward to language also if staff have some language proposal revisions on the footnote or otherwise. But I also just wanted to share, so I'm trying to add here to the comments versus repeating them. So just thank you for all the engagement today. Thank you for all the stakeholders who are here, particularly from the communities that are impacted by this order. I know weren't able to stick around, but thank you for being here and sharing your comments. It's meaningful to me. It's helpful to hear different perspectives. And I just also wanted to particularly call out the Central Coast Regional Board and thank you for your work, because it's, your stewardship here, frankly, in trying to lead the charge. And I know there's a difference of opinion in terms of the presidential order, what it requires, and the direction that you took. But nonetheless, here we are having this conversation about and addressing the need to advance protection from nitrate impacts to groundwater in a way that hopefully will provide some statewide clarity. And so I appreciate the work that you've done with Ag Order 4.0, and I know we'll continue to do. And particularly looking at Executive Officer Matt Keeling, I know this is, you're kind of on the tail end here, and we may not be able to, may not have the opportunity to work with you as Executive Officer. I know you're stepping down soon, so thank you for your contributions to this work. It's not gone unnoticed. And then the other area I wanted to just emphasize, I guess, is that we heard from many stakeholders today about the need to do and complete and consider impacts to environmental justice communities, disadvantaged communities, BIPOC communities in our work. And this is so complicated because, as we've talked about many times, this order really affects many regional boards. It's of statewide significance. So I know today I'm comfortable with the order today. I feel like we do need to move forward because of the timelines embedded in Ag Order 4.0. But as we move forward through future actions, I think it would be worthwhile for us to consider having a more comprehensive assessment of impacts to environmental justice communities through our work, through these types of orders, even if it's not explicit in AB 2108. I think it's something we should be doing. It would be consistent with the racial equity resolution. And it's something that I would like to see, frankly, as we progress, because I think that one takeaway from today's discussion is that I didn't have a solid understanding of that. And so that description, that discussion would be helpful in my mind as we have future actions, whatever they may be. And I'll leave it at that. Thank you.
Thank you, board member. I think it leaves us generally on any potential adjustments to the language around the expert panel. And I know, Mr. Bishop, you cautioned us here about not boxing ourselves in, ultimately on somehow creating a laundry list, but how best might we capture some of the urgency that we definitely hear at the dais and, assure folks that won't be a 5-year process.
Well, I was disappointed. I was hoping to, stretch this out a long time, but no, we understand the urgency. I did want to reflect on just a couple things I heard today as we move forward, because it appeared to me that there was an impression that there was a trade-off between giving people extra time to do alternate compliance. As staff, that's not the way we see it. What we see is that there is an inherent issue with meeting water quality, receiving water limits for agriculture, and that it's going to take time. And during that time, we should be providing alternate water supply. I think that's different than this idea that we're somehow giving them extra time because I also think that it's important for you to know that staff takes as soon as possible in these orders very seriously. It's not a phrase and then you have 35 years or 25 years. We take that as the you need to be doing everything that you can be doing as you move forward, and in no instances can it go beyond the time frame. So I don't want to opine any farther, but I do want to turn it over to Phil. We have a couple of suggestions to add to the order at this time. And before I end, I will say that I will be working with the staff at the state board and at the regions to look at that data expeditiously to develop a starting point for the questions. I think we need a starting point, but that doesn't mean that's the ending point, and we will be taking the input from the all of the stakeholders on what's important to them for us to move the underlying question of how do we move agricultural discharges forward? How do we move it forward so we're reducing the impact on our communities?
Thank you for that. Mr. Wiles.
So we do have a couple of areas that we're proposing revisions for the board's consideration, and if the clerk can put them up. There's 3 different areas. We were not proposing, just to the last point, we were not proposing to make any changes to the order with respect to the urgency for the expert panel. I think we hear loud and clear that that is the board's expectation. And so we, John is quite capable of moving staff quickly. So I think we're not proposing any language changes. But what we are proposing here are 3 changes. The first relates to what we heard from the board about um, being more explicit about our concerns with respect to the communities that are affected by nitrate contamination. And so that's the first paragraph that would be added to the bottom of page 2. And I'll give you a chance to read it. I will walk through all 3 and then come back and read them for the record for the benefit of our Spanish translators and the people who are listening in Spanish. The second one is to address the issue about whether it's premature right now to state that the expert panel would consider reviewing the groundwater protection targets. And so a slight change there, just to flag that it's something that we will be considering doing in the future. So that, again, part of the public process to figure out the full contents of what gets referred to the expert panel. And then the third, which you can't see yet, but I'll just preview, relates to the issues that were raised by water quality preservation with respect to the growers who have highly diversified crops and may have language barriers and concerns with both reporting R and A. So I want to give the board members a chance to review these. These are just our proposals, and then I can walk through them if you'd like. And you may have some thoughts on the wording yourselves.
Just as we go through, I mean, honestly, where I'm at right now is I'd rather just not include the first part. The first edition. I agree with the intent, and I know Vice Chair Diadama has been. Obviously, we very much agree that we need to tell the story better. It's just but I don't know that we are going to do that in this meeting, and that we should be wordsmithing that today in this order. So I'd just rather not, honestly, is where I'm at. I think, if I'll just say fundamentally nitrate contamination of drinking water by ag is one of the epitomes of an EJ issue in the state, and actually one of the first EJ papers, sort of peer-reviewed papers, was that race was actually the biggest determinant in terms of nitrogen or nitrate contamination of wells back, this was Carolina Balez's work many, many years ago. So there's a lot, to do justice to in terms of capturing kind of the EJ concerns and story here. And I just wouldn't want to, I don't think adding a few lines will do justice to that. So I'd rather just acknowledge that I think we need to do better, as we've all said, next time. I think, that'd be my personal preference on this.
Yeah, I appreciated the attempt as well. And in reading it, I started thinking of things that I would want to be adjusting here. And I think that, to the board member's point, it might be best to just not include, a significant amount of text there that we may have additional desire to spend quite a while trying to get just right, and without too much benefit ultimately to our discussion. So, any other board members with any feeling on any of?
Well,
do you want to?
I was going to say on the other
parts?
two, I'm good with. I like the suggestion on the footnote and I like both of them.
Well, Board Member McGuire.
I concur. I agree. I mean, I think I really appreciate your comments on the first paragraph. And I think, to my hope, that in the future we can be more comprehensive with that thinking and the analysis that goes into this work. I think that's really what's going to be most impactful at this point. But I appreciate you proposing some language here.
Looking to see if there's any colleagues with additional thoughts on the revisions that we have before us, the 3 revisions. And Mr. Wiles, I don't know if there's anything you wanted to add.
Well, I do want to just remind the board that at the beginning of the meeting, we did have one other minor revision with respect to the alternative drinking water. So if that's with the board's pleasure, I would recommend that you include that as well.
Yes, thank you. I'm supportive, but look to my other colleagues.
I'll move adoption of the order with the revisions read into the record earlier today by Mr. Wiles. And the 3 changes, I'm going to just, because of what was included in this earlier, I'm going to just reference them by title: revision to footnote 85, revision to page 10, and addition to the end of footnote 33.
And I wonder, I think it might be appropriate for me or anybody to read them so that the Spanish-speaking observers can actually hear the translation.
That sounds great, Mr. Wiles, if you don't mind reading them into the record here.
Not at all. So I did read the alternative drinking water language earlier in the meeting. So now we're talking about the revision to footnote 85 would result in the first line reading, "We also intend to consider granting a request submitted by several environmental justice organizations." And again, that's a change to footnote 85 on page 21. The next revision is to page 10. And it's just striking the words "not relevant here" from the sentence that starts, "We made it clear in order 2018-002. And then the final revision would be to add the following text to the end of existing footnote 33 on page 10. And that text would read as follows: "Based on comments we received from the third party, we expect that the Central Coast Water Board will, on remand, consider using this discretion as appropriate. We also encourage the Central Coast Water Board to work closely with the third party to develop targeted education in appropriate languages for reporting A prior to revising the general WDRs on remand." Period.
Thank you, Mr. Wiles. Do we have a second?
I'll second.
Any further comment? Ms. Tyler, can you please call a roll call vote?
Vice Chair Diadamo,
Aye.
Board Member McGuire,
Aye.
Board Member Firestone. Aye. Board Member Morgan, Chair Esquivel.
Aye.
Thank you.
Thank you as well. The item is adopted. And again, I want to echo Board Member McGuire's thanks to the regional board and everyone here and their contributions to the discussion, and look forward to what will be a lot more discussion and hopefully hear them soon. Thank you, everyone. That concludes item number 13, and it also concludes our 2-day board meeting. It brings us to the end of our agenda here. I just want to thank everyone for their work over the last 2 days. Our next board meeting will take place on October 3rd and 4th. And until that time, we are adjourned. Thanks, everyone. Appreciate today's discussion.